As we normally do every day, I've welcomed the public protector, the evidence leaders, all members, members of the media, members of the public, and our support staff. And I indicated at the beginning that we started 8 minutes past 10 as I opened the meeting after registering at 10 that we're here ready, but we're short of few members for our quorum, but we're also missing the witness who was not in yet. And I am aware that there's been a slight problem which is beyond her control that maybe I'll just allow her to explain that. Just switch on your mic and welcome back, Ms. Mvuyana.
Good morning, Chair. Good morning to the quorum.
Maybe
And
today
evidence
you're
leaders.
going to use the other mic.
Yeah, I think so.
Today you'll switch on that other mic because today you will be speaking to the person on your right. You're not speaking to a person on your left today. Yesterday it was person from the right, and you know people from the right. So so today you're speaking to somebody on your left. So it's certainly going to be a good day. So I don't want you to have a sore neck going this and that.
Noted.
Thank you. Just explain what happened to you. Why did they delay you?
We went to the incorrect gate with my driver. We then had to go to the visitor center for credentials to enter Parliament. So there was a very long queue there, and I had to wait like everyone else. But I'm sorted now, and apologies for the late coming.
Thank you. Don't switch it off. Keep it on. We appreciate that. That will be the visitor center. It applies to all of us. When I forget my access card, I start there. We just don't know how the fire started. You know, when we have that kind of. But it's another order. With that, colleagues, I am now going to invite Advocate Bauer to interact with the witness.
Good morning.
Good morning, Advocate Bauer.
How are you today?
I'm well, and how are you?
I'm good, thank you.
Thank you.
Can we accept as a starting point that underlying the work and the reports of the public protector, amongst all kinds of other principles, but I'm just going to hone in on a few of them, must be openness, transparency, independence, and impartiality.
That's true.
And that, as a starting point, the SARS unit report has now been reviewed and set aside. Constitutional Court has refused leave to appeal. So the report is no more.
It's set aside, that's correct.
Right. We also know that shall we try and differentiate between the two reports? Shall we call the one the IGI report and the other one the SARS unit report? The IGI report being the classified report.
Yes.
So we also know that that report has been reviewed and set aside.
If you say so,
Okay, you don't know that.
I'm not sure about that information. I can confirm.
Right. We know that the Section 7(9) and the reports are signed by the public protector, correct?
Yes, that's correct.
So it's her reports. It's the public protector's reports.
Yes.
And there's been no accusation made against you or against the chief investigator of collusion or corruption or taking any sort of bribes, as far as I'm aware, in any of the court judgments that have come down.
No.
And there's also no finding of you or the chief investigator having acted with any form of vendetta.
Yes, in the judgment, that's correct.
And so what made you testify in respect of that?
What was I?
What was it that informed your testimony to raise the fact that there's the issue of a vendetta or collusion or something? Why did you feel it necessary to raise it to the committee?
Besides the fact that I was asked a question, it's been alluded to by a couple of newspaper articles and some of the witnesses that came here. That's why I felt that it must be clear that from my own personal work ethic, there was no malfeasance on my side and bias or, yeah.
Can you tell me which witnesses' evidence you regard as having said that?
Not having said, I said alluded,
Alluded to that.
yes.
Which of the witnesses?
Mr. van Logerenberg, Mr. Pillay, a couple of our own staff members. If I can just mention a few that I know of. Newspaper articles, I can't recall all of them, but I don't have the specifics for that.
Can you in your own words tell me what you understood them to be alluding to?
What you just alleged, so being either biased in conducting the investigation or being dishonest, ignoring evidence, etc.
As in attributing that to the investigators or as in attributing that to the public protector?
If the public protector is said to have ignored evidence, that means she doesn't deal with the evidence. I deal with the evidence. So that's where the allusion comes from.
But do you agree as a matter of first principles, whatever goes into the report, whatever gets taken out of any drafts is a decision which lies with the public protector?
That's true.
Now, there is a period from when the complaint comes in to when the report is handed down in July. October, you get the first complaint. July the 5th, I think, the report is finalized. What do you regard as the investigative period?
For part one of this report, then starts from October to currently, basically, because this is part one. So part two has not been finalized.
No, so we're talking about the investigation which informs the report that comes out in July.
Okay, which is,
Are we saying that you investigate up to the point, if new evidence came to your attention on the 4th of July, would you, and it would change a conclusion that was in the report, would you have regard to it and change what needs to be changed in the report?
that's a difficult question. If it came on the 4th of July and the final report is now with the public protector and is being quality assured, it would have to be a discussion and a decision with the team that is being made. I wouldn't take that decision because these things are planned. So if there's a media briefing tomorrow and the report is being finalized, a discussion will be had and we'll decide whether or not to incorporate such evidence, if it can be incorporated though. If there is new evidence submitted on the 4th, we'll just have to work all night.
You're not suggesting if there's evidence which implicates any of the people who's the subject matter of the report egregiously or exonerates any people implicated in the report on the basis of this report being handed down tomorrow, that you won't have regard to it, or the public protector won't have regard to it?
No, we'll have to regard to it.
Now, if we look at your investigative diary, and we go into 190.57319, as I understood and from Mr. Matapogo's evidence, you meant to keep track of what you're doing in this investigation in your investigative diary.
Yes,
Is that correct?
that's the intention of a diary.
And if we look at your investigative diary, you get that? 7319. And your investigative plan has not been provided to us.
Is it?
No,
Oh, okay.
despite having asked it previously and asked it again, it's not in the file. It doesn't appear to have been included in the documentation provided to us. Is it the reason why it's not there, or do you still have it?
I would not know what the reason is because I'm no longer in possession of the file.
Right. So this investigative diary commences on the 12th of November 2018, when it's referred to Ms. Moghaladi for allocation. She was at that point the executive manager GGI, correct?
Yes, correct.
And then the file is allocated to you on the 15th, and you acknowledge receipt of it. Right. Maybe you can just take us through your investigative diary. Seppo, just go down. You asked to attend to this urgently. You note that the file is received. What do you do next?
Letter to President sent. So in between the 15th and the 19th, I'm drafting letters. On the 20th, letter to the complainant is sent and the meeting is held.
To be held.
The acknowledgement would have been before the 20th. So this was just to update. Then the meeting was held, I believe on the 20th. I'm not sure when the meeting was held, I think, but sometime in November.
Is this the meeting with Mr. Shivambu?
Yes. Okay, that is clear. Okay, must I read it out?
Yeah, just go quick if we just go through
Okay,
it.
discussed way forward the team. That's Mr. Matabuche from the PP, as per directed from the PP, namely letter to SARS and Minister Kotan.
Right.
Okay, that's letters inviting consent. Meeting confirmed for the 4th. So this is also happens before the 20th, I believe. Oh, this is 30th. Oh, yeah, it was held on the 4th of December, this meeting. This is incorrect, mistake. Letter sent to SARS, meeting held with complainant to log issues, letter sent to Kortan, listing allegations, and then we go to June 2019. This is June. Okay, request for
I
extension.
think that's January.
Is it Jan? Oh, yeah, sorry. Yeah, extension granted, and then response received from Mr. Kortan, response received from SARS, acknowledgement sent, perusal of documents began drafting section 7.9, discussed with CI in between that time period, and then report issued. File certified closed on the 5th of July, 2019.
So would you accept that your investigative diary doesn't actually disclose any investigation?
We won't, which part of the investigation does it not disclose?
Anything? Tell me which part of this is an investigation.
The start of the investigation, meeting with the complainant, receiving documents from SARS is part of an investigation process. Analyzing those documents is part of the investigation process. Drafting the section 7.9 is part of the investigation process. Discussions with the team is part of the investigation process. Drafting the report is part of the investigation process. Yeah.
Okay.
That's an
So,
investigation.
so what you don't detail in here is any meetings you have with any other witnesses.
Yes, what is not detailed there.
And should it be detailed there?
Ideally, yes, it should.
And so why is it not there?
It was an oversight. Unfortunately, a lot was happening, like I'm saying. Sometimes you don't see to the file on a daily basis. So you will fill in the diary as and when you touch the file, and then remember to fill in such details. So there was a lot of documents that were submitted here. And most of the time was spent on analyzing that evidence. So yeah, it might have been it is an oversight on our part, my part, especially because I was the owner of the file. Yeah, but I do agree that there are things missing.
And we talked, or you talk about an investigative team. Who is that team?
Me, Rodney, and the PP. That's a team.
Now, you had a consultation with Advocate Mayose and myself. I think it was end of June, end of July, somewhere around there.
Yes.
And you indicated to us that the investigation team or you yourself had not had access to the IGI report and you didn't place any reliance on it.
I myself did not see the IGI reports, yes.
And you placed no reliance on it in drafting the report.
No, I couldn't have, I had not seen it.
So if there are inserts into the report that emanate from the IGI report as a consequence of it, then it doesn't come from you.
No, it does not. And I can't confirm who it came from.
Were you aware at the time that Mr. Matabogo had access to the report?
Yes, I was aware.
And what security clearance did you have at the time?
Just confidentiality. Myself or Mr. Matabogo?
You.
Confidentiality.
Okay. Now, on what basis did you conclude that you could only access the classified report if you had top secret security clearance?
How did I conclude?
Hmm.
When did I conclude that?
You said that you didn't get the classified report in your direct evidence because you didn't have top secret security clearance.
Yes, that's what I was told. So when the issue of the report being dropped off, etc., came to light, I then was told that I could not have access to it because I don't have security clearance.
And who told you that?
It was Mr. Matabogo as well as the PP, and Ms. Bukhaladi also confirmed.
And did you check the law on this?
No.
Now, as I understood your direct evidence, you were saying that the PP does not get involved in investigations. Did I understand that correct?
I think from my statement, I said certain portions. So that would be analysis of and receiving of documents and certain parts of the investigation. But at some point, the Section 7.9s, the letters are signed by her, the Section 7.9s are signed by her. They are discussed and she makes inputs. So the process, she would have to be a bit involved.
Yeah.
Yes.
Mr. Matabogo's evidence was that she's involved in the investigation of matters from the start to the end with continuous insightful inputs to direct the course thereof, often with well-researched case law to assist the teams with legally sound conclusions, which also being open to persuasion to a different viewpoint or conclusion. Do you disagree with that?
No, I don't. That's what I was saying, that inputs are made, discussions are had. So she wouldn't be totally excluded from the investigation process. Updates are given to her as well.
So when did you find out about this anonymous person who dropped the report at the PP's office?
I believe it was in January 2019, if not Feb 2019.
Was it before or after the meeting with the people from the IGI?
When was the first meeting?
The
Because
31st of January.
I believe it was before.
So when you got the Newsweek article, you knew about the IGI report already.
I knew that the public protector had the IGI report.
Yes.
Yes, I knew of the existence of the IGI report. The complainant said there was a report as well. So it wasn't just from it being dropped at the office.
Sorry, I'm asking the question badly. At the time when the Newsweek article came to your attention, when Mr. Shavambu sends it to you on the 24th of January, let me ask the precursor question. Was that the first time the Newsweek article was brought to your attention?
No. The Newsweek article was issued, I think, in Feb. So Mr. Shivambu says that there is a report. This is in December when we meet him. He says that there is a report that supports his allegations. That is from the OIGI, etc. Yeah, then we still write to SARS and we continue with the investigation, whilst then the OIGI story comes as well now from Newsweek.
Okay, but Mr. Shivambu sends you an email with the Newsweek article attached to it on the 24th of January. Do you recall that?
No, I know that he sent it to Pona. I don't know if
No, maybe. Shepherd, can we put a bundle F 189.15? We're distinguishing between the Newsweek article and the classified IGI report. So I'm talking about the Newsweek
Okay.
article.
Yes, that's my email address. Yes, I did receive.
You did receive that.
Yes, I did receive
And in
it
fact,
and
he-
I printed it.
Yeah, and he tells you that the report of the IGI on intelligence is out already in the email.
Of the IG is out already.
Yeah.
Yes, he says that.
He sends that. Okay. So when you get this, are you aware that the public protector is in possession of the report?
No.
If we go to paragraph 4.4, Shepherd, we're going to the SARS report. That would be bundle E 7/4/216. Now, where in the SARS unit report does it say that the public protector has the classified IGI report?
I don't know.
If you look at paragraph 4.4, which is the list of the documentation. Sorry, I had it and I've lost it just. Yeah. Go up. This is the key sources of information that's listed in the document. And let me save time, Ms. Mvuyana. What is not there is any reference to the classified IGI report, any reference to the Nugent reports, both, and any reference to the affidavits from Mr. Lebelo, nor is there reference to the emails that had been received, which I'm going to take you to in a while, from other parties that's there, nor is there any reference to the anonymous complaint that had come in, or the communications with the anonymous complaint. If I'm wrong, Advocate Mpofu will tell me, but I'm going to let him scroll down to show you. And so I'm asking you, why was there no reference in particular to those documents in this report, and in particular, the classified IGI report?
I don't think that, I agree with you that they're not there. But there's also a lot of other documents that are not there. I believe that were submitted by SARS as well, memos, etc. So I won't be able to answer that question. They're just not there. They were not included, but they're in the Rule 53.
So the classified IGI report, the Nugent report, and the Lebelo affidavit is not in the Rule 53.
I think the IGI report, I wouldn't know because I never saw it. I wouldn't know how it looked like in my compilation. The Nugent still is a public document. So we believe that anyone could have accessed it. What else was not there?
The affidavit that you got from Mr. Luther Lebelo.
Oh, I don't know about the affidavit. I don't know if.
Chair. Okay, just a pause. Advocate Mpofu.
Yes, I just wanted to, if maybe Advocate Bauer can identify that affidavit for us. Because the only affidavit I'm aware of from Mr. Lebelo was given to the Nugent Commission.
If you go to one.
You're not on your mic.
Where we requested certain documentation and information from the Office of the Public Protector,
Yes,
and that information was compiled. Were you involved in the compilation thereof?
yes, I was.
Did you do it?
Not alone. I was assisting Mr. Matabuche. The letter was sent from the CEO's office to Mr. Matabuche. I assisted.
You assisted, Mr.
Yes,
And the contents of this letter, did you both agree to the contents of it, to the response?
well, can I please see the letter?
It's done in a table. So let's just see.
No, we didn't do it in the table. The responses were not done in the table.
The responses were done. Let's go to 189.52. Did you provide a copy of the documentation and the file to the CEO's office?
Yes, we did. Both files.
Both files.
Hmm.
It's 5071. Right. Was that what you had compiled?
Yes.
Just a pause, Advocate Bauer and Ms. Mvuyana. Honorable Gondwe.
Chair, through you, just a request to Ms. Mvuyana. Sometimes she responds with to just say yes so that we can capture it on Hansard.
Noted.
Thank you for that. Switch on the mic, Advocate Bauer.
So you provided it in that format. And if we go to 189.45, it's on your, here we go, right? This is what was provided to us as a summary of the comments you made and the documentation provided into each request. Was this compiled not by you, but by the office of the CEO probably?
Probably.
Right. So let me go to the end of the document. Yeah. Additional information provided. There says notes on meeting with Mr. Lebelo SARS dated 11 December 2018.
Chairperson,
Yes, Advocate Mbofu.
I object to this line of questioning. I spoke to my learned friend about it yesterday. No. Thank you, Chair.
Advocate Bauer, I kind of missed that. That was to kick, but go ahead. Your mic is off.
Chair, Advocate Mpofu asked me to direct him where. Now, am I taking you to it or? Okay, so just, Chair, if you could bear with me. All right.
Sorry, Chair, but the code deadline.
In the T adjournment, because I just need to find that it's attached to an email, which I know is there because I looked at it yesterday.
Yeah.
But
no,
it's
in
listed
fact,
on the email state.
Chair, can I just say this? Can this line of questioning, can you deal with it after tea, after we've spoken? Yeah. Thank you, Chair.
So, Ms. Mvuyana, it matters little whether a document is in the public domain or not, if you've, for purposes of compliance with Rule 53. Do you agree with that? Because your Sikakani report and other reports are all there. It's only the Nugent one that is not.
Noted. You say, I don't get your question, sorry.
Sorry. I asked you why the Nugent report was omitted from the Rule 53 record, and you said to me, well, it was in the public domain. But that's not the criteria for Rule 53. You would know that everything that you have regard to for purposes of the report should form part of the Rule 53. Isn't that so?
Sorry, I thought you were referring to the Nugent report not being in the report, in the public protector, listed in the public protector report.
Sorry. I started off by saying it's not in the report, and your response was there's lots of stuff that was not in the report, but it was included in the Rule 53 record. I
Okay.
then pointed out to you, well, actually, it wasn't included in the Rule 53 record. To which your response to me was, well, it's in the public domain. If anybody wanted it, they could get it. Is it
Yes, yes,
right?
that I
To
did
which
say.
I then put the proposition to you, but that's not the Rule 53 purpose. That everything that you have regard to, everything that the public protector has had regard to for purposes of the report and that emanates in the compilation of the report must form part of the Rule 53. You do know that, don't you?
Yes, I do, and you are correct.
Right? So the fact that the Nugent report is in the public domain for purposes of Rule 53 is irrelevant.
That's correct.
And so for the outsider looking in, what is omitted from the public protector's report and the Rule 53 record is essentially, amongst other things which we may touch on, but three essential things: the IGI report that was in the possession of the public protector, the Nugent reports, and this affidavit from Mr. Lebello.
I can't comment on that question, Advocate Bauer.
Well,
I was within, so I can't know from the outside what it would be perceived as.
no, but you would accept that there was an obligation on the public protector to disclose all documentation to which she had regard to for purposes of the report.
That is true.
Now, if you look at the report, let's go to 263 of the report, paragraph 5.2.26. And I'm going to ask you this, Ms. Mvuyana, I'm going to put the proposition to you that there is nowhere in the SARS unit report that it says the public protector was in possession of the IGI report. Do you disagree with that?
I'd have to check the report
Well,
again.
we'll do that as we go along.
Okay.
As in paragraph 5.2.6. She says, apparently the then Inspector General, well, let me go one paragraph up. I'm going to come back to this paragraphs for a different reason in a while, right? The report recommended, actually, let's go up to 5.2.24. Let's do it while I'm here, right? So that Ms. Mvuyana can see the context. Go back up. In which section it is, go to the heading so she can see what the heading is. Stop. Right, the heading is under the Sikakane report. So go down. Right. So there's the findings of the Sikakane report. And then at 5.2.25, it says the report recommended. You are referring to the Sikakane report, correct? The recommendation comes from the
Yes,
Sikakane report.
yes.
That the activities and functions of the SPU be investigated by the Inspector General of Intelligence. Stop. Right. So Sikakane recommends that there be an investigation by the Inspector General. And then it says in a meeting held with the Inspector General of Intelligence, Dr. Dintwe on 31 January, he confirmed that the Office of the Inspector General of Intelligence had indeed previously investigated allegations of an intelligence unit within SARS and confirmed the existence thereof. Were you at the meeting on the 31st of January?
No.
Did you draft that?
Draft this paragraph.
Yeah.
Yes, I did draft it, but obviously it is changed to confirm confirmed by the people that were actually there. But I was aware that there was a letter since all the documents came to me. So the letter was written and the meeting was held.
Yes, but you don't know whether Dr. Dintwe on 31 January actually gave the confirmation that he said in that report.
No, I just know through discussions, so it was confirmed.
Right.
That was what I was told, that there is a report.
And you were told that by who?
The people that were in the meeting, so that would be Mr. Matabuche.
And the public protector.
Yes.
And the next line, it says, apparently the then Inspector General Advocate Faith Radebi conducted an investigation on the intelligence unit within SARS and issued a report on 31 October 2014, which I was reliably be informed that it was in the custody of the former Minister of State Security, Mr. Depuyo Letsasi Duba, from whom I tried to get a declassified copy of the report without success.
Yes.
Right. You would agree that what's apparent from that paragraph is she doesn't say that she is in possession of this classified IGI report, which is in the custody of the former Minister of Safety and Security.
Yes, that's true. It doesn't say that.
All right. And she then says she tries to get the classified report without success. All right. Then you go to 5.2.
Chairperson.
Thank you. Look at them both.
Yes. No, sorry, maybe it's just for my own clarity. Up until now, we have had the version of the evidence leaders, Mr. Van Lochenberg, and the judgment being that the public protector explicitly stated in the report that she had not seen the IGI report. And now there seems to be, by some sleight of hand, a change in that version. And I just want to understand, is now the new version confronted with the truth that she did not say in the report that she had seen the, or that she did not deny having seen it. I just don't get what is being proposed, but it's clearly a variation from the original theme. So I just want to know what is being put to the witness. Sorry, Chair, just for my clarity.
Chair, will you allow me to continue my questions? And as we go through the paragraphs, because the witness took responsibility for the report yesterday without knowing certain information that emanates or had direct knowledge from her investigations in the report. And I will answer the question, Advocate Mpofu, but I just want to take the witness through where I'm going first.
Why? I just want to know.
So I didn't recognize you.
Oh, sorry, Chair. But
Please switch
no,
off the mic. Please switch off the mic.
I'm sorry, Chair.
You done?
Because I think, yes, I am.
Think?
Yeah, no, I'm done. I want to get back to my question.
Okay. Advocate Mpofu?
Chair, I've just asked a question. I just need to be clarified. I don't know why it must be postponed.
Chair, my clarification will emerge in my question.
I would grant her to do that, and you will intervene at any point when you think
Okay,
it's not answering the question.
that's fine,
Thank you.
Chair. But also it's not correct to say the witness took responsibility for the report, but we'll deal with it when I get my response. Thanks.
Okay, thank you. Switch on your mic, Ms. Mvuyana. It switches itself automatically. I know it's not you. Proceed, Advocate Bauer.
I want to go to page 264, paragraph 5.2.27. It's under the heading of interviews conducted. And in 5.2.27, the minister, the PP says, in an attempt to determine the veracity of the allegations of the existence and activities of the intelligence unit, I sought more information from the IGI. This information was attributed to a report by the former IGI advocate Faith Radebi. Do you see that?
Yes, I do.
She doesn't say that I'm seeking to determine the veracity of the allegations as contained in a report which I already have in my possession. That's not in that paragraph. Do you see that?
Yes, I see.
Right. And then if you go to 5.2.29, I had also subpoenaed the minister for submission of the report, which led to the meeting on 15 February. At the said meeting, the minister undertook to request the Director General to avail a declassified copy of the report to my office. I have yet to receive the report as promised. Do you see that?
Yes, I do.
She doesn't say in this version that I told the minister at that meeting that I have in my possession a classified IGI report.
No, it's not stated in the report.
All right. If you go to 5.2.30, as per my letter dated 25 June 2019, I will be requesting the new Minister of State Security to avail the declassified report to my office. All right. So the public protector is looking to obtain a declassified copy of the report. Do you see that?
Yes, that's what it says.
And then and do you know for what purpose she's seeking to obtain a declassified copy of the report?
No.
At 5.2.33, right? It says, in light of the above mentioned and in terms of the powers vested in me by section 181, 2 and 3 of the Constitution, I have it on good authority that the findings of the OIG report inter alia were that the following. Do you know what good authority that is that's being referred to?
No, this portion,
Okay, so you were not responsible for putting this portion into the report either.
no.
Okay. So logic dictates that the only way you can actually work out what is in the IGI report is if somebody tells you or you have the report yourself. And we know she has the report, correct?
Yes, that's correct.
So that good authority is probably the report itself. Would you agree?
If you've seen the report, yes.
If
Good
you've seen the
authority,
report,
yes.
yes. Now, the OIG report recommended, right? And I want to take you through this carefully so that we follow my train of thought. The OIG report recommended inter alia, so there's more recommendations, that criminal charges be investigated against Messieurs Gordhan, Pillay, Van Lochenberg and Richter for the establishment and involvement in the COVID intelligence unit in SARS. 1 and 2, SARS produced a credible inventory of all operational equipment which was used over a period by the NRG in the course of its COVID activities. Do you see that?
Yes, I do.
So we know that the OIG report implicates those 4 people into some criminal acts and it recommends criminal charges. What they are, you don't know.
No.
Right. So now you come to page 335, which is paragraph 8.3.1. Who drafted the recommendations in the report?
Mr. Matabucha usually drafts the remedial action in reports.
Do you have input into it?
Yes, just on as a teamwork, making imports, making amendments, etc.
Right. So when you recommend that within 90 days of the issuing of this report, acting in line with the Intelligence Services Amendment Act, implement in totality the OIG report dated 31 October 2014. In essence, you are recommending that criminal charges be investigated against Messieurs Gordhan, Pillay, Van Lochenberg, and Richter for the establishment and involvement in the COVID intelligence unit in SARS. Isn't that so?
Yes, that's what the report says.
So you do make a finding in this respect for the establishment involvement in the COVID intelligence unit against Messieurs Gordhan, Pillay, Van Lochenberg, and Richter.
Is this not remedial action?
Well, the paragraph above that I read you, you set out what the IGI report had indicated, and this is the remedial action.
Yes, but the remedial action is different from the finding.
Oh, so are you saying you are making a remedial action for criminal charges to be pursued without any finding of criminality against them?
I've never known the public protector to be able to make criminal findings.
But she can recommend that criminal charges be investigated. Sorry, I'm putting criminal findings probably badly. That there is a basis upon which people are implicated in crimes that warrant criminal charges and investigations for criminal charges against them. Would that probably be more accurate?
Please repeat.
I don't blame you. That sounded bad even to me. Right. The recommendation is that criminal charges be investigated against Messieurs Gordhan, Pillay, Van Lochenberg, and Richter for the establishment and involvement in the COVID intelligence unit in SARS.
The recommendation of the OIGI.
Yes, and the recommendation of the public protector in her remedial action is that this report, including that recommendation, must be implemented.
Yes, that's what it says.
In other words, the
Mm.
public protector is of the view that criminal charges must be investigated for those 4 people's involvement in the establishment and involvement in the COVID intelligence unit in SARS
Yes, that's what it says as a remedial action.
as a remedial action.
Mm.
What presupposes that remedial action must be a conclusion that those 4 people are involved in the establishment and involvement in what is regarded as an unlawful SARS unit.
the your questioning is confusing me a bit, because what you're suggesting is that the findings are directly linked to the remedial action, if I'm understanding you correctly.
Yes, because that's what your guidelines on the remedial action say you should do. You should link your remedial action to your findings.
Can I see the guidelines, please?
Let me just find it for you quickly. Give me a sec. Okay, let me take you to, you detail it in the report. Go to page 239 of the report. Um, 3.6, where you detail what the EFF judgment says. It deals with complaints are lodged with the public protector to cure incidents of impropriety, prejudice, unlawful enrichment or corruption in government circles. And then 3.62 says an appropriate remedy must be an effective remedy, for without effective remedies for breach, the values underlying and the rights entrenched in the Constitution cannot properly be upheld and enhanced. Now go down. Then it says, taking appropriate remedial action is much more significant than making a mere endeavor to address complaints, which was the most the public protector could do in terms of the interim constitution. However sensitive, embarrassing, and far-reaching the implications of a report and findings, she is constitutionally empowered to take action that has that effect if it is the best attempt at curing the root cause of the complaint. The legal effect of these remedial measures may simply be that those to whom they are directed are to consider them properly with due regard to their nature, context, and language to determine what course to follow. And then it says, every complaint requires a practical or effective remedy that is in sync with its own peculiarities and merits. It is the nature of the issue under investigation, the findings made, and the particular kind of remedial action taken based on the demands of the time that would determine the legal effect it has on the person, body, or institution it is addressed to. The public, and this is the part I was referring to, the public protector's power to take appropriate remedial action is wide, but certainly not unfettered. What remedial action to take in a particular case will be informed by the subject matter of the investigation and the type of findings made. And so I'm saying that when you make or issue a remedial action that says criminal charges must be considered against these people, then based on this, it must be informed by the findings made.
Chairperson.
Advocate Power. Advocate Move.
Yeah, okay, I object this being put as a as a fact or in this form of a leading question. Maybe it should be elicited from the witness, because I can't see any basis for this, saying that if someone says you must implement a report of someone else, then it means it's your findings that you are implementing. It's that person's findings. And there's nothing that Advocate Bauer is saying that appears from the remedial action. It doesn't say you must put criminal charges, blah, blah, blah. It simply says you must implement the IGI report in totality. And that covers like 20 or 30 things, at least, that I saw, including legislative changes and what have you.
Advocate Bauer.
Chair, I'm not taking this witness to any part of the IGI report that is not in the SARS report. I'm taking the witness to a part of the remedial of a conclusion reached in the IGI report that is transported into the SARS report, not by this witness, but by the PP. And I'm saying to this witness that the impact of having done that is a remedial action informed by what is contained in the report for criminal charges to be investigated against 4 people.
Chairperson.
Now, if the witness understood it differently, then she must tell us that.
Chair.
Thank you, Advocate Bauer. You're
Sorry,
coming back, Advocate Bauer.
Yes, Chair. On a quick point, I think Advocate Bauer has answered her own question. The unfairness of the question, Chair, is that question can be put to the public protector as the person, or Mr. Matabuche, if he had any hand in it. But to put it to a witness who has told this inquiry that she never read the IGI report, and then you tell her about transporting this and that and whatever of something that she has testified that she never read. Talk to the people who read the document and did the transportation if there's an allegation of transportation. She has explained the unique circumstances, Chair, under which she personally, because of her lack of the correct status, had no access to that particular piece of information. So how can she be questioned about the contents of the very thing she says she did not see?
Are you on the contents of the report?
Chair, there is a context to the report, a report which the witness told us yesterday. I was the investigator. If there's ABC wrong in this report, then I take responsibility. Now, the witness didn't put certain things into the report, but she didn't tell us that yesterday. And so now I'm checking whether having criminal charges investigated against 4 people in respect of at least one of those people we know has been complaining very loudly in this forum to this committee that I wasn't given a hearing. But you effectively, in your remedy, suggested that criminal charges must be investigated against me. And that's where I'm heading with this. And I do want the witness to comment because she was the investigator on the matter. And if her answer is this part of the report I had nothing to do with, then I know that this witness must say that.
Thank you. Over to you, Ms. Mvuyana.
Okay, might have lost you there a bit, but I understand where you're coming from, Advocate Bauer. Like indicated, I did not see the reports. So the information contained, as the remedial action says, in totality, I wouldn't have been able to actually put in the report. And then just to correct on the taking responsibility, I indicated that as an investigator, you draft the report. And then I also said that it goes through various lines where inputs are made and it's sent back to and fro until the final draft is with the public protector. In between that, any person, because it's sent as a Word document, in that chain of command can insert paragraphs that of some information that they know or that you might have incorrectly put from what their understanding. So I can, for example, I can record that a meeting was held with Dr. Tintwe, but I will not know the specifics and probably won't be able to put it as clearly as the person who was actually there at the meeting and be able to word it the way they would want to communicate it. Yeah.
So as I want to put a hypothetical to you, and I'm not suggesting this at all, but if anything relating to the IGI report that is either put into the SARS report or taken out of the SARS or not put into the SARS report, either put in or omitted, right? Reflects some form of vendetta, collusion, or bias, then you have no part in it.
If there's inclusion of the OIGI report,
If
I'm repeating your hypothetical
Our-
question.
So my hypothetical is like this. If anything that is put into the SARS report,
Mhm,
which emanates in respect of the IGI report,
mhm.
or is not put into the SARS report, and omission or commission relating to the IGI report, is a reflection of bias, actual or real, collusion, or some form of vendetta, then that could never be attributed to you because you had nothing to do with putting it in or leaving it out.
Yes,
So the general proposition where you started off yesterday about if you're going to find bias, vendetta, or collusion emanating from this report, and I'm equally responsible, doesn't apply to every aspect of the report. Would you then agree?
I don't remember saying anything about responsibility. I said that I take offense, not responsibility.
So if it, well, then let me rephrase that. If it relates to that aspects of the report that you didn't put in, then there would be no basis upon which you could take offense.
Was it aspects of the report or aspects of the whole? Well, I think Advocate Mpofu was dealing with the alleged conspiracy against Mr. Kordan.
Yes, but if that alleged conspiracy find itself, and I'm putting a hypothetical to you right now, if that alleged conspiracy, if the root of that conspiracy emanates from the IGI report, then you have nothing to do with it because you had nothing to do with the putting in or the taking out of parts of the IGI report.
I have nothing to do with any conspiracy, either from the OIGI report or from the investigation. I think I stated that yesterday.
Yes, but you wouldn't, you see, I understood, and correct me if I'm wrong, you were saying, if you're going to find a conspiracy against the public protector arising from this report, then you would have to find that I had been part of this conspiracy because I was the investigator in this report. Is that what I understood you to say yesterday?
Yes.
Right. But if that conspiracy's roots lie in what is put into this report arising from the IGI report, then you have nothing to do with it.
Yes, specifically because I did not see the report.
And the same thing would apply to anything else that's put into the report that doesn't emanate from you.
Yes.
Right. Now, if you go to the second part of the IGI report, which relates to the issue of equipment, I want to take you to page 174 of the judgment. Actually, okay, let's do that. 174 of the judgment. All right. You will recall that the recommendation which we took you to said that the intelligence equipment utilized by SARS had to be returned, retained, audited, and placed in the custodianship of the SAA. And I want to go to now, you in the report, I want to go to the judgment, which is C 318. And it would be paragraph 174. And you might as well leave it open. Yes, and you see that on it's on page 678. Okay, maybe go to 173. So just as a matter of first principles, Ms. Mvuyana, a court makes its judgments from the evidence that's put before a court. We can agree to that,
Yes, we
right?
can.
And if documents are not put before the court, then the court obviously doesn't have regard to it.
Yes, that's correct.
Right. And if there are certain allegations that are put up by an applicant that is not disputed, or an alternative version is not put up by a respondent, then the court is entitled to accept the version of the applicant.
That's correct.
Right. So if and as Mr. van Lachenberg testified, his entire affidavit, which was put up before the court, remained unanswered by the public protector, then the court would have been entitled to accept Mr. van Lachenberg's affidavit. Correct?
Yes, as a matter of principle, if not responded to.
As a matter of principle, if it's not
Yeah,
responded
that
to.
we are,
Right. What was your involvement in the litigation process in respect of the preparation of answering affidavits beyond the filing of the Rule 53 record, if any?
yeah, I had none. I remember there was a meeting with the legal team. That was just about it, nothing else.
You were not, as the author or as the first drafter of the report, asked to comment on the allegations in the affidavits at all.
No,
Right. So you wouldn't know whether, so you're not familiar with the affidavits put up before the court at all?
no,
Have you seen Mr. van Lachenberg's affidavit at all?
no.
Did you read the judgment when you have read the judgment?
I read the judgment, but that was in 2020.
Did you read the judgment in anticipation for giving evidence here?
I skimmed through it. Yes.
So you can't actually come to a conclusion as to whether the judgment is right or wrong, because you wouldn't know what the underlying evidence was before the court.
Well, the judgment is put in paper and then you read it. The conclusions that are made by the sitting judges is all I can comment on.
That is so, right?
Yeah.
So if you look at paragraph 173, the judge says, or the full bench says, the public protector briefly dealt with the equipment and employment issues and stated she had sufficient evidence to come to the findings in the report. This is what she says in affidavit. She stated that she had ample sources of information on the establishment of the unit, its activities, and the capability, its resources and equipment. And then go down. And she affirmed that the Rule 53 record amply demonstrates the vastness of these sources, which included anonymous complainants and whistleblowers. Did you include the anonymous complainants and whistleblowers in the Rule 53 record?
Yes, the Specifically, the scared whistleblower, which were in my possession, was included, I believe so.
Right. Were there any other whistleblowers? I don't want their identity. I just want you to tell me whether there were other whistleblowers and how many there were.
There's one that I know of that we met. But they didn't put the complaints into a document. So it was just told to us. There were various other emails that were dropped, or not even dropped, emailed by, what do you call this? Internet cafe email addresses. And that would just pop into your email. And no, they would not have been included in the Rule 53 because some, I don't know if I mentioned before, we've already covered in one complaint. So we don't keep on putting in complaints or putting in information that we already have.
You wouldn't also be able to test the veracity of what's contained in those.
Yes, especially
Yeah.
once you email them back, then they don't respond for meetings, etc.
And do you usually email them back to ask them to come in for a meeting?
That's the standard, yes. But sometimes you make the decision not to, based on, depending on the situation and the circumstances at the time. Like I said, the internet cafe complainants are easily identifiable. So, you know, those ones that it's at info.com. So that belongs to a general crowd. You then don't want to also compromise anyone.
Okay, right. Now in 174, you will see that the judgment details, I should probably read as far as the interception issue is concerned. The public protector stated the following, and then says, when this interview was conducted with the office of the OIG, I was aware from the preliminary investigations that there was an unlawfully established and rogue spying unit established within SARS. The OIGI, as set out in its report, had concluded that the SARS had established an illegal spying unit which was engaged in corrupt and illegal activities. There are recordings of people working in the spying unit detailing how the spying unit performed its activities, which are part of the record of these proceedings. The content of these recordings demonstrate an abuse of the unit that could make anyone with a constitutional duty to promote and advance the Bill of Rights cringe. I was shocked to learn that SARS had established a spying unit to advance its statutory objections. More importantly, the spying unit appears not to have operated lawfully, but in a rogue manner. Now, can I ask you about these recordings? Did you listen to these recordings?
Sorry, before this what that you've just read, it's from,
The public protector's affidavit.
okay.
Go on.
Okay, so there's recordings of the people that worked at the spying units. Yes, I did listen to these recordings. Deval and Lombard, I believe.
All right. And how did you ascertain the veracity of the recordings?
We did not ascertain the veracity of the recordings. You mean in terms of it was provided to us in a memory stick, or to me in a memory stick already as a recording. So unfortunately, I don't have resources to verify if a recording is not tampered with, etc. A recording just is a recording.
And what steps did you take to get Mr. Lombard and Mr. Deval to come in to meet with you?
None that I can recall, but I think we did try to, as Mr. Van Locherenberg, obtain information from the former employer or alleged former employer, which was SARS. That information wasn't provided.
Sorry, I don't understand the answer. I asked, what steps did you take to get hold of Mr. Lombard and Mr. Duval so that they could come in for you to interview them?
We tried to obtain information from the former employer who could not provide.
And who tried to do that?
Mr. Matabuke is the one that was in communication with the SARS whistleblower internally.
So you didn't actually ask SARS, you asked the whistleblower to give you this stuff. And when he couldn't give you, or you gave you wrong stuff, you just left it.
Yes. This person was holding a high position within the HR division, so they had what we believed access to the information easily.
So, and no formal letter was written to the commissioner of SARS asking for it. No subpoena was issued, nothing.
No,
So what affidavits of any member of the alleged SARS unit did you have in your possession under oath indicating some form of evidence?
I'm not sure. Did we say that we have
No,
affidavits?
Well, I'm asking, did you have any, let me rephrase it. Did you have any affidavits from any member of the unit in which you found that the members had been engaged in unlawful activity? Did you interview any of them and take an affidavit?
No.
Chairperson.
Thank you. I'll get both.
Yes, thank you, Chair. No, I don't know if this will assist from Advocate Power. Just to remind you that the alleged interviews were actually with the Commissioner of SARS. And if she wants us to obtain an affidavit from him to say that he participated in the affidavits, we will do so.
Chair,
Advocate Power.
we've been told about Mail and Guardian, left, right, and center. And Mail and Guardian says you must go and do your own independent investigations. I'm sitting here not interested in the actual recordings. I'm interested in what was being done at the time this report was being compiled by the public protector as diligently for purposes of this report. So that's what I'm asking.
Chairperson. Then, okay, thank you, I understand that. But so if that is the case, then what on earth is the relevance of that to the issues in charge 11.3 and 11.4? Either we can spend the whole day here about how an investigation was done or could have been done better or this or the other. But that's not what this inquiry is for. This inquiry is for the issues of alleged dishonesty and bias on the part of the public protector, not even this witness.
Chair, the manner in which this investigation was conducted and the outcome is what informs the allegations in the court on bias and dishonesty. Now, you either did do something because you were, and I'm not saying this, you're asking me a question, and so I haven't come to that conclusion, so I don't want you to say that I've reached. You either have done something or you haven't done something for purposes of being determined to come to a predetermined outcome, or you have done something or you've not done something because it was impossible for you to do, or you have done something or you have not done something because you just couldn't be bothered to do it because you were incompetent to do it. So there's a range of issues, and the committee must eventually make a call on, was it informed by some sort of predetermination to come to a set outcome or not? That certain seems to be very obvious steps to have been followed in an investigation was not guided by the public protector to the investigators to do.
Okay, I'm going to allow her to proceed. Proceed, Advocate Power.
You see why I'm asking you this, Ms. Mvuyana, is because when you get the Noseweek article, even though the classified IGI report there may be some hesitation on wanting to rely on it or wanting to put it out there because there are some concerns about security or for whatever reason the public protector will come and tell us. What the Noseweek article tells you in terms is that Mr. van Lachenberg has reams and reams of information at his disposal. Do you agree with that?
You can put up the article.
Shepherd, the article is it's bundle F4357. Yeah. The Noseweek article, 189.15. The Noseweek article, just as a precursor, refers to the 62-page classified report, and it then quotes Mr. Adrian Lakay, and you've got to go down because Mr. Lakay then says, is that the sign for T, Chair? Okay, let me finish this.
I wanted
Chair,
you to,
one moment.
unless you want tea instead of.
No, let's
Okay.
go down. There we go. Mr. van Lachenberg said Lakay had presented 34 related instances to Inspector General Radebe and identified over 60 individuals he believed should be interviewed. He provided the IGI with multiple data and evidence, including a memory stick containing whatever information and data was in his possession. Almost right. The IGI secret report, whose contents were now present, tartly observes that in the first of 2 interviews with him, where he was accompanied by an attorney and 2 advocates, van Lachenberg attempted to direct the interview by proposing that he had 38 themes on which he would like to advise the IGI team, and he provided names. So you would know that he has a memory stick containing whatever information and data was in his possession from this report. Correct?
Correct, yes.
I actually, maybe rightly or wrongly, thought that this might have informed your need to send him the subpoena in the first place. Was that not the case?
Partly, but not really. Partly.
Maybe you should explain the partly part.
Information is gathered from anyone who is willing to assist. So from this article, Mr. van Lachenberg says, I believe that he was a part of the so-called unit and he has evidence. So when we check the evidence as well that was submitted by SARS, besides the fact that there were also allegations directly linking him or alleging some improprieties on his part, he at some point was the head of the so-called unit. So that's why I say partly.
Okay. So you knew that for several years. I think he testified that from 2007 but for some break in the period, for almost a continuous period of 7 years, he was the head of the SARS unit.
I won't be sure about the number of years, but yes, I did.
You did know that he was the head of the unit.
Yes, at some point after, I believe, either Mr. Pillay or.
Okay,
Yeah.
thank you. On that point, we're going to take a 10-minute break and be back at 1:45. Thank you.
Recording stopped.
At least this tea time, you made the time today. We're just waiting for Advocate Chabala and then we start.
Can I take you to paragraph 35 of your statement? Page 458. What knowledge do you have of Mr. van Lochenberg's participation in the Sikakane inquiry?
From what I can recall, the Sikakane report was commissioned after allegations were made against him by a certain girlfriend, if I'm not mistaken.
So now the reason I'm asking you this question is that you are aware that the matters relating to the SARS unit did not fall within the initial terms of reference of the Sikakane report.
I won't recall the exact terms of reference.
If I'm wrong, Advocate Mpofu will jump in and say I'm wrong. And Mr. van Lochenberg's stance has been, when I was interviewed by Advocate Sikakane, that interview took place prior to any inquiry by Advocate Sikakane into the existence or legality of the SARS unit, and hence I was never given a chance to address that issue with him. Are you aware of that?
No, where did he say that?
He said it in the affidavit in the High Court.
I didn't see the affidavit of the High Court, so I'm not aware of that.
And what do you know about Mr. van Lochenberg's participation in the KPMG report?
None.
And in the Nugent reports?
None.
And in the OIGI investigation?
And unless you consider what he said in the Newsweek article, that's about all the information I have.
So when you say in paragraph 35 of your affidavit, as in the case of the Sikakane, KPMG, and Nugent reports, Mr. van Lochenberg had apparently been given the opportunity to participate in the OIG investigation. Where did you get that information from?
The Newsweek article, does it not state it?
No, but you didn't know what his involvement was in the KPMG and Nugent reports, right? You draw the conclusion from that essentially Van Lochenberg participated in the Sikakane matter, the KPMG matter, and the Nugent reports, and he had also been given the opportunity to participate in the OIG investigation.
Like you've already stated, I think in the Sikakane, if I can recall, Advocate Sikakane stated that he had interviewed Mr. van Lochenberg in relation to the allegations made against him. KPMG, I won't recall if they stated it. Nugent, I also don't recall. I didn't read that part. So it's only the OIGI where the Noseweek alleged that he had made some sort of statement to the OIGI,
So this doesn't actually fall within your personal knowledge.
except for Sikakane and OIGI. Personal knowledge in terms of something I read or something I know that he told me.
Well, no, just read the sentence that he had been given an opportunity to participate in,
Had apparently,
yeah, apparently been given the opportunity to participate.
yes, that's why I put apparently.
Because it seems to be an inference is drawn that even though he didn't get Audi from the public protector, he got Audi from all of these bodies in relation to the issue of the SARS unit. But you don't have that kind of detail, do you?
No,
So one mustn't draw that conclusion from the sentence.
no. I don't know if the apparently maybe is not put in the right place or, but this is what was apparently the information that we had, or I had, that it's some of the reports, or especially Kakane, and the Newsweek article stated that he had been given an opportunity. So from him directly, I wouldn't have confirmation of that fact, of course.
You then say in 36, I'm advised that the OIG report. Who advised you?
Mr. Matabuche and Mr. PP, sorry, seems to be the backbone. Okay.
Of the dishonesty findings against the public protector. That's in the judgment.
Oh, yes, that
I-
is not Mr. Matabuche. It was discussed with the legal team,
Which legal team?
PP's legal team.
Okay. So they told you that that was the basis for the dishonesty findings.
Yes,
And you haven't looked at the judgment in great detail.
yes,
Recently.
mostly on the basis of the charges, so that alleged dishonesty and bias.
So when you say as explained below, this finding seems to be based on the demonstrably inaccurate premise that the public protector stated in her report that she had not seen the OIG report, which was anonymously dropped at our offices. Was this also told to you by the legal team?
The inaccurate premise, the inaccurate, this is my assessment of the judgment in terms of when they speak about the fact that the public protector was dishonest in that she did not see the report. So it was put to me, where in the report is that written? And I stated that it is not in the report.
Okay.
So that's where that comes from.
So let's accept that it's not in the report and you looked and you said it's not in the report. But you go a step further and you say that the finding of dishonesty is premised on the demonstrably inaccurate premise.
It seems that the finding.
Yeah, seems to be based.
Hmm.
As explained below, this finding seems to be based on the demonstrably inaccurate premise. Is that your understanding?
That's what is stated there.
Yeah. And you didn't have regard to any of the affidavits she filed at court?
No, I did not.
Okay, go down. We will read it. You say, however, nowhere does the PP ever say she did not see the OIG report. Right. We've also established that she also doesn't tell them in the report. Nowhere does she say that she does have the OIG report. You agree with that?
Yes, as we've already discovered.
Right? And although you say it was openly disclosed in correspondence with the minister and other leadership of NIA, who's the other leadership of NIA?
The Director General, Dr. Dintwe, was the minister, and other leadership is Dr. Dintwe. Those, I believe, were the only correspondence that were referred to.
So,
Honorable Kondo.
I just wanted to point out that Dr. Dintwe isn't part of the leadership of the NIA.
Can't hear you.
I said,
Please,
Dr. Dintwe isn't part of the leadership of the NIA. He was the Inspector General of Intelligence. So it's totally independent from.
Chairperson,
you done? Okay, thank you. Advocate Mpofu, sometimes you need to pull back from interfering before somebody concludes
I
whatever they're
apologize, sir.
saying.
I apologize.
Yes,
Just
over
drawing your attention here.
to you.
Chairperson, Dr. Kondo last week said that if the public protector wants to testify, she must come and testify. And she said it speculating, playing a voice expert. Well, I want to tell her if she wants to testify, she must just go and take the oath. It's not for anybody to say what information. The witness has been asked a simple question. What did you mean by the leadership of the NIA? She says she meant Dr. Dintwe. That's it. So if in fact Dr. Dintwe works at Groteskir or whatever, that's a matter for evidence, not for a member to come and testify about it.
Okay, thank you. You will later get an opportunity for your questions, which you can point directly. But when you came in, Advocate Bauer was in the middle of responding to that. If we can allow her. Because what I heard you doing, you were seeking clarity.
I was seeking clarity because she did acknowledge that he was the Inspector General of Intelligence. And now she's she's saying that he's part of the leadership of the NIA. So
Put that as part of your questions.
Yeah.
Thank
So
you.
I was seeking clarity on what exactly she was saying.
Yeah, note that for yourself.
No, Chair, she was not seeking clarity. She was making a statement, giving evidence.
I was seeking clarity.
Okay.
You can't speak
No,
for me
Chair, she
either.
was not
Okay,
seeking
okay.
clarity.
Okay. Advocate Bauer.
if I can maybe go back to my questions. You saying that sentence before we come to the leadership of the NIA, you're saying that sentence, it was common knowledge that the report or a version of it had been anonymously dropped at the offices of the PPSA. Common knowledge to who?
To the public protector team.
To the public protector team.
Yes,
Because you don't find that in the SARS report either.
yes, as we've previously
So that's
stated.
That's not shared to do that. You haven't seen the affidavits because I've looked to see where that's in the affidavits. I'm not saying it's not there, but I'm not sure that I could find it. What I do know from the judgment is that the council was attributed in argument to have put that forward to the court. Right. So then we go.
Sorry if I may, I'll just correct the NIA for Inspector General of Intelligence. Thank you.
Did you ever listen to the recording of the meeting of the 31st of January?
No.
You raised this issue about the declassified report was provided in November of 2019. Did you have a look at it afterwards?
No, the investigation was completed. There was no need for me to.
Now, one of the issues that came up yesterday, and I'm going to jump around simply because was a notice that had gone out on YouTube, and you were asked to confirm whether it was true that the Section 7(9) notice to Mr. Godan, which was issued on 3 June 2019, went out on YouTube prior to it being given to him. Do you know anything about that?
No.
If we take you to bundle E, I'm not going to take you to it. It's fine. You don't know anything about it. Right. You then were asked yesterday as to the order of the subjects of the public protector report, and your answer was Godan was the counting officer. Pillay then followed Godan when he was appointed finance minister, and then Magashulu followed Pillay. Did I understand you correctly?
Yes, but I may have gotten the dates wrong, or who came before the other.
Yeah, because if I look at what they say in their affidavits, I don't think it's major, is that Magashulu was immediately appointed as acting commissioner when Godan left to become finance minister. He was then appointed commissioner and he served as such, and Pillay became acting commissioner only years later when he resigned. So what you said yesterday wasn't correct.
Yes, it wasn't correct. Who is, in terms of who was the commissioner before the other?
Because I thought that was sort of an endeavor to say some order of importance or some scale of targets, primary as opposed to secondary.
No,
But is that what you sought to convey?
no. Everyone who was an accounting officer basically was what I wanted to convey. The order wasn't necessarily important.
Right. Now, as a general proposition, if you investigate a government department and it comprises of 10 people in this department, and they are all implicated in your investigation for some sort of maladministration, would you interview them, or would you make findings against them individually, or do you only do that against the accounting officer of the department?
It would depend on the implication. If 10 people within a certain department, the responsible person So that is responsible for accountability of an institution is obviously the accounting authority or accounting officer. So in that 10, the junior official that drafts the memo, for an example, would also be implicated as the drafter. So you would then make a decision to either interview them or not. And then also make a decision whether you make the finding is against them or not. But at the our first point of accountability measure is the accounting officer. So
And let's assume you have a department where there's a DG and you have 3 deputies,
Mhm.
senior managements, and there's 30 people work in the department. And the 3 senior managers each control 10. Would you, and the entire division of 10 is implicated. Say let's call it division A, and you find that division A had acted unlawfully. Would you make a finding against the senior manager?
it would depend on the conduct that is being investigated. Not in all instances, but but I'm saying it would depend on the conduct. Maybe you'd have to be more specific.
So when you make a finding, as in this case, that the SARS unit operated illegally and that members of the SARS unit engaged in illegal activities,
Mhm.
right? Do you,
Oh, sorry. Sorry. It was Dr. Gondwez, when I say is looking at me.
she can be terrifying if you say yes. Fine. See, now I've forgotten my question. Okay, so I was saying to you, you've now found in your investigation that this SARS unit and the members in the SARS unit have been engaged in illegal activities.
That's the finding in the report.
That's the finding in the report,
Okay.
right? Not only has it been unlawfully established, and
Mhm.
for that you hold accountable the people who established it, but you've also made a finding that they've been involved in illegal activities.
Yes.
You would agree that you make that finding in the report?
Yes.
Now, there are 26 members at any given time or not within this unit,
Mm.
but the finding is that this unit is engaged in unlawful activity. And as I understood your evidence earlier on, you didn't speak to any one person in this unit,
Yes, that is true.
right? Now, if you make a finding of a unit being engaged in unlawful activity, then the implication of that is that the people who are employed in that unit are engaged in unlawful activity.
It would depend. I don't recall. Can you please go to the finding so we can read exactly how it was constructed?
Report. Right. Let me take you up to the 6 things that you set out you're investigating, and then I'll tell you. Okay, go to, Shepa, go to 245 at 4.3. Right. The following were issues considered in investigation. The first one is the Executive Members Ethics Act, the EMEA complaint.
Correct.
That EMEA complaint takes up very little of the report. Would you agree? I think it's 4 or 5 pages.
I'll agree with you. I'm
All that-
sure you wouldn't mislead me on that.
All that you had in regard to for purposes of the mere complaint is Mr. Godin's statement, the extract from the parliamentary Hansard, which says what he said to Parliament, the extract of what he said to the Zondo Commission, and an analysis of a comparison of what Mr. Godin said vis-a-vis that. I'm going to come to it in a bit, but just I'll take you there. I don't want to mislead you. And then whether Mr. Godin had established an intelligence unit in violation of South African intelligence steps, and whether that constitutes maladministration. Right. And then 3 was the issue of the procurement procedures. Right. For gathering intelligence, and whether that amounts to maladministration. 4 is the recruitment of the people who worked in it, whether that constitutes maladministration. Now we come to 5. Whether the intelligence unit carried out irregular and unlawful operations, and whether this constituted maladministration. So in order to make a conclusion that the intelligence unit carried out irregular and unlawful operations, then it stands to reason that the persons who are in that intelligence unit carried out irregular and unlawful operations.
Do you want me to answer before we
Yeah.
go to the finding?
Yeah.
Because I requested to go to the findings so that we can see the actual
Can you,
drafting.
if you look at 4.3.5, if you read it, whether the intelligence unit carried out irregular and unlawful operations, and whether that constituted maladministration.
Yes, the unit consisted of members or employees. They would then be the ones that would have allegedly carried out
Okay,
the
so,
irregular and unlawful operations, allegedly.
right. And then you come to paragraph 5 of the report. 5.1, you see it will start at Shipper, let me just see your numbering. Okay, yeah, it's 250. You see it, it starts 5.1, it's 250. And if you go down, you apply the legal principles, you see the conclusion on 254, which is why I said you 4 pages on the issues, right? And so that's the first thing on the EMEA complaint. And the high watermark of that finding, which the court then finds to be irrational, is that it is the conclusion in 5.1.15. His response is misleading and does not seem like a bona fide mistake. And therefore the conclusion is made that he deliberately misled Parliament. So that was based on 3 issues, and the court has reviewed and said that aside is irrational. But I want to take you to the second investigation is the establishment of the SARS intelligence unit. Go down at 5.2.1. Right. Okay. And if you look at you first detail SARS's response in a few paragraphs. This is but the snapshot of the actual response you get. It's much lengthier, correct?
This is the letter, and then there's annexures attached.
Okay, so the report has annexures attached.
No, we don't attach annexures in our reports.
Sorry, I misunderstood your response. You talked about annexures.
When SARS response to our allegations letter, which will detail the allegations and also request documents and any other information that they can provide. SARS then, or most institutions, we prefer them to do that actually, will then write a response to each allegation, either saying they deny or accept or do not deny or accept the allegation. And then they will put supporting documents as annexures to that specific allegation.
Okay.
So it won't be here. Usually that is now the evidence that will detail will be your memos, your invoices, etc., depending on what you asked for.
So when you detail in 5.2.5 a reference to the Nugent Commission, you are detailing what SARS referred the PP to in respect of the Nugent Commission.
Yes,
Correct?
that's correct.
Okay. And then if you go to 2.57 at 5.26, you then refer to this memorandum requesting funding, which Advocate Mpofu took you to at length, and I want to come back to that in a moment, but let me take you to where I was initially going. You then see quite a bit. I want to take you to number 5. The findings against the unit. Would be 5.5. Page 299, right at the bottom. So regarding whether the intelligence unit carried out irregular and unlawful operations and whether this constituted maladministration, right? So we look at the common cause issues just to refresh your memory. Let's go down. And then you refer to an interview information regarding the recordings of Mr. van Rensburg to Advocate Brassey. Did you have Advocate Brassey's report?
I believe so.
Okay, I'm going to flag it and double check during the lunch adjournment because I don't think it's another
in
one
the
of the
report.
documents.
I
Not-
don't, yeah, if it's not listed as one of the reports in the SARS report, then no, I don't think I had access to it.
So effectively, we know that you didn't have any affidavit from Mr. van Rensburg, and it's a sort of a double hearsay,
Yes.
right? Go down.
Sorry, double hearsay.
He says it to Brassey and you get it from the recording.
Okay.
I'm sorry, I'm
Yes,
trying to help here. Yes, not an objection. I seem to recall that the Brassey opinion or report or whatever is listed as one of the documents it might not be in the report, maybe one of the drafts, but if I find it, I'll point it out too. Thanks.
Thank you for that. Advocate Bauer.
So, Mr. van Rensburg's, the sole source up until you come to 5.5.9. Did you by any chance speak to Mr. Gerinal?
No.
And he would be readily available if anybody wanted to speak to him about any of this. Would you agree? You
No.
would be able to find him.
I believe so. He's an outer. Ne?
Yes. You then look at information. And this is a recording which you get from SARS, from Mr. Lombard and Mr. Deval. Right?
Mhm.
That they give Mr. Mvuyana. And these were recordings that were quite dated by the time they came to you. They hadn't been recorded recently, correct?
Yeah, not as recent as 2019.
Yes. Right. And that was the sole source of information as recorded in the report, apart from what? Go down, Chipo, so we can see what the next recording is. The next heading is at 5.519. We see at Mr. Gordon denying it. We see Mr. Pillay going down. And then you've got a heading that says independent evidence obtained. It says other operations conducted by the CBCU included surveillance operations of premises, following of vehicles, obtaining information from confidential sources. Now, do you recall where that information came from?
I believe from either the whistleblowers or not the whistleblower, the anonymous emails, and I believe there were pictures as well.
These anonymous emails are not part of the Rule 53 record, are they?
I can't recall.
And
'Cause, I can't recall whether independent. I'm just saying that maybe from the emails and pictures as well. I can't 100% recall where it came from.
you see, I scoured through the Rule 53 record and the supplementary Rule 53 record to ascertain where this came from. And the reason why I'm raising it is because the court also in its judgment raises some concerns about it to do that.
Okay, just a pause. Advocate Mbofu.
Thank you, Chair. Yes, sorry, I found that reference is in the draft report of the 1st of July, page 6458, where item 4.4.1.12 is a copy of a legal opinion of Advocate Brasi dated 11 November 2014. I do accept that it didn't find itself into the report. I just wanted to point that out. Thanks.
Thank you, Advocate Mbofu. Back to you, Advocate Bauer.
So with that interjection of Advocate Mpofu's, what must we make of that, Ms. Mvuyana? If
No,
the-
Chairperson, can ask me. What must make of that?
Can I finish the question, please?
Yeah, well, don't put it to the witness.
I can put it to the witness in a different context. Let me finish witness. Advocate Mpofu says that the Barassi opinion appeared from the list of documents in a draft version of the report, but it doesn't appear in the final version of the report. Now, what must we make of that? That it was taken out?
I don't know.
It's clearly referred to in the SARS report. You agree? I just took you to a place where it's referred to.
In Van Rensburg.
Yeah.
Yes, you took me there. But I would have to see the draft that Advocate Mpofu is referring to. And so I can recall if or not it was removed. Is it still in the same place? Then we go to the report to check if it's there. And then I'd have to try and recall why we would have removed it if we did.
Advocate Mpofu says it was at 4.2, 4.4.1.12. And I can tell you that it's, am I right? 4.4.1.12. Yeah, it's not there. It's 4.4.1.12 are all the letters dealing with the OIGI.
Sorry, just so that the record doesn't show that I was misleading the inquiry. I think what Advocate Bauer is mixing two different reports. What she's correctly saying is that I identify 4.4.1.12, but not of the report, of the earlier draft. Thanks.
And I understood the witness to be saying if it's not where it was in the next draft, then she needs to figure out why it was removed from that location. Is that?
The first draft might have had different numbering even so the final report, it might be paragraph 5. And in the first draft, it might have been paragraph 4. Final numbering check is done at the final stages. Because when information is put in, deleted, the numbering changes depending on the word, the laptop or machine that you're using to draft.
Sorry, Shipper, can we go back to the page we were at? Um, 250 something. There we go. Yeah, there we go. Right. So your independent evidence obtained relates to one line in the report, and then you refer to submissions of Mr. Manyiki. And that was submissions that had been provided to the public protector during the investigation that had been undertaken by Mr. Madiba previously. Would that be so?
Correct.
Right.
The closing report was signed by Mr. Madiba. He did not conduct the investigation.
Right. He was in charge of the person
Team.
who conducted the investigation reported to him in the first instance.
Yes.
Right. And he concludes in the closing report that the PP didn't have the requisite capacity to undertake this investigation. Do you recall that from the closing report?
Yes, I do.
Right. And what capacity or did you have that Mr. Madiba didn't have or thought he didn't have to undertake the investigation this time around?
I can't answer that question because I don't know what Mr. Madiba was referring to when he said capacity. I know when I spoke to the investigator who was in charge, we did mention that there were backlogs, not enough investigators. He also took some time to actually attend to the matter. So that could have also been categorized as a capability, a person to actually investigate or to sit and actually attend to the file could have also been a problem. So I won't know what Mr. Matiba or the investigator said or why they said that.
And so you relied on this, on the documentation that had been provided by Mr. Manyiki. Did you interview Mr. Manyiki?
No, we could not get a hold of him.
And this information that he provided the Public Protector's Office was not an affidavit, correct?
No, it was almost like a submission of some sort he drafted. It wasn't an affidavit.
And what did you do to ascertain or check the veracity of the contents thereof?
Please explain.
The authenticity, the legitimacy of the contents of the submission. Check whether what is said therein is true and correct.
We just put the information as in when a complainant provides us with information, we capture it in the report as well. Then from that, you then combine that information with the information that would have been submitted, as well as evidence submitted by the respondent department, and then come to your conclusion.
Okay, so you didn't do any independent investigations.
Like what?
I'm not
Let,
the
let's
investigation.
maybe let's go through what he's saying.
Okay, well, he makes certain submissions. That's his submission. You've
Mm.
transported it into the report. Let's go down. Right. Okay. Go down. You then applied the legal principles. You didn't have any other information besides what the denial on the part of the SARS Godan Pillay and what you were provided for essentially by Mr. Manyiki.
Yes.
And you took what Mr. Manyiki said at face value.
Yes, we took it and put it as he stated. I think there is a sentence where we state that this was also corroborated by the information that we had from Mr. Lombard. So yes, I guess if that answers your question.
Right. So on the one hand, you have Mr. Pillay and Mr. Godan on affidavit. And on the other hand, you have Mr. Manyiki in his submission and Mr. Lombard on a recording, neither of which is verified. Would that be true?
I wouldn't know about verification, but that's the information that we had.
You, the investigator, did you check whether any of the vermins in the recording or on the submission could be corroborated independently in any other way?
No,
Did the PP in the Mail and Guardian dicta fashion say to you, you have to go and independently investigate this to check the veracity of the allegations contained there?
no, I do not recall, no.
See, I want to take you to what the judgment has to say at paragraph 182, which you'll see at page 681.
Just repeat the paragraph.
182. Right? By dismissing Mr. Pillay and his evidence out of hand, because that's essentially what occurred Isn't that so? The version that was put up by Mr. Pillay and SARS was rejected in favor of the version that was put up by Mr. Manyiki.
Are they referring to the report or the affidavits?
They're referring to the affidavits put up by Mr. Pillay before the report.
In response,
Now, before you, they're not referring to Mr. Pillay in the court proceedings, they're referring to Mr. Pillay in respect of what was submitted to the public protector.
okay. And can you please
go-
repeat the
sorry.
question?
Sorry, let me not, I don't want to put you in, go up to 180. That's the context in it. And the complaint is the failure to deal with Mr. Pillay's evidence. He responded in considerable detail to the complaints enumerated by the public protector in his first affidavit. And then she set out the considerable findings that's in the provisional notice. And then they deal with that the sole reference in the notices to the content of his first affidavit was a terse recordal of a few submissions made in his affidavit. So he had very little space in the 66 pages. And regarding the allegations that the unit was unlawfully established, and a redacted and inaccurate recordal of what Mr. Pillay stated in his affidavit regarding the allegations that SARS had irregularly procured costly intelligent equipment, which the intelligence unit used for gathering. A dismissive response to the contention in Mr. Pillay's affidavit 23 April, that the public protector had previously investigated and satisfactorily resolved complaints relating to the recruitment and the recordal. Go down a bit. I want to switch past that. And then Mr. Pillay puts in another affidavit setting out his detailed factual responses. And then the court says that his evidence was dismissed out of hand, and that what was dismissed was the only evidence that served before her on oath and uncritically adopted under the guise of conducting her own investigation, the unattributed and anonymous complaint that was delivered to the Office of the Public Protector by Mr. Manyiki on 21 February 2012. That was the one that was declined. And then they go down, because I want to come to the CBC thing. In the report, the public protector describes the complaint as submissions of Mr. Kaletso Manyiki and states that he was employed as a specialist agent with the CBCU. Right? It is common cause that he was not a specialist agent, and Mr. Pillay and Mr. van Lochenberg disputed that the complaint originated from Mr. Manyiki, that it had actually been lodged on behalf of someone named Dr. Mvuyana. Right? The public protector in the report continued attributing certain allegations concerning the operations of the unit to Mr. Manyiki, as if he testified before her to this effect. She did not investigate the origin of the complaint or the veracity of the allegations made in the complaint. That is correct, right? There was no investigation of the origin of the complaint or the veracity of the allegations made there.
The 2012 complaint is, because in the report, I think it's 2014. So are they the same investigation? Yes, I know Mr. Manyika's complaint, but as far as I can recall, it's a 2014
Yes.
complaint.
Yeah.
So I don't know anything about a 2012 complaint.
I think it was initially opened in 2012, and then the additional information was provided in 2018. So the complaint was 2014. Sorry, and the complaint was finalized by Mr. Madiba only in 2017. If you look at it, I'll show you the reference. Yeah, I'll find it for you during the lunch adjournment. But let's just go down. Right. Go to paragraph 200. right? There are numerous places in the record which are demonstrative of the fact that the public protector, prior to the writing of the report, documents in a possession which plainly show that the unit never procured or used any unlawful clandestine spying equipment. In the report, the public protector made certain findings that attributed the listed equipment directly to the unit in question, that is SPU, NRG, and HRIU specifically. She did not attribute it to ACAS or customs or to the CU, but to the unit. Do you know what ACAS was? Do you recall?
No, I do not recall.
It was the Anti-Corruption and Security Unit, which was a standalone division reporting to the General Manager, Risk and Enforcement, and later to the SARS Commissioner. It was an entirely different unit to the SARS unit that was under investigation. And one sees that from footnote 43 of the judgment that describes what the unit is about. And then the public protector found that the procurement of intelligence equipment utilized for the unit was improper and amounted to maladministration. Then the court says the listed equipment in the report and Rule 53 record are used to seemingly support this as evidence. On closer inspection, this is not so. There is no evidence whatsoever that demonstrates any of the impugned equipment to have been procured by SARS for the unit, used by the unit, or that the unit even knew of such equipment. All procurement files in the Rule 53 record dated from 2009 onwards until after Mr. Mvuyana took over at SARS points to ACAS. The files include motivations, quotes, and approvals by ACAS and signatures by ACAS staff. None of it can ever be described as wiretapping or interception equipment. And then it goes on that says, in the report, the public protector sets out in detail how ACAS procured equipment for ACAS in 2009. And then at paragraph 5.3.18 on page 64, the unit is simply slipped in. And at page 65 of the report, the public protector dealt with the so-called Magloba list. Again, all these items can directly be found under the ACAS procurement records in the Rule 53 record. The same goes for the items dealt with on page 66. It is all part of the ACAS list and or the Mvuyana list. Pillai's affidavit annexes a newspaper article complete with photos and description of these items donated by the US Customs, taken by SARS in June 2017, long after Pillai had left SARS and long after the unit had closed down. Nowhere is the unit reference listed or reflected in any of the procurement or payment documents. Go down. And this is the part I want to take you to. After listing the evidence, the public protector found that although SARS failed to provide me with documents relating to the procurement of equipment for the CBCU, NRG, and subsequently the SPU, evidence at my disposal confirmed the existence of such equipment as well as the acquisition thereof. This is untrue. You see that?
Yes.
I'm not going into a debate with you as to whether the judgment is right or wrong. The judgment is what the judgment is. The reason I'm putting that to you is because you had said earlier on that the underlying dishonesty attributed to the public protector was to be found in the IGI report. And what I'm pointing out to you is that the court at paragraph 202 also say that the finding isn't true in paragraph 202 of the judgment. The court then goes on, there was no evidence available to support the findings made by the public protector. As stated, all the documents in the Rule 53 record had nothing to do with the unit and all related to ACAS. It even included photos taken by the SSA at SARS Office B3 Riverwalk offices, which was the storage of ACAS. There was no evidence that this demonstrated any procurement of any equipment by the SPU, NRG, or RIU from 2007 to 2014, except for the list supplied by Mr. Piller in his second affidavit in reply to the notice and confirmed by Mr. van Lochenberg in his affidavit. Moreover, the public, just hold on, Advocate Mpofu, just let me finish. Moreover, the public protector could easily be invoking her powers of subpoena, have obtained further documents and viva voce evidence from various persons who would have assisted her in avoiding at arriving at an illogical and unsupportable conclusion about the equipment. And the conclusion that is found in the report and which the court finds to be illogical and unsupportable is to be found in paragraph 203 of the judgment, where he quotes from the report. This is a verbatim quote from the report, but let's just read it from here. The public protector finds in the report, it is extremely impossible that the unit carrying out investigations on behalf of SARS would not have procured equipment for the fulfillment of its duties and functions as admitted to in many instances and at so many levels. The only contention by SARS being that it was not conducting illegal operations. This is a peculiar statement to make. How does no evidence become evidence? The public protector then proceeds to make the following finding. If its operations were lawful, it is unclear why SARS and or its former employees would keep the procurement of equipment such a guarded secret. And I understand that to Ms. Mvuyana, the guarded secret to come about because the information wasn't provided to the public protector. And because it wasn't provided to the public protector, the conclusion that she comes to is, I can only come to the conclusion that proper procurement processes were not adhered to and that such conduct amounted to the violation of the PFMA and thus constituted improper conduct under those provisions. And then he says, I'm of the firm view that the failure and blatant refusal of SARS and its former employees to provide me with records of the procurement to confirm the purchasing of the said equipment and the whereabouts thereof is suspicious, go down, and unwarranted, and is aimed at perpetuating the narrative that no such intelligence unit existed at SARS. And so the court says the reasoning adopted by the public protector in coming to these findings in light of the evidence available to her at the time is illogical and clearly fallacious for the public protector to conclude that the unit was in possession of equipment capable of being used to conduct clandestine activities in the absence of SARS providing the office with a list of this equipment is astonishing. Go down. And then they say, you come to the conclusion by adopting a flawed finding of the Sikakani panel. And effectively, it says that not even Sikakani found equipment for wiretapping and interception. Instead, Sikakani found as a general rule, it was accepted that the unit did not have the required equipment to carry out such electronic surveillance or interception. So, Ms. Mvuyana, if I look at the court judgment and having looked at the documents in the Rule 53 record, it doesn't appear that on any of the information that was before the public protector as found by the court, could those conclusions be borne out by what was put into the what served before the public protector for purposes of the report?
I cannot comment on that since you don't feel that the evidence or the double hearsay evidence is evidenced. So what do I do? Then I say there, because you've made the conclusion.
No, I haven't made the conclusion. I've said to you, I've asked you, have you done any independent investigation?
Yes.
And you indicated to me that you hadn't done any independent investigation. You relied on Maniki, Lombard, etc. And so I asked the question, on the one hand, you had this unverified information. You have powers of subpoena. You have powers to obtain very wide powers. And on the other hand, you have affidavits from Gordhan, Pillay, Magashula. You don't exercise the powers as the public protector, and you accept this uncorroborated evidence to make findings against them. And I mean uncorroborated in the sense that if you put evidence forward, you must either have interviewed the person under affidavit, as you do when you summon Mr. Pillay and Mr. Gordhan to the offices, or at the very least you have affidavits done under oath, but the public protector had none. Would you agree?
From Van Rensburg,
Yes.
Duval and Lombard.
Yeah.
I agree.
So when you balance it, on the one hand, you have evidence, and on the other hand, you have documentation and information that's been put up without any verification. And so the story, let me not say the story, but it is then said, and again, it's not coming from me, I'm trying to show you where it comes from, that this was such an imbalance in what was before her to have come to the conclusion she did. She must have been informed by bias, if I'm taking it to the conclusion of which it's reached.
You'll have to be more clear. So you're saying that what is said in the judgment and what is contained in the report is where the allegation of bias comes from.
Yeah, in 178, Mr. Pillay contends that the public protector relied on fundamentally flawed and discredited reports of others, applied a process of irrational reasoning and flawed logic, showing a clear pattern of bias in doing so. That's the wording of the judgment, not mine. To do
Okay.
that. I'm wanting to engage with you on it without it being attributed to me in any way.
Noted.
And I'm not for a moment doing that. And that is what informed on the affidavits before the court, the findings that the court comes to about bias in respect of the part of the public protector in doing that.
Okay. Yeah, I guess I agree if you say that the judgment, yeah, okay.
Right. And it stems from a closing of a mind to the evidence that was put before her. And that's why it might seem on the face of it that this issue about whether Mr. van Lochenberg was found or not becomes far more relevant in the greater scheme of the question of bias. Do you understand what I'm
Yes, I
Thank
understand
you.
what you're saying.
to do that? Now, if we shift off that for a moment, right? You did this exercise of showing us between an investigator, senior investigator, chief investigator, executive manager, COO, and public protector. Now, if I take you to 185.45 of the documents that came from the CEO's office. 185.45. Oh, 189, sorry, Chip. Right? We had investigators tell us while she's trying to find it as a general proposition, you have structures within the public protector's office that is aimed at improving on the quality of work that emanates from it. So when you do reports and when you do section 7(9)s, you present to think tank, or you present to task force, or you present to, I can't keep them straight chronologically as to how, but let's call them some sort of a structure which is aimed at improving the final product. Would that be a
Yes, that's
fair
correct.
assessment to say? Right. I have not come across one document in everything that has been provided to me by Mr. Matabogel, in the documents that has been forwarded to me, that shows that an EM or a COO had input or made comments or improved on the section 7(9) notice or the report in respect of the SARS unit? And I'd like your comment on it, because what I do find is I see it goes from you to Mr. Matabogo straight to the PP.
Yes, that is true. At some stage, I believe there was no acting COO, or the one that had just arrived was fairly new. But ultimately that was a decision of the public protector.
So during this period, and we had evidence to this effect, one of the answers given to us was that it was Miss Mohaladi, but that she had been suspended. Do you recall that? There was a-
Yes, I do recall, but I think I gave you that answer actually. If not, but I did check. Ms. Mukhaladi was only suspended in October. So she would have still been the EM for GGI during the time of the investigation.
In fact, she was appointed on the 1st of November 2018. And the last involvement I see her as having is in the correspondence on the 20th of February that goes out to the Minister of Safety and State Security.
It's,
Right.
yeah, it's possible.
Did you present your report in any forum which included the chief investigator or the EM in any way?
In a forum,
Yeah, like, you know, these structures.
think tank.
Yeah.
No.
And there was also no involvement of the COO who was appointed on the 1st of February 2019. Ms. Pasani Baloy was there for 6 months.
And okay, we've established there was no think tank. I'm not even sure if think tank was actually functioning at that time at all with all reports. I'm not sure. To Miss Baloy, to actually go to her and present, or if the document, if she saw the document.
You see, and it's not a trick question. You have a system in the public protector's office that
Yes.
reports get circulated
Yes,
and comments made on reports that then
Yes.
comes back to the investigator, who then incorporates all the comments it's made, and it goes up. And when everybody's happy, then a draft goes to the public protector, or it's given to Mr. Kabinda to pass on. That seems to be the ordinary course. Would you agree with that?
yes.
That does not occur in the SARS unit report.
Yes, I sent to Mr. Mataboge, so I don't know who he could have shared with, but I never received comments from Ms. Mokhaladi or Ms. Boloy on those documents.
So the only changes that could have been made to the report was either made by Mr. Mataboge or the public protector.
Correct. Oh, there's also quality assurance. Sorry, there's that structure that is in the COO's office.
You see, even on quality assurance, I think sometimes even on the Busasa matter, for example, there was a very similar reporting line. Mr. Satoli comes in to look at the report, but I don't even find anything. I'm not saying, I can't say to you unequivocally that it didn't happen. I'm asking you. I have not seen any input into the SARS unit report from Mr. Satoli or any other person on quality assurance. And I'm asking you whether you had received any feedback from anybody.
I'll have to check, because like I'm saying, from Mr. Matabuche, it would have had to go to legal services or quality assurance. Quality assurance, I recall that there were some emails sent between myself and the investigator responsible for that unit. The document, I'm not sure why it would not have been attached to the email, or if the inputs were made verbally. That's
Well,
also possible.
Yeah, you want to throw your last questions and then
Not
go
this
through
one,
lunch.
should we do
Yeah,
that? I just
Okay.
need to take you so that I don't misrepresent something. I just want to check a reference. It's 189.16. And it's 4365. I may have found a bit of quality assurance. I'm just not sure if it's Pusasa or SARS unit. Let's
Okay.
just, Sepo, just check it. 4365, item 189.16. Go down. I think this is a hint that we should just adjourn for lunch. We can just, I'll check it, and if it's applicable, I'll put it up. Go down. Go down. Go down. Just check.
Is that what you're looking for, Advocate Bauer?
So if we go to the bottom, right to the bottom of the document, right? The Pillay matter is the Pillay pensions matter. You were not involved in the Pillay pensions matter, correct?
Correct.
Right, right, and then Mr. Satoli says, and the date is also wrong because your report would only have been available at the end of June, beginning of July. It's not May. Am I correct?
Yes.
Right. So this is a QA for the, okay. This could be the 7-9 notices that's being referred to. Would that,
It's possible, it's just, there's no subject matter.
it says PG on the top, if you look.
PG is PG.
But you wouldn't be
Okay, it's
quality
here.
assuring a report
Can
at
you
this
go to
stage.
this report?
I think it's the Pillay matter. Mvuyana, if you go up,
Yeah, no, we wouldn't have remedial action at this stage.
yeah, that's the Pillay matter comes out, I think, around mid-May or that part of end of May. Yeah. Okay. So that's the only quality assurance during this period that I've come across to do that.
Okay, but yes, so Rodney, me, Mr. Rubenheimer, Mr. Stoll, I guess you don't have the email with the other QAs, but it's fine. The QA at some point did touch or read the report and made inputs. I don't know how you did not get that information.
Well, if you chair, if just 1 minute, because it'd be good to just finish this. If you look at the 189.45 documentation that is provided in the response received, and maybe we don't even need to go there because you have it in the response received, you yourself don't provide us with anything. We ask for the name of the EM who supervise investigations and quality assurance in respect of the Pusasa matter, and the answer was no. And in respect of the other matter, we have no information of any involvement of anybody in respect of the SARS unit matter.
Can we go down? Thank you.
Chair, shall we give Ms. Mvuyana a break?
I've long wanted to do that, so we're waiting for you. We'll have a lunch break, colleagues, and be back at 10 to 2. Thank you for the next 45 minutes.
Recording stopped.
We resume with our work and with Advocate Bauer and Ms. Mvuyana. Over to you, Advocate Bauer.
Um, we were told we can just pick it up on the last subject about the COO involvement. Mr. Mataboga suggested to the committee that the reason for the smaller investigation team was to avoid leaks. Were you involved in reports where the EM or the COO of the unit was said to be leaking documents of any kind?
No.
The effect of the system of reporting from the investigator upwards by knocking out a few of the rings or stages. The consequence of that is that the only place you then get guidance on how the investigation should go is then your immediate senior investigator, your chief investigator, and the public protector.
Yes, if that was done.
Then, were you involved in the preparation of the 7-9 in the Pusasa investigation?
No.
Is that Mr. Njabulo?
Njabulo is quality assurer. I don't believe he was involved in the investigation.
Okay. Okay, so it seems, and this is, so we've gone through the issue of the equipment that I showed you, and it seems as if you going to be looking at a determination on the lawfulness of the unit. I want to put the proposition to you. And I was thinking about it. You would have to look at what those units' operations would be in the period in which it operated. What activities occurred during those operations and its outcomes, and which unit members participated in those activities, and what laws or powers had been contravened when those operations took place. I want to put the proposition to you that if you don't do that, you can't come to a conclusion as to whether the operations are lawful or not.
Yes, correct. Excuse me.
Right. Then I want to take it, and Advocate Mpho, for the reference was 192, page 6072 for the affidavit of Mr. Lebelo. Shepo, can you go there, please? 190.2, 6072. Emalia. You get an email from the public protector that just says find attached with the document to it and no further details. You see that?
Yes, I see it. I don't see my name.
Yeah, ignore the date above. That's just a printing date. The date that you get this email is the 7th of December.
She says she doesn't see her name on the
Oh,
email.
sorry. Sorry.
Yep.
Yes, it goes to Ms. Mogaladi and Mr. Mataboge. Let me go down. What's attached to the email is a supplementary affidavit. Go down. That was submitted to Judge Nugent. Are you provided with a copy of it?
Sorry, I don't recall this affidavit. Yeah, I'll
Ye-
just stop there because there's other issues.
No, let's stop there, but you didn't get this affidavit.
Yeah, as far as I can recall, yeah,
We know from the information provided to the evidence leaders, there was a meeting on the 11th of December with Mr. Lebelo. Were you in attendance on that meeting?
yes.
Okay, thank you. Right, now I want to take you to 5979. It's 190.1, sorry. Five nine seven nine. Right, you'll recall that Advocate Mpofu asked you about this email. Will the last go up to the top of the email? It's not tea time yet. This is sent on the 8th of November. This is also not sent to you.
Yes.
Is this given to you?
It could have been, we were printing a lot at this time. So Mr. Matabuche would have printed it. If it relates to any investigation that I was conducting. So I'm not involved in the 2001 investigation, if there is an investigation that was conducted.
Right. Mr. Mataboge's evidence was he got it from the public protector for purposes of noting. You
Okay.
suggested yesterday that it came from a complainant. How do you know that?
No, I was asked to comment on the style, I believe. And is this the style of the public protector? Because I cannot confirm that it came from a complainant. There's no, it says from Advocate Mkweba.
And was it was put to you that there was no name on the top of the email addressed to anybody?
Yes, at the beginning of the email, dear public protector, or dear Bianca, or dear Rodney.
But that's not uncommon for the public protector because I've seen several emails where she gives a range of instructions. And it's not addressed to anybody in particular.
To the team.
Yeah, even to Rodney. I mean, the previous email, which we've just looked at, she just forwards it. There's nothing, there's no dear whatever on it.
Okay.
But you have no personal knowledge about this.
I don't recall this email. Like I say, it probably would have been shared if it contains any investigation that I was involved in.
Yes, but the previous email had an affidavit that wasn't shared in respect of an investigation that you were involved with.
Yes.
Let's go to this. Anonymous complainant that comes in, scared whistleblower. Either all the documentation and emails wasn't discovered, but I got lost somewhere along the line. If you go to, you get this complaint in, you write to him and you say you want a meeting in order to do that, right? He then sends you an email back and he says to you, I can come in December and we can have a meeting. And I think that's emails at 5:93. I don't think you recall the exchange?
Yes, can you please screen it those, because I want to see the dates.
Okay. Yeah, it's 5:930. Right? It tells you on the 22nd of October, I'm in South Africa in December. Can we schedule an appointment then? This is even before Floyd Shavambo's complaint lands in November,
Yes,
and before it's allocated to you. You've already
Yes.
got this one allocated. Do you
yes,
recall?
correct.
I don't see you responding to this email.
I did not.
So you didn't set up a meeting with the complainant for December.
No, unfortunately, I remember this time. On the 25th, I was on leave. I was even on leave, I believe from Monday, on this Monday. And did not come back into the office. I was on leave for about 2 weeks. So when I arrived back, I have a allocated file then from Mr. Shivambu. So no, the meeting was not set up.
So the next email I find related to this, so Scared Whistleblower continues to communicate with you and he sends you odd emails, because I see he sends you stuff periodically on.
I remember from the evidence I was sent to by Ms. Fatima that I think he communicated in April of 2019. Yeah.
So if we go to 5:930. This is when Minister Gordhan says to you that says to the public protector that he wants to interview the complainants. And the PP then responds at 5:930. You're not included in this email, but I just, and this is where I get lost a little bit. The PP then responds, I see the request interviewing witnesses and want 6-9 reasons. Just to make a point, can you see this email is also not addressed to anybody?
Oh, yes, noted.
Prepare a response while finalizing the report. We cannot reveal identity of US-based anonymous because we do not know. How did you know he was US-based?
Does he not say in his email?
No,
Can we go back to the email?
sure.
He does not reside in SA.
He says
I'm
it
not
doesn't-
sure then how PP would
Ah.
know that. Let's just double check if it doesn't say he's in the States. Could we spell? Okay, then I'm not sure either. It's possible that PP could have heard it from us. I'm not sure.
If you go down to the original message, if you go to the original complaint, there's no mention on the original complaint that is based in the US either.
Either, ne? Yeah, no, I agree. It's not mentioned. And we can go back to PP.
So I just raised that with you. If you go down, you're not included in this, so let me not waste your time. Right. There is a number of other information like the gene Ravel information that is also referred to. In the report, you recall that relates to the to evidence of illegal surveillance that was provided to you. If we see from the judgment, which is probably the quickest way to pick it up, Um, no. Okay, then let me move on. I can't find the reference quickly. Wasn't, Mr. Shavambu then tells you if you see 190.2 at 6070 Sepo. Right? He says that what 6070 190.2, right? He sends you an email and he tells you that he has evidence that you need in relation to the complaint, and he can refer the public protector to other people who will verify the information. Do you ever follow up with these other people?
Can I see the email, please?
Okay, down. He sends go up. 22nd, go up. Down it, there's it. I will be able to bring about the evidence that will be needed in relation to the complaint. Also be able to refer the public protector to other people who will verify all the information. That it be expeditiously managed, because we believe there continues to be existence of unlawful intelligence services which we complained about at 6071. Right? Did you interview any people following up on this? Did he provide you with that information?
I believe so. We'd have to go to the notes of the meeting. Do you have them? I know I lost my notebook, but I think Mr. Matabofe would have provided you with his notes.
You want the notes of the meeting with Mr. Shavambo?
Yes, I'm just trying to recall which names did he provide. But as we've already established, no one was interviewed except for the whistleblower, which we've kind of exposed now.
Yeah. All right. I'm not sure I've got Rodney's notes at 189.46. You're talking about the meeting with Mr. Shavambo himself?
Yes. Who does that email come from? Is it not Mr. Shivambu?
Yeah, it does.
Yeah.
Yeah. So the meeting notes I've got is this is the meeting at which he tells you about the 2014 secret report.
I believe so.
Yeah. If you go down, Shepherd. It's 4986. I'm not sure what you my question was whether you followed up with any other witnesses. Oh no, don't go down. 4988. In fact, there is one name on here. Actually, yes, let's go down. 4988, go down. So he provides you with Mr. Labello's details. You see that?
Yes.
Right. And that seems to be the only name that he gives you.
It seems so.
Right. Actually, if you go to 4989, He also gives you other names. On the next page, we just go further on. Was it pursuant to this that, did you contact Mr. Lebelo or did he contact you?
I believe he contacted us.
Okay.
Or requested the meeting.
Right. Now, if we go on from there, we come to the subpoenas that were issued. You drafted the subpoenas and you supplied to Mr. Mataboge. If you go to page 190.5 at 7358, right?
Yes.
You do a memo, correct?
Yes.
And 190.5, 7358. And in this memo, you ask the PP to approve and sign off on the subpoenas, correct?
Correct.
Right. By the time the PP gets the memo, she would have known it's coming because she would have expected you to be issuing these subpoenas. You're doing it on her instructions, aren't you?
Sorry?
Do you do this on her instructions or do you do it or is it your doing that you're issuing that you're asking for these subpoenas to be issued?
In this investigation or in general?
In this investigation?
No, I wouldn't say an instruction per se. Once the documents and evidence were analyzed, we obviously identified who we needed to get more information from. So those people were identified and we then drafted the subpoenas, obviously with the approval of the PP in terms of when you provide an update to say, where are you in the investigation? You then say, we just need to subpoena, and then she says, okay, subpoena. It's not really an
7358.
instruction.
You see, the reason why I ask you the question about whether this was just a formality and she basically told you to do it is
Okay.
the absence of any reasons in the memo as to why you required a subpoena. If you go down, this goes through the COO and to the PP in April. You set out the background of the complaints. And then on the next page, approve and sign the subpoena.
Okay.
I would have expected a subpoena is a drastic remedy that you would have had to motivate as to why a subpoena would have had to be issued.
Okay.
And the absence of a motivation makes one think that she knew what was going on. She was waiting for it to come and it was going to happen. You didn't need to do much more than dot the I's and cross the T's.
I don't know if you want me to agree or disagree with you.
Now, if I'm completely wrong and you tell me, if you can't remember, tell me. If you're not sure, tell me. I don't want you, I'm not asking you to fashion a response by agreeing with me or
No,
please.
I won't comment on your assumption. But like I said, we give updates to the PP either in a meeting or if she calls Rodney and to ask, okay, how far are we with this investigation? Rodney will then give an update. Then it will be discussed. Either Rodney will tell her the next step or she can also suggest the next step. And then the next step is then done and the memo is prepared. I don't know. It's not, I'd say written in stone that we must provide a reason in the memo. It's the writing style of the particular person, or if there's an update already given. Yes, she may have known that the subpoenas were coming though. Yeah.
It's just that in ordinary parlance, if you were taken on review for the issuing of your subpoena, And this was the supporting documentation. And there was no basis for the subpoena being issued. It would look very strange. Do you agree? That no reason is furnished for the issuing of the subpoena in the guiding memorandum that recommends that you approve. Where is the reason for the recommendation?
The reason for
The recommendation that she approves and signs the subpoena.
the investigation is the reason.
But you're an office that applies the 3-strike rule.
Yes, in most instances.
Yes. And so you would have to show that I've hit my 3rd strike before I can get the subpoena.
Yes, specifically maybe for Mr. Pillay and Van Locherenberg, but we would already started communication with Mr. Gordon, and there was a lot of toing and froing with him, and the decision was then taken with, okay, let's just subpoena an affidavit not to appear.
Not to appear?
I don't believe it was to appear
Ah.
before the public protector.
And this is signed in April of 2019. So you're
Yeah,
saying the
think so.
toing and froing with Minister Gordon occurred before this?
Yes, we remember we had written to him in December. Not toing and froing in a bad way. It's just a lot of, okay, an extension, and then there were issues raised in between that legal services would have dealt with and the PP directly. So that is what was happening at this stage.
And what you are referring to is Mr. Gordon saying these allegations have happened more than 10 years ago. Under section 7(9), this falls outside of your jurisdiction. If you're going to be investigating this, provide me with special circumstances.
And not only that, but it includes that.
Includes,
Yes.
right. Now, if we come to this vexing Mr. Van Locherenberg subpoena, the report says his last known address. Now, on what basis was it ascertained that that was the last known address?
The response I gave yesterday, and which is the truth, is that we contacted our whistleblower who had offered to provide us with information. He checked the records at his former employer, which was SARS, and provided that address. And there was no cell phone number, email address for Mr. Van Locherenberg in his personnel file, allegedly, as I was not the one who spoke to the source. We then drafted and put the address on the subpoena and attempted to serve it.
Just stop there for a moment. You say you didn't speak to him, and Mr. Matapoga says he didn't speak to him.
Maybe he doesn't recall.
So
Because I couldn't call, due to protocol reasons, I was not
if you
going
look
to
at,
call
if
the
you
guy.
look at the, sorry, I interrupted you. Speak.
No, due to protocol reasons. Yeah, it was tasked, he was tasked with that.
In 185.45 in the documentation that you and he provided to us, the explanation they provided was either the supervisor or the PP called.
Yes,
Did you write that?
yes. Advocate Bauer, this happened in 2020. It's now 2023. The response that you're talking about was done in 2022. I can't recall things that happened 2 years ago. I don't know, a call about 2 years ago. So it was either one of the two, because I did not.
I'm happy, Ms. Mvuyana. I can't remember what happened last week, so
Thank you.
so that isn't the issue. The only reason I'm raising it is because there's one thing written and there's
Mhm.
another thing said in oral evidence. So I'm trying to work out where it lies. If you're not
Okay.
entirely sure which one of the two it is, then that's what it is. I'm not doing that. Now, after Mr. Linde came back with the story, after Mr. Linde's story is, I went to this house, I found a man. I don't know if you've read his affidavit, Ms. Mvuyana.
I read the affidavit, yes.
I don't necessarily want to go there because I think he came back and he wasn't able to serve it. And he came back in the belief that he's not going to find this person. And he was able to ascertain that the person was appearing before court. And he indicated that he relayed that to Mr. Mataboge. He did not indicate to us that he relayed this to you. He said he reported this to Mr. Mataboge.
Okay.
But you were aware that they were appearing in court.
Yes, Mr. Linda did also tell me because our offices were very close to each other, so.
So maybe he
Well,
didn't remember that he
yeah.
told you. Nothing turns of that. So you knew where Mr. Lochenberg could be found. He could be found on his court appearance.
On whatever date he was appearing, yes.
Yes. And you could have called the National Prosecuting Authority to see whether the person they were prosecuting, whether they could locate him.
Yes, we could have.
There's lots of things you could have done.
Yes, there's a lot of things we could have
And
done.
with hindsight, none of them were done.
Yes, with hindsight, none of them were done.
And the point is, the public protector didn't tell you to do anything.
She also suggested serving and during a court for the appearance. But when we spoke about it with Mr. Matabuke, and knowing that we usually only serve at a person's address, we've never served a person on the street or in court while they're appearing for another matter.
And you say you went to Google,
Mhm.
right? Now, in your statement, you offer up this information about how his name is spelled. You say it had subsequently come to your attention that Mr. van Lochenberg sometimes deliberately misspelled his surname.
Yes, yeah, I think he even states it in the Sikalkane report, if I'm not mistaken, or KPMG when they're discussing the allegations about the alleged girlfriend.
Right.
Mm.
But you didn't misspell his name.
I spelled it the way I know how to spell it. Then from the documents that we had received, it changes. Sometimes another person will put the G or the R before the E or something like that. So I spelled it and he did pop up as an author. So obviously I spelled it right.
Yes, but if I don't know why the conclusion gets made, this too might have made efforts to find him more difficult than usual. Because it doesn't seem as if there were any efforts made. In your affidavit, that's what you say.
Chair. I'm sorry, Chair. Yeah, maybe it's me. Maybe it's the afternoon. I thought the witness just said she did exactly that, and his name popped up as an author of books or whatever. So I don't know now how it can be put that she didn't do it.
Yes, she did. Oh, go ahead, Advocate Bao.
So
Sorry?
I missed that. My apologies, Ms. Mvuyana. You said you punched his name into the Google and his name propped up as an author.
Yes, that he'd recently written a book at the time, or had written a book some time ago. And then there was another story. There was a lot of stories.
There was a lot of
Yeah.
stories. And you know that if we've just done the exercise during the lunch adjournment, that if you put in the wrong spelling of the name, Johan van Lochenberg, Google
Mhm.
actually self-corrects it for you to Van Logrenberg.
When you do it, when?
Oh, Sep,
Today.
Sep was just done it.
Yes, that's today. In 2019 was Sepo there.
So it couldn't happen in 2019.
So you never know.
Chair, Google improves every year. The app.
But the point is,
Oh, sorry.
you didn't make that mistake.
No, I did not.
So how do you reach the conclusion that the wrong spelling would have made efforts to find it more difficult than usual?
It might have, if I had, I mean, there's other search engines that can be used. But that was not done, like I've explained as well.
Okay, so the might be is actually irrelevant.
Sorry?
It's actually irrelevant. I'm trying to work out what's the value of the sentence.
That Mr. Van Logrenberg was difficult to find.
No, this too, the misspelling of his name, this too might have made some efforts to find him more difficult than usual.
Yes, and as a passing remark from his evidence as well, or
Now-
evidence that were in other reports. Okay, let me just stop there.
Now, I'm sorry, don't let me,
No, I'm
I
done.
know it was suggested by Advocate Mpofu to him when he gave evidence.
Okay,
Advocate Mpofu had made the same proposition to him. I was just trying to work out on what basis you reached that conclusion in your affidavit. But I take the point that what we did in 2023 may have been different in 2019.
possibly.
You also then said that the public protector played no part in tracing of witnesses or serving documents. The actual physical part of it, she doesn't do.
No,
But she does guide it. She does guide the signing of the subpoena, and
Yes.
she can give the instructions that any
Yes.
one of the mechanisms of being able to find him could be pursued.
the mechanisms that are within the powers of the PP.
Yes.
Yes, she can give an instruction. She can even provide telephone numbers if she knows the person.
Yes. And once she had received the letter from Weber Wenzel, she would have known who his attorneys were.
Yes, of course, she received it. She knew who
Yes.
they were representing if she read the letter.
Okay. And if you look at page 590.1, page 5910, it's the same 590.1, 5910. Right? This is the 10th of June.
Yes,
And this is an email again forwarded this time to both you and Mr. Mataboge,
all right.
which deals with the buying of illegal spying equipment by Praveen and Pillay. And it tells you all about the spying equipment. And at the end of this email is a person's name, which I don't necessarily want to go up. Right?
Yes,
And there's a whole lot of equipment detailed.
Oh, okay. Sorry, I must have missed something. You said you were not going to show the author. Okay, thank you. Thank you, Chair. Sorry.
Okay. Go up to the top. This is information about all kinds of equipment that's provided Did you verify the contents of this email at all? Did it impact on the investigation?
Some did, and some did not. Some we did not follow up with. Some didn't relate to our investigation.
So at the 10th June 2019, you were still busy with your investigation.
We were still receiving information from different complainants, different people.
And the letter from Weber Bensel comes on the 14th, 4 days after this. So if you had known who Mr. Van Lochenberg's attorneys were on the 14th of June,
Is it
Then-
not the, I was told it was the 4th of July.
no, sorry,
It was-
the letter, the letter comes, let me just be exact. 51. The letter is at 5/9/11. Just check if we there. 14th of June. 15th of June. There we go. 15th of June. The letter is provided, the demand. If you go further down on Saturday, it's sent by the PA. I think the actual letter could be dated the 14th. When
Oh,
Weber
okay.
Bensel sends it on the
Noted.
Friday.
noted.
This is communication that comes up on the Saturday. So the only point I'm trying to point out to you is that it was possible to obtain the details of Mr. Van Lochenberg whilst the investigation was still ongoing.
Yes, if he sent an email on the 15th of June, then it was possible, but now 7/9 had already been issued here.
Yes,
I believe we'd even received some responses to the section 7/9s. If I remember correctly, but yes, you're correct, it could have been.
no, because
It,
if you're getting in all kinds of other evidence that you're having regard to, even after the 7/9s went out,
information.
Information.
Yes,
then nothing stops you from having regard to other information as well.
yes, we definitely, even the email, we went through it. And I don't know if you can confirm if any of the information in the email above from the supposed other person was now included in the final report, because this would have been received after the section 7/9.
You see, Ms. Mvuyana, it doesn't have to be included in the final report. The only point I'm trying to make is you had regard to the information. You may have accepted it, you may have rejected it. You may have found that whatever evidence or information came from Mr. Van Lochenberg was absolutely useless to your report.
Yes, but if the reason why I'm saying that is because if this information would have been in the final report and not in the section 7/9, or we'd have to issue a supplementary section 7/9, because the people who received the initial 7/9 would not have had this information.
But that's form over substance, isn't it? It's a procedure that you would have to do.
Yes,
You would make sure that they get proper Audi by giving them proper Audi of all the relevant material. It can
yes.
never be an impediment to the process.
No, it can be done depending on the severity of the information, but like I'm saying, that we'd have to compare the two to see if there was a break in procedure.
I haven't done the exercise, to be honest, whether the contents of this email
Mm,
found its way into the final report.
Okay.
I'll certainly have a look at it and maybe ask the PP when she comes and gives evidence about it.
Okay.
Right. Now, on the We have gone through some of the reports and I don't want to belabor the point. I think the point was made this morning that there was no independent investigation conducted of the contents of the report and how you had gone through it in conducting the investigation with reference to one of the headings. In fact, we've dealt with two of the 6 complaints in that regard, and I put the proposition to you in respect of one other. Now, if it is so that if the proposition I put to you this morning, that the remedy that was imposed into the report does amount to implicating Mr. van Lochenberg in respect of the findings, then there can be no doubt that he would have had to receive a 7-9. You agree?
I did not respond to that question. You didn't put it like that.
No, I'm putting it to you now. I didn't ask you the question this morning. I showed you where the findings were and where the remedy was. And I'm putting to you, if the findings implicated Mr. van Lochenberg and you were going to have a issue a remedy that impacted upon him, he would have been entitled to a Section 7-9 notice.
Ideally, so yes. But I believe that's not how you put the question initially. And Advocate Nkosi clarified, sorry, not Nkosi, Mpofu, clarified that, or you even also clarified that the allegation of the conspiracy in relation to the OIGI is totally out of my purview. So are you trying to get it back into my purview?
No, not at all. I'm putting a general proposition. If you're implicated, you must get a 7-9.
If you're implicated in the
The findings of the
findings,
report, you must
and
get the 7-9.
if you will take action, so implement the remedial action, you get the Section 7-9. That's why it's directed to the Minister of State Security. I believe in that portion. So the implementer of the remedial action and the person whose findings are made against gets Section 7-9.
Okay.
That has changed, of course, now.
Yeah.
At that time.
So let's look at it. You refer to the Sringrove and Kumalo opinion. And you would agree that this opinion is not binding on the public protector.
Correct.
You refer to the Sikakane report. And similarly, it's also not binding on the PP.
When you say binding, what do you mean?
Well, I mean what you meant when you said in 185.45 that the Nugent report was not binding on the PP. I was trying to work out if you meant she wasn't obliged to follow what was contained in the Nugent report.
The findings, to stick to the findings.
Let's look at 145.85. 189.45. Sorry, somebody's on the ball behind me. Go down. Go. Here we go. 3.10. Information why Nugent report not considered or dealt with. No information, verbal discussion with people and investigation team. The reason was that the findings of the Nugent report were not binding and could not be relied on. My question is, none of the other reports or opinions was any different to the Nugent one?
Yes.
So why have a discussion specifically about the Nugent report?
We had a discussion about most of the reports that were submitted to us. in the report? You mean a verbal discussion?
To leave it out. I understood that that was the answer, that you had a verb. The question is, provide us information why Nugent's report was not considered or dealt with. And the answer is, we have no information. It was a verbal discussion with PP and the investigation team.
I think the no information comes from our understanding of the question, which would be that you wanted notes. So we don't have notes of that meeting.
Okay. And you can't recall what was the reason for leaving it out? Or can you?
For leaving the findings
Well,
of the Nugent Commission.
you summarize, or the PP summarizes in the final report, a summary of Tringo, summary of Sikakani, a summary of KPMG, and the Nugent report is the one that the implicated parties specifically refer to the PP. And the reference in the report to that is a reference to them, and I think there's one other reference, but it's not summarized or dealt with what is the findings. By the way, did you have one report or two reports
Where
for the Nugent report?
was we had the interim and the final.
Chair,
Advocate Mbofu?
no, Chair. Yes, no, I just want to say, I think what's been put to the witness now is factually incorrect. Because not only is the Nugent report referred to in the report, I think it's probably the only one that's quoted verbatim. So to say it was not referred to in the report is not true.
Sorry,
Thank you. Advocate
Advocate
Bauer?
Mpofu, I went to the quoting of it verbatim. It comes out of what SARS had told the public protector section. When I talk about this, I'm referring to where you go heading of the report, and there isn't one for the Nugent report. And I understand the witness understands my question, or let me be clear, not assume
Oh,
she understands it.
Okay, no, sorry, Chair. Yeah, well, the witness might understand your question, but she's not the only one who's going to read the record
No,
from now on. And I agree, for the record, I agree with what you're saying, that the other reports, there are headings like the Cruan report or whatever. But what you cannot say is that it is not referred to when it is referred to and quoted.
Ms. Mvuyana, the issue is you don't specifically deal with the Nugent report in the same manner you deal with the other reports. Let me put the question fairly.
No, the terms of reference for the Nugent report were different from all other reports. Nugent dealt with the rogue unit issue in passing. And that's why we also just kept it and only confirmed that what SARS had sent us was an actual quotation of the report. And that was it.
Okay. And the Sikakani report was also not initially mandated to look at the rogue unit. They were mandated to look at allegations in respect of Mr. van Lochenberg.
That's
They
true.
then midway through dealt with this in a different manner.
Mm.
And the KPMG report, you were aware at the time that KPMG had essentially indicated that they were retracting their report, and in fact, I think they went as far as saying publicly that they were going to pay SARS back.
When did they retract?
They retracted this report in 18. It's 110 of the judgment. And you see that 16 September 2017, long before the report was delivered, KPMG had disavowed its own report and its conclusions regarding the lawfulness of the unit. They tendered an apology for its governance lapse.
Yeah, I believe so. I think so.
Chair,
Yes, Reverend Mpofu.
sorry, Chair, yeah, no, I think it's not fair to put a question like that. Because yesterday I indicated that the KPMG so-called retraction was exaggerated. So it might be maybe appropriate then to put it up to the witness, the actual terms of the retraction. Because our version is that it was not a holus bolus retraction of the entire report.
Over to you, Advocate Bao.
I'm sorry, I was hoping that you do. I know I don't have immediately, but I can find it. Who's Advocate Kodan? Yeah. No, I do. I'll find it. Sorry, I'll find it before you finish.
Switch on your mic.
Let me tell you what the judgment. Let's not, we'll get to the actual terms of the retraction. Were you aware that there was a retraction by KPMG?
Not necessarily a retraction, at the beginning stages of the investigation. Of course, we did find out, during the investigation that it had been. But yeah, it was all over the news.
Right. And that and there's no mention in the SARS report in respect thereof.
I can't be sure about that.
Okay. We've already discussed the IOGI report. And then in respect of the statement in relation to the SARS advisory report chaired by Judge Kroon, he issued a media statement in which he said that they had not done any independent investigation and that they had relied on the Sikakane report. Do you recall that?
Yes, I do.
Did you find any member of that SARS advisory board coming out publicly and saying that Judge Kroon doesn't speak on behalf of the whole board?
No.
Um, Now, if we go to page 6408, which is 190.2. Yeah. If you go down to 27th June. Oh, no, go up, sorry. We now stop there. On the 4th of July, Advocate Nkubani tells you're not included in this email, but would it have been given to you?
Yes.
Okay, so go down, advocate. On the 4th of July, Advocate Mkubani is instructing you to put certain evidence into the report. Go down. Up, sorry.
Sorry, can I just check? If it's an instruction. Sorry, can you please point out to where she's making corrections? And saying, please intensify on the equipment, it must be premised on the Brasi investigation. I guess that's where the instruction comes in, must.
Yeah. For ease of reference, check the affidavit and the equipment. It aligns them very well. And more importantly, they were discovered by press and were part of the DC charges.
Okay.
You will also see in the affidavit we further instructed his office. Which affidavit is she referring to?
Can you point me to the line? You will also see in the
It's
affidavit.
referred to in the 5th line. It's
Okay.
referred to in the line where
I see,
Shepherd
I
was-
see.
you will see in the affidavit.
How to record. I'm not sure which affidavit this is.
Hold on. I just want to see because that's the end of the email. Okay, these go up. Sorry. And then he asks for a bit more time to clean up. And she tells you we issuing tomorrow, just go up.
Sorry. Okay, right, I
Alright.
see.
Go up. And he then says he's going to come and collect. Sometimes does she give you changes in hard copy
Yes.
corrections? Okay. All right. Right. Now, if we go to the 17th of May, 5899, I want to take you to the drafts of the 7 9s. Five, 8, 9, 9 would be. Yes. All right. Yep. This is on the 17th of May. And you come to the public protector's office in the boardroom and you must bring the records and the report. Do you see that?
Bianca with all the records and Jabulo with report.
Yes.
So maybe the English, either Jabulo had the report or I had the records or
Go down,
come
maybe.
with Jabulo. Maybe it could have meant. Okay.
Go down. Right. Okay. If you go to 5900.
Sorry, can we just go to the one that refers to Njabulo? Because I see the subject matters are different. Sometimes it's the Shivambu complaint and sometimes it's draft report on Minister Gordhan. Njabulo was dealing with the Mr. Pillay / pension fund issue, so I'm not sure. And then when he was an investigator with investigations, and then at some point he became a senior investigator within quality assurance. So
Could be the Pillay matter and you coming with the.
it
records in
could
the
be,
court.
unless, if we can just check if, when the PLA report was issued, so that we can obviously, disqualify it from being
Ye-
spoken about in these emails.
Give you a sec. 24th May,
So it's possible.
it's possible, right? So if you go to the 5/900, which is the next day. Go down, there's a letter received in May from from Minister Gordon's lawyer after Muntu sent him a letter. You're not, you are included in receiving the letter.
Mm.
And the instruction from the attorney after we're proceeding with the 7-9 as planned, as the affidavit as expected, is a denial which we can deal with in the narrative as issues of dispute. So you receive his 7-9, his response on the affidavit that you've requested him to be provided. And Mr. Matapogo says, well, we're proceeding with the 7-9 as planned, as the affidavit as expected. He is a denial which we can deal with in the narrative. Were you expecting Minister Gordon to just deny everything?
Of course not. I'm not sure what discussions would have been had pursuant to this email, but no, we were not expecting anything. We expect responses. Maybe Mr. Matabuche could have, and will, from experience, since he was also involved in other matters of Mr. Gojan, would have known that he will deny these allegations, or whichever allegations are being spoken about here, or 7-9, that's Shivambu file, okay.
Go back up. And the PP responds to him, you're not included, make sure rebut all what he says and the dates and lies. Wanted to assist, also check the file number we have opened about anonymous complaint to inform PP to investigate this coordinating response. That is a completely different matter, which is
Yeah,
a
that is totally.
different dispute.
Yeah.
You're not involved with that, so you're
Yeah.
not going there. Take a sigh of relief. Right? Right. Now the section 7-9 notice that went to Minister Gordon. You will see it at bundle F 189.7. 189.7, 3996. Okay. So there's a draft 7-9 in the process of being worked, and generally when it comes back from the PP type, then it's got yellow text. Is that, or when you send to her, you highlight it, it doesn't matter what color it is.
No, the highlight is Rodney. Rodney usually does the highlight. PP, I think, refers to the paragraphs, if I'm not mistaken.
Okay,
Maybe also highlights, but I know Mr. Matabuke is the founder of highlighting in yellow text.
so just go down. You should teach him track.
He doesn't want to do. It's too complicated to for him.
Okay, I want to go to paragraph 13.2.23. So you can go far down. I am sorry. I think I'm not sure what the page number is. Oh, it's not there. Okay. Go down. Uh, 189.189.7. Go to 14.2.25. You see, Ms. Mvuyana, in your very early section 7.9 report, go up. 14.2.25. Stop. All right. This is where it gets inserted into the draft that you make.
Yes, that's the email says the text in yellow is the
Yes.
inserted part.
In the preceding draft, which I can't lay my hands on, but I will for Advocate Mpofu's purposes. It's 13.2.23 and 13.24. It is pointed out that the IGI report could not be utilized. It was still waiting for the Minister of Safety and Security to declassify the said report. And that then gets changed in this version. There's a duplicate in numbers, but that's not here. To the reliably informed, but right. And if you go to 3996, which would be 14.2.26. Yeah. I am however unable to utilize the report or any part thereof, as I am still awaiting the Minister of State Security to declassify the said report. And that you've since requested the President's assistance to avail the declassified report. Do you see that?
Yes, I do.
All right. And we know that essentially in the correspondence, the PP had said that she was seeking to verify the allegations. Right. Now, in the report, let me jump to special circumstances for a moment. Take me to 5869 while we're there, Sepo. Yeah. Would be 190.1. Yep. Yep. If you go down, there is a letter that comes from Minister Godan in which he asks for, go down. It gets brought to the PP's attention, which is his initial response to the 7.9 or the 7.4 that's issued. I think it's the 7.9 that's issued, right? And then go up so that we can see the context. The issue a media statement, and it causes the Chief of Staff, right? I'm not making
Yes,
assumptions.
Chief, Chief of Staff.
Add the paragraphs on what was expected in the subpoena to come in person to ask for extension. That has not been done. They decided to send an email violating the provisions of the subpoena. Is it common? You issue a subpoena for somebody to provide an affidavit, and then if you want an extension on the subpoena, you must come and appear in person to get the extension on the subpoena.
I know yes, even with, besides an affidavit, if you've subpoenaed an affidavit, I know even in cases where we've subpoenaed, for an institute department to submit documents, or when we subpoena documents and they are unable to provide those documents, they have to come and request the permission in wider period.
So the suggestion that he was being singled out is not correct.
No, it has been done.
In this April, the PP then gives an instructions that the
Sorry, here, with the Minister Godan is the one who's requesting an extension. Okay, he is the one who requested an extension.
Yeah.
We're further investigating the minister. Okay,
if you look here, the special circumstances is provided by the PP. The special circumstances in this matter is the allegation that those surveillance equipment are still being used in this state to illegally tap people's phones and install cameras in key strategic places, and that the security companies in key government institutions are using such equipment. Were you aware of this information?
no. Is this not for the response to a letter, though? Because I'm not in the email, and especially if they were responding to either a media statement or a letter of attorneys, then I was not involved in this.
Now you were not involved in the email correspondence, but the
Yes.
trail follows. Maybe just Advocate Godan is seeking the special circumstances for
Yes.
purposes of investigating, and the
Yes.
PP is giving an instruction as to what those special circumstances.
Advocate Godan. There's no Advocate Godan.
are.
Just
I'm giving him promotion.
okay. I see, but he's not there yet.
So
Switch it on.
it's the process of promoting. It's not easy to be an advocate.
And it's not cadre employment. Right. You see, now I've lost my train of thought. Okay, let's go down. Let's go down and let's see if I can figure out what I was going up. Go down to 5870. Right. Go down. There is a statement issued by the Office of the Public Protector. And then there is a responding state. Okay. There's a-
Sorry, is this email now after
No.
the first email?
Go right down, Sipa, go to 572. Go up. Up. That's probably the starting point. There is a media statement issued on behalf of Minister Pravin Gordhan, where they place on record interactions with the Office of the Public Protector. Right? And that has got to do with this whole collusion issue, which I don't want to get into. So let's go down on this media statement. No? Yeah. Right. Stop. The last paragraph. We are yet to officially receive a response to the substantive matters raised in our letters of 16th April, which are primarily and germane to the request for an extension, as well as the follow-up letter of 22 April. Apart from the media statement the Public Protector issued today, no correspondence has been received by us from our office. Okay. Now the substantive matters raised in the letters of 16th April and the follow-up of 22 April. Tell us what the special circumstances are, inter alia with other stuff, as to why you're conducting this investigation. So now, if you go up.
Sorry, before you go up, please repeat what you've just stated. In between 16 April and 22 April.
Right.
This is a media statement issued by Mr. Gordhan.
That's correct. In
Okay.
response to a media statement issued by the Public Protector's Office.
Okay,
Right.
saying that they've not received correspondence.
All right, but go back up. I want to take you back to the email I was at. No, go earlier, man. Go to 5868, where we were earlier. Right? Go to the top of this. Stop, just stop by the one before that, the bottom of 5869. Yeah. Right? They bring this to the attention to the PP for comments and approval, right? And this is and then you go up. And then the PP gives her comments. And in her comment, she tells him what is the special circumstances in this matter. All right. You see that?
Yes, I do.
Right. Now we go down to the letter. Now go. Next page. Go. She does a final draft of the letter and the PP says, remove the yellow highlights. I've signed it. Let's go down. Should be dispatched. I've inputted the suggested text for PPs and causes inputs. Go further. And so there's the letter. Right, now let's get to the paragraph. Stop, first paragraph. Reference is made to the letters dated 16, 22nd and 23rd received from Mr. Godin's attorneys, right? So let's go down. Right, go down. In the number 2 is just the details of the complaint. So move on, number 2. Number 3 is the letters that is raised in the correspondence relating to 2 years and older. Right. Number 4, stop. With regard to paragraphs 2.1 and 2.2 of your letter, please be informed that the reasons for my acceptance and investigation of matters which arose more than 2 years from the occurrence of this incident due to special circumstances in terms of 6(9) of the Act. Please be informed that this is based on the available information from reliable sources that the surveillance equipment illegally acquired at astronomical costs is still being utilized to intercept communications between people by the unit which was not completely disbanded. So this is a matter of special interest as public funds were still being used for illegal purposes.
I see.
Were you aware of this?
Like I said, the yellow is Matabu. I don't, and I would never send this to the PP. I don't send things to her directly.
Okay. I understand that the yellow is Mr. Mataboge, but the substance of what is in the yellow is still being utilized to intercept communications. Did that emerge from your investigation?
Not from other evidence that we had. It might have been information that was passed by a source to the PP, but I never saw information or documents that show that it was still being used. The astronomical cost, yes. Yeah, but from a reliable source, so. Between people by the unit.
Okay, go
Yeah.
down, Sepo. You see, because if you look at the report and the explanation in the report for special circumstances, One of the criticisms which the court had, because it's only dealt with in paragraph 3.5 of the report, is that the generic reasons for special circumstances is cited and not any specific reason is given. Do you need me to take you there, or do you recall that?
Yes, I recall that.
Okay, so we can skip through that one. Right, we've done all that. Now we come to Mr. Pelle's matric certificate. Isn't there a regulatory body that you can check whether people have matric certificates?
There is.
Did you check?
No.
When Mr. Pelle was interviewed, was he asked for a copy of his matric certificate?
Which interview?
He was interviewed by the public protector. I think in the Pelle pension matter, or in the in the Pelle pension matter. You wouldn't know. Are you aware of the public protector ever directly asking Mr. Pelle for a copy of his matric certificate?
No.
And it was suggested that the reference in the report was simply an error.
Yes.
When was this error discovered?
After the report was issued, from when I discovered it, after checking the response from Mr. Gordon, double checking and checking the response of SARS. The reason why I would say it is an error is because maybe of a misinterpretation of the response received from SARS, which stated that Mr. Pillay didn't have any formal qualification. So formal qualification could also include a matric certificate.
But you were not part of the meeting which Mr. Pillay has with the public protector, where they actually discuss him receiving a matric certificate, which high school he went to, etc., etc.
Yes, I was not a part of that meeting.
And in fact, you were not part of the exchange which where Mr. Mataboge, and I'm going to take him through it in when he does come back. I'll put this to him, where he actually points out during the compilation of the report that the audio of the meeting with Mr. Gordon does not address the matric certificate either directly or indirectly.
At the meeting?
Yeah. Mr. Gordon doesn't deal with it, the issue of the matric certificate.
So when did Mr. Mataboge state that, or was he informing me that the
No,
recording
it
is?
didn't relate to you. Did he never tell you that the Gordon recording he had gone to check indicated that that it never raised the matric certificate?
I don't recall.
He says this to Mr. Mshlongo on the 28th of August 2019. Right. Now, we're getting there. Now we if we go to just want to take you through the drafts in the remedies. If you go to 189.53, I think we're almost done. Just need to check a couple things on your statement. It's 18953. Yeah. It's an earlier draft of the report. Right, which you sent to Mr. Mataboge, and I want to go to 5131. Right. 5131, yes. Paragraph 5 it has a different recommendation in respect of the IGI. You see that it says the report recommended. It's very similar to what was there before, and then go to 5200. Page 5200. Right, and you see the remedial action, go down to the Minister of State Security. It basically says, commission an investigation by the Inspector General of Intelligence on the current status of the unit for any continued crowdown, breaches of the Act by individuals or organizations, and take the necessary appropriate action as provided by the enabling legislation. And in respect of the Inspector General, conduct an investigation into the existence of the unit and verify its continued existence through an audit. So you'll see that the remedy in this version of the report differs from the remedy, that the remedial action that comes into the final report. Correct?
Yes, correct.
Right. Now, if you go to there is then a meeting that you have with her, and we have your meeting notes dealing with the remedy. And if we go to those meeting notes, I had it for Mr. Mataboge the other day, and he then said to me, it's not his handwriting. Let me just see if I can. Give me a second. Okay, I think it's 4939. Six 4939. 189.43. Is that your handwriting?
Yes,
Right.
sometimes
And
it changes.
Oh, I just wanted to understand that sometimes it changes.
It changes depending on the day.
the mood.
Yes,
On that day, it was yours,
yes.
right? So it's heads discussion of draft with PP. Right? And
It doesn't have a date.
no, I have it pegged to an email, which I'll take you into a while, which says it's roughly the 3rd of July. Let me
Okay.
take you through your note and then we'll go to the email and you can confirm with me whether I'm correct in that. If I go down, am I correct that she tells you on which paragraphs what changes to make
Yes, in this meeting.
at this meeting? So you write down your notes and then you go back to the report and you clean it up.
Yes, it's shorthand, so I'd have to,
Right.
yeah, summarize.
Right. So if we go down, you'll see on page 10, she talks about the National Intelligence Agency, now SSA. And then she tells you what to say there. Go further down. And she tells you to remove the Jean Revel dossier, even in the narrative.
Yes.
All right. So you had the dossier, but you removed it.
Yes.
Do you know why?
Is it not in the notes down there?
Go down.
Oh, I don't think it is. I can't recall why. I can't recall from my archives.
Okay. Go further down. Stop quickly. Go back up. She tells you that the finding of the OIGI report was that SARS had no mandate. And to do that at 2.3.3, go further down. Right. Down. It says Magashulu analyzed the response irrespective of the different name CBCU. Were you treating the CBCU and the SARS investigative unit as one unit?
Analyze the response. I'd have to go to Makashula's response to, yeah, the shorthand, irrespective of the different name, CBCU. Possibly, but I can't recall because it also speaks of text from Jaburu.
Go down. He may very well have been doing some quality assurance.
Yeah, probably, maybe.
And then we go down.
Because unless, yeah, there's a lot of possibilities.
Lots of possibilities.
Mm.
Go down. We come to the remedial action.
Notes, yes.
And it's here where you're told that the ministers SSA must implement the IOGI report within 90 days to ensure equipment is returned to SSA.
Yes, that's what the notes say.
So that's an
Yes.
instruction that you get from the PP.
It looks like, seems like correct, because it was amendments we were doing with her. So it would have been a discussion, and this is what a suggestion would have been.
And if you go up, and I was going to take you to 190, we might as well just finish the note for just there on top, take note of charges. We'll be filing the proceedings with interest based on the findings. So the charges were going on, go down. And then there's the response to section 7(9) bashing the PP, go down. And then it says JM in Cape Town, info received, SARS bugged the house in Cape Town. Journal call to take photos of alcohol issues, articles, include the drive. What was that referring to?
I don't recall even who JM is. Oh, JM stands for, okay, I recall. It's the story that I don't recall. But yeah, there's information. I don't know. Which, do you want me to interpret the shorthand?
If you possible, if you don't know, maybe it's best you don't, then we don't put a
Okay,
version that might not be correct.
in Cape, there was information received that in Cape Town, allegedly SARS bugged the house in Cape Town. I'm not sure which house now. Journalist called to take photos of alcohol dash issues articles talking about include the drive. So this must have been information in a drive provided, but this was not in the report. So unless this is the information that was being referred to in, I can't know, but this is July now. Okay, no, I don't recall. But that's the story that is shorthanded. But I don't recall it in the report. So I don't think it must have been a passing comment, or we decided not to include it.
So just to put your note into context, I must take you to 190.26409.
Okay.
Okay. Get to the essence of it. We have tried to cover, but sometimes it comes through. Right? Go down. She tells you to come and get it to clean it up so that come get more comments to clean the dock tomorrow morning. See that at the bottom?
Yes, I see the part.
And that the email is dated the 3rd of July. I'm not putting it up on the screen because it's got Advocate Mkubani's
Oh, okay.
private email address on it.
All right.
But Seppo behind me can confirm the date on the email.
Okay.
Okay. And that's how we've placed where your notes fit in to the chronology. There's the date. All right. To do
Okay,
that.
also from PP, ne?
Yeah.
Okay.
And I had assumed it was Mr. Mataboga's notes because the email went to him. But it could be that you had gone instead of him.
No, we would have gone together.
We'd have gone
But
together.
we didn't. I don't meet the PP at that time. I didn't meet the PP alone without my supervisor. Actually, I still
Okay.
don't.
So then I've just got one or two things that I just want to clear up with you, and then I'm done. Right. If we go to your statement. Well, let's take it from the top. I just want to clear some things up with you in your statement. Okay. We've already established that. Okay, we've gone through that. We've Done that. You say in your affidavit that I'm of the firm view that some of the evidence has grossly misrepresented paragraph 8 on page 452. You refer to the evidence of some of the witnesses, and I'm not sure if you've only read media reports on Pillay and Lochberg, or you're referring to the evidence. In paragraph 8, you say, I'm of the firm view that some of the evidence has grossly misrepresented the true situation. And I'm wanting to ask if you can provide some more specificity as to precisely which evidence you thought was a gross misrepresentation.
This true situation that happened during the investigation. I think let's also complete the sentence so that we have context. Grossly, the fact that it's alleged that the investigation was started off as in a vendetta or bias towards certain individuals, that we did not try to locate Mr. van Locherenberg is a misrepresentation, that none of Mr. Pillay's evidence was taken into consideration, including the 2014 response that he provided to our office, as well as the 2019 responses. So basically that's where that was coming from.
But you come to this view even though you didn't hear all the evidence.
Responses to the Office of the Public Protector.
Yeah,
Yeah.
sorry, I've lost you. I'm trying to figure out let's take a step back. You didn't hear all the oral evidence. That's what you say.
From
in
all the
paragraph 8.
witnesses.
From all the witnesses.
No.
Did
from
you,
all the witnesses within in the inquiry?
now, did you hear the oral evidence of Mr. Pillay and Mr. van Locherenberg?
Yes. Mr. Pillay portionally, van Locherenberg, I heard the whole thing.
Okay. So when you come to that conclusion, it's based on what was said in the inquiry,
Yes.
right? You had not previously had Mr. van Locherenberg's evidence.
No.
When you come to the conclusion that you disagree with the material findings of the High Court and with the factual foundation of that, you also indicated in your evidence, although you come to that conclusion, you had not had insight as to the evidence before the High Court.
No, I've never had, but in the judgment, they mentioned that evidence was submitted by Mr. van Locherenberg to the Office of the Public Protector containing reams and reams. So that portion of the judgment is the one that I feel was misrepresented, because when we were doing the investigation, we did not receive those documents that Mr. van Locherenberg allegedly submitted previously to the office.
Okay, so here's the position. If Mr. van Locherenberg puts up an affidavit before the High Court in which he says, I submitted that information in 2016 to the Public Protector's office, and the Public Protector does not refute that allegation, what is the court meant to do?
It obviously found that Mr. van Locherenberg was telling the truth due to the non-response to the allegation by the PP.
And if Mr. van Locherenberg attached evidence to his affidavit, which reflects that he had submitted the information to the Public Protector's office, then conceivably the information could be lying somewhere at the Public Protector's office and just has not been found.
Possibly.
right. Then if we go to paragraph that. That. In your affidavit, you deal with this issue of, in paragraph 9, it is common cause that the term rogue unit was first used in the public domain in 2014. Right? You then say it was not invented, introduced, or exclusively used by the public protector and their team. I don't think the evidence was that the term was invented, introduced, or exclusively used by the public protector or her team. Did you understand that the evidence before the inquiry was of that nature?
Of the evidence that was given suggested that the public protector purported to push the narrative of the rogue unit. Unfortunately, I'm not sure if I'm quoting it well. So in this statement, it's just to say that the name rogue unit didn't come from the public protector or the team. It was a name that was already being used in South Africa for the alleged unit that was in SARS. That was basically what I'm trying to say here.
In fact, in his affidavit before the High Court and for Advocate Mpofu's benefit, it's bundle B, item 2.3 at para 44. He says that the term isn't used in any of the reports, Sikakane report or the Nugent report, etc. That it was initially arose in the Sunday Times in 2014, and there had then subsequently been certain retractions by the Sunday Times, but that it's almost exclusively used by the public protector and the media to do that. And wasn't the concern in the evidence that the public protector at the meeting with the IGI had referred to the unit as a rogue unit and as a monster? And she expressed the view that she was going to defeat the monster. I seem to recall that that was the evidence. Was that what you were responding to?
No.
No.
No, and I can't comment on the meeting and the monster comment.
Okay. All right. You then in paragraph 10 say, apart from the public protector, various other independent reports found that the establishment or operations of the were unlawful because of the alleged nature of its activities. These allegations have been denied by Mr. van Lochenberg, but have never been disproved. What do you mean by that?
They've never been disproved. They've never been any court case except what you've just told me now of the OIGI being set aside. And previously, all the reports, Yosip Kakane, had not been set aside to say that there was non-unlawfulness in the formation of the unit.
Do you
So,
accept that Advocate Sikakane rendered a legal opinion?
sorry?
Advocate Sikakane's report was an opinion provided by 3 advocates.
Yes.
It's not ordinarily so that you would review and set aside a report of counsel. Do you accept that?
A review and set aside.
A report given by the advocates.
Yes, but it can be disproved.
Well, SARS has gone out and said that they're not placing any reliance on it, and they've effectively apologized to the people involved as a consequence of that report.
I heard.
And the Kroon media statement is also not something that you would review and set aside. You agree with that?
The advisory or the,
Report, yeah.
which statement
The media statement that they issued.
that he issued about the unlawfulness,
Yes.
establishment being unlawful?
Yes.
No, but it could also be disproved.
But they retracted,
Who?
Kroon.
Only Judge Gruen retracted.
Now, I asked you, Judge Kroon went out and he publicly retracted the statement that was issued by the advisory board. And I asked you, did anybody else who sat on that board contradict Judge Kroon and say
No,
you didn't speak on behalf of the advisory board?
No, Chair.
no.
Chairperson.
I'm not understanding the
He
question.
issued the media statement. I almost stand correct, but I can't, I have to check whether he issued it on his personal capacity or
Chair.
on behalf of the board.
Suppose I could borrow a book.
No, I object to that. That's clearly a misleading question. The witness has said repeatedly, and actually I put it to Mr. Van Lochenberg, I think I put it to Mr. Pillay, and I put it even to this witness, that distinction. So Advocate Bauer has no right to say they when she puts the question to the witness, when it's clear that whatever apology or whatever you call it was an individual act of Judge Kroon. I read out the statement yesterday where he says he many times there. Even Judge Nugent uses that word. So I take the point that no one else came out to contradict him, but also no one else came out to support him.
Okay, over to you, Advocate Bauer.
Is Judge Kroon saying, we didn't do an investigation, we relied on the Sikakane report in respect of coming to that conclusion. Do you recall that?
That I remember you stated it, yes.
Right? So essentially, we have KPMG who says, we didn't do an investigation. What was done there, we took from the Sikakane report, and the Sikakane report, SARS is not relying on. So
No.
what's left?
No, it's another misrepresentation. Sorry, Chair. That's not what KPMG said. It's Kroon who said he relied on Sikakane.
Sorry.
KPMG said that they relied on counsel's advice.
KPMG says they withdrew their findings, recommendations, and legal opinions in 2018, which was widely published. In 2016, they also widely published limitations, included them being precluded from engaging those affected. Right. The finding that that the unit was illegal or unlawfully established was withdrawn in 2018.
Yes, but that finding, particular finding, but the statement you are ascribing to KPMG, sorry, Chair,
Yeah,
was for Judge Kroon.
I withdraw that. You're right. All right. To do that. But as we established from the public protector's point of view, you didn't engage with any of the evidence that served for these inquiries or reports or opinions.
No, they were not provided.
So you none the wiser as to whether they're correct or whether they're incorrect.
No, ours was not to find them correct or incorrect. We were just stating that there were investigations conducted and this was what the investigations either recommended or found. And then we used the evidence thereafter.
And
Not-
that's why you say in your affidavit, whether they are true or false, I cannot say.
Yes,
So whether they are true has not been proven and whether they are false have not been proven. That's what you're trying to say.
no,
Okay.
I'm saying what you said before the statement you just stated.
Yeah.
Whether or not they're true, I cannot say.
Okay. All right. Then if we go
Just an indication you're standing between us and tea. You said you're about to finish, so I just need to.
Well, actually, let's have tea and then I'll just, it might be quicker, Chair.
Okay, we'll take a 10-minute break for tea and be back at 4. Thank you.
Recording stopped.
Done that.
Thank you. Just settle. I'll wait for you. Take your time. You are not like somebody here who just stands up and who sits there and go in and out. So you don't have that luxury, just like me. So I'm going to allow you to settle.
Thank you.
That person won't be named.
Thank you.
Thank you. Welcome back, colleagues. Advocate Bauer, back to you.
I've just got two questions that arose from that. You were referred to an NPA report by an advocate Pretorius SC. Did that relate to the establishment of the unit at all?
No, if I recall correctly, it related to the charges. So it emanated from the charges that were, or the charges emanated from that report.
From which report?
The opinion of Advocate Pretorius. If I have
Okay.
his name correct.
So it didn't have anything to do with the, it didn't relate to the establishment of the unit at all.
As far as I can recall, it was the charges of the allegations of the bugging, if I can put it like that.
And then you did in your affidavit, I don't need to deal with it with you, but you received a letter from Mr. Mark King and the former acting commissioner of SARS as part of your investigation, correct?
Correct.
All right. And those are my questions, Chief.
Thank you, Advocate Bauer. That concludes your interaction with the witness. We are now going to invite members if they have any questions to put to the witness. That's where we are now. So I will recognize if there are members who wants to do that, both on the virtual as well as here at M46. If you don't have anything, that's also fine. But let me note the members in their order. We'll start with Honorable Sukas, to be followed. I don't have anybody there. Honorable Siwela. Honorable Siwela will follow Honorable Sukas. Any member in the virtual platform? Any other member in the virtual platform? I am aware that you're multitasking, but we have to do our work. None so far. Anybody here at M46? Honorable Lagude. Thank you. Those are the members. We'll start with Honorable Sukas. The time now is 16:06. Over to you, Honorable Sukas.
Good afternoon, Chair. Good afternoon to the committee. Afternoon, Mrs. Mvuyana. Thank you for coming before the committee. I have a few simple questions, and I'll kick off with what is your your attitude towards the South African judiciary. Do you have a respect for the learning and integrity of our judges, especially those who sit in the Constitutional Court?
Thank you, Honorable Sukas, Ms. Mvuyana. So we'll take them one by one. So you can switch on your mic.
Good afternoon. Is it Advocate Sukas?
It's Honorable Sukas.
Honorable Sukas. I'll answer. My attitude towards the South African judiciary is a good attitude. I respect the judiciary. I respect their decisions. And of course, the Constitutional Court as the last resort court or the highest court in the land also has my respect. So I don't doubt our courts at this stage. I don't know if that answers your question.
Yes, it does. My second question is, you would concede that the judges are more knowledgeable than you or I. And I heard you say advocate, and it seems like we get promotions today, but certainly more than both of us, more so myself. I think you have a legal background, and so you would concede that they are more knowledgeable than both of us, certainly.
Yes, they are more knowledgeable in the judgments that they make, but I don't believe they are knowledgeable in investigations.
So am I then to take that you're saying the judgments, with them not having knowledge of investigations, as you've put it now, that based on that, you would question the judgments that they make?
No, unfortunately, I can't question judgments. Only if a high court judgment is made, only the Supreme Court or the Constitutional Court can set it aside. My opinion, I'd like to keep to myself.
Okay. Advocate Zulu Sukoni, the Zambian public protector, has described an adverse court judgment as an opportunity for self-cleansing. Let me rather say analysis, reflection, and implementing change to improve outcomes. You personally worked on reports that were set aside and heavily criticized by the judiciary. Did you participate in any sessions organized by the public protector or management to reflect on these findings and improve the processes within the public protector South Africa? And could you please describe those sessions?
Yes, I have participated in sessions where those judgments are discussed, or specifically certain portions that relate to the procedures of the public protector, or procedures that were not adhered to in full by the public protector team. Some of those we would go through them, even though I won't recall the exact days of the trainings or what they were called, but an example would be the section 6.9 issue, which has been much contention in the courts as well. So as investigators, we were then went through the judgment, and we were made to understand what is expected going forward on how to deal with investigations that are 2 years and older. So yes, I have participated, and yeah, the judgments are very appreciated as well, because it makes the public protector a much better institution.
Honorable Sukas, are you still there? She's cut off. Okay. That's all. We will come back to her to conclude whatever she has to ask. At this point, I will recognize Honorable Siwela.
Thank you, Chairperson. Just to show off that is me, I will close my.
Thank you. We can see it's you. Thank you.
Thank you, Chairperson. Good afternoon or good evening, Ceci Bianca. I have got few questions to ask you in relation with an intelligence report. Do you know it is unlawful for any person to possess any intelligence report that is classified? That is my question.
Sorry, can you please repeat, Honorable Siwela?
My question is in relation with an intelligence report. I'm asking that, do you know it is unlawful for any person to possess an intelligence report that is classified?
Any person besides?
Any person.
A normal South African, yes, but I mean, if I work at state security or I actually drafted the report or I'm the Minister of State Security, then I would be able to have possession of the report. Me personally, I can't. So that's my answer on that question.
Before you proceed, I'm going to ask Advocate Bofu to whisper quietly, whatever you whisper.
No, Chairperson, somebody is snoring.
No, before that, I hear that the snoring, but
Apologies.
go ahead, Honorable Suwela.
I'm asking this in relation with the information we got. Chair, I'm asking this to say in relation with what has been presented, that it was established that the PP had a report in her possession. So that's why I'm asking her that, is it lawful or unlawful now? But she has answered what she has answered. Thank you, Chair.
Thank you, Honorable Siwela. I'm going to take the next speaker. Honorable Sukas will indicate when you're back. I now note Honorable Tlakude.
Thank you very much, Honorable Chairperson. Good afternoon, Advocate Mvuyana and your team, evidence leader, Advocate Bauer, and Ms. Mvuyana. During Advocate Bauer's question, you mentioned that the intelligence report was dropped in the PP's office by an anonymous person. Then you go on to say that Mr. Manyike, Mr. Manyike submitted documents detailing operations and functioning of the intelligence report. Can you please make me understand if the anonymous person is really not Mr. Manyike? Because an anonymous person dropped this intelligence report. Then Mr. Manyike submitted a document detailing the activities of the intelligence unit. Are we talking about one and the same person who dropped the report? Because in my own analysis, I think he's the one who dropped the report.
Yeah, okay. Mr. Manyike is a 2014 complainant. The documents that where you say we state submitted documents detailing the functions of the it wasn't of the intelligence report, of the intelligence unit. So he was a 2014 complainant and his matter was closed in 2017. Whether or not he knows about that, I don't know. But Manyike would not have known of the intelligence report, I think, because it was done in 2015, if I'm not mistaken. And the drop off by the anonymous individual occurred in between late 2018 to 2019. I cannot confirm because, like I said, I was also not the one that received it from anonymous. So I won't know if it was Mr. Man. Could have been Mr. Manyike, but anonymous is anonymous.
Okay. Thanks for your response. You also indicate that on the 24th of January, 2019, Mr. Shibambu sent you an email. It was there that the report of the Office of the Intelligence of the Inspector General of Intelligence is out. I'm just curious about this person who dropped this report, the classified report of the
YGI.
of the Inspector General. So, given that Mr. Shibambu indicated to you through an email that the report is out, can maybe implicate him in this mix of dropping the intelligence report? Is it him or is not him? Because it dropped but I'm linking him to this because he sent you an email that the OIG report is out. And after that, a report is found on the doorsteps of the PPSA.
Okay.
We just want to understand as a committee.
Like I said before, Honorable Zagut, I don't know the anonymous person. Yes, Mr. Shivambu did send an email on the 24th saying that the IG report is out. And then in that email, he attaches the Noseweek article. So the Noseweek article then details the report or if they, I'm not sure if they had a copy, but they detail what the recommendations and the findings were, etc. And then all of a sudden, I'm informed that the report is at the public protector. So I am not the one who went to pick it up, and I cannot guarantee or even say that it was Mr. Shivambu that dropped it off.
I'm still suspicious. I'm still not satisfied because I just want to understand why would he send you that report from that message of saying the report is out. Maybe were you part of investigating this rogue unit even before the report was out?
No, Mr. Shivambu laid a complaint in November. We had a meeting with him in December. He stated to us that there is a report by the OIGI, or the OIGI is conducting an investigation. So in the 24th, I won't go into his thought process at the time, but that's what he said, and he sent the Newsweek article attached. If he wanted to give me the report, he would have attached the report in the email. And if he wanted for me to have the report, he would have indicated that the report is attached. So I cannot confirm, unfortunately, if it was him or if it wasn't.
Ms. Mvuyana, you indicated under direct evidence that you didn't use any of the information. You didn't rely on the OIGI report when you make your findings and remedial action. Then in your remedial action, you also said that the recommendation or the report of the OIGI must be implemented. I think there is something that is not right there. You didn't use it to reach your findings and remedial action, but you, on the other hand, in your remedial action, you said it must be implemented. Can you please clarify for me how we come about implementing while you didn't rely on it, on your findings?
Okay, okay. I don't remember my own answers, but the OIGI report, I did not see. I did not have access to it due to my security clearance. The people who did have top security secret, and I'm aware that knew about it, had seen it. I don't know if they read it. Was the public protector and Mr. Matabuche, and there was a trail of emails of the people that are listed to have seen the report. When I was drafting the report, I don't know when Advocate Bauer showed the yellow text being included in the report or even in the drafts. That shows that the reports were interchanged between me and the people that had access or awareness of the report. So that's how I believe that happened. So your remedial action being implemented, etc. I think even from the notes, Advocate Bauer pointed out that the note says that this must be implemented during a meeting with the public protector.
Thank you, Ms. Mvuyana, for your response. When did you start working for the PPSA?
In 2013.
2013. Okay. In your understanding, since you arrived in that office, is it common practice for the PP's office to obtain an intelligence classified report?
I wouldn't know because I've never been involved in a matter or investigated a matter that had any issues with the state security or near. This was my first investigation in relation to that. So if the another investigator maybe would know, I don't know. I've never had an investigation of that kind.
Okay. You have indicated, my last question, Chair, you have indicated under direct evidence that the reports of Skakane, KPMG, and the publications made by Sunday Times on the operations were not binding when you conducted your own investigation. Then nonetheless, you used some of these reports to make certain findings to finalize your report. Are you aware that KPMG withdrew its report? Sunday Times apologized for the false publication, and the SARS Advisory Board, headed by Judge Kuon, apologized for adopting the findings of the Skakane report. Are you aware of that?
Go ahead, Honorable Jabot.
Ngilinde impendulo.
Oh, sorry, I thought Advocate Pofu was coming in.
No, there's a chair here.
Oh, okay.
Thank you.
Sorry, Chair. I think it's already been answered. The reports were used as evidence to state that basically they have been received. These are the reports that were received from and requested from SARS. Actually, we just requested information and they supplied the reports. We included the reports in our report to say that, yes, these reports were investigated. This is what they found. We then used other evidence that was obtained from SARS as well, which included internal documents from SARS. Not only did we use the reports to come to the findings. So on the second portion of the question of whether or not I'm aware, I'd like not to comment on that because they've deliberated. But some Skakane, I'm not aware of it being retracted or disproved. I'm also I'm aware of the KPMG apology and Judge Groen's apology.
You were aware of the two, but still some of the information from their reports was used in your findings and remedial actions. Okay, I'm done, Chair.
Oh, that doesn't need an answer. It's a comment.
You can respond.
I'm not sure which portions of the findings were exactly as in their reports, the ones you've mentioned, but like I said, the reports were used as evidence, as well as other evidence that was submitted to make the conclusion. So it wasn't just relying on the reports or copying and pasting them.
Okay.
In your evidence, you said that the evidence of Mr. Pillay under oath was ignored. Why was that?
Sorry, was?
The evidence of Mr. Pillay, who was under oath, was ignored by the PP or the PPSA's office, your office, all of you. Why was that? Instead, the use of information that was given by someone who, like Mr. Manyike, who was not under oath, was used, that information, but the one for the person who was under oath, it wasn't. It was disregarded. Why is that?
I don't know which information of Mr. Pillay was disregarded, because his first response is detailed there, where we do put Mr. Gordon's response, Mr. Pillay's affidavit, and we state that Mr. Gordon denied, Mr. Pillay also denied. And then in the final report, we also state that on this date, affidavits were taken in, etc. So I'm not sure which evidence was ignored.
Okay, sir.
Thank you, Honorable Lagude. I will now go to Honorable Mailam and then back to Sukas.
Good afternoon, Chair. Good afternoon, members, and thank you very much, Ms. Mvuyana, for availing yourself today. Ms. Mvuyana, you said earlier that judges aren't good at investigations. Can you tell me what the difference is between a judge and an investigator, please?
No, I cannot.
Okay. You also said yesterday in your evidence that that you stood by your report in terms of the so-called rogue unit. Do you stand by that right now?
Sorry?
So yesterday in your evidence, you said that you stood by your report and your findings in terms of the so-called rogue unit. Do you still stand by that report?
Did I say the findings or the investigation conducted?
Well, the report itself.
I don't recall saying the report.
So you don't stand by the report then?
I said the investigation.
Okay, let me
The
ask you
report has
this.
been set aside.
I'm aware of that. That's why I was asking. Let me ask you this. In terms of the investigation, would you agree that the investigation into the so-called rogue unit was a shoddy investigation, in that it did not take into account all the evidence, it did not talk to all the implicated people, it did not seek all the evidence from various witnesses, and instead relied on selected evidence?
It relied on evidence that was before us and that we had received. So that is what I can say about that.
I'm going to repeat my question. Would you agree that it was a shoddy investigation?
No, I will not agree to the word shoddy.
Even though you did not take all the evidence into account?
What's the meaning of shoddy?
Well, exactly what I've just said, that you did not take all the evidence into account. You did not interview all the witnesses. We've heard from earlier from Advocate Bauer that you did not make every effort to even contact some of the witnesses. That to me is shoddy, and I'm asking if you would agree with that.
No, I still maintain not agreeing with shoddy. Maybe
So
if
you
you
think
know
that,
another word.
okay, let me rephrase it. Do you think that the investigation into the so-called rogue unit was a quality investigation, a high quality investigation?
No, there were certain things that were overlooked.
Okay.
So it could have been improved and done correctly. I agree with that.
Okay. Let's put that to one side and let's look at in fact, let me leave it there, Chair. Let me end on that note. Thank you.
Okay, thank you, Honorable Mailam. I now go back to Honorable Sukas.
Thank you, Chair. With your permission, I will keep my video off so that the connection be more stable.
That's okay. Thank you.
Mrs. Mvuyana, I just want to take off from where we got cut off. I heard you say that there was reflection on portions of judgments and there were attention paid to judgments that were critical of reports. Did I hear you correctly in entirety? Because I got cut off.
Yes, but I don't believe all the judgments, or I was not a part of all the judgments, but I have sat in focus groups. Yes.
Okay. I would. My next question to you is, what changes or improvements, processes, new ways of doing things were introduced following such sessions? And if you can, please expand on this specific judgment that this investigation that you were a part of, and that was found wanting by the courts. What were the improvements and the processes, new processes or improvement processes to improve the way you do things in terms of your investigations? What were those that were made by yourself or your units in regard to that? So I've asked you the broad question, and then I just narrowed it down to say, in terms of your investigation specifically, that you were heavily involved with, and where there were adverse judgments. What were, out of those sessions, processes that were improved on, or changes that were made in how you work?
In relation to the focus groups, like I've stated before, the focus group that I went to is the section 6.9, which relates to considering the 2-year rule. So a decision was taken by the public protector team as a whole, being top management, that the rule be applied strictly. So that is currently happening. We really go into detail when identifying special circumstances and also communicating the special circumstances at the beginning of an investigation. And if the special circumstances are not provided by the complainant in the complaint, they are now asked to provide reasons why they failed to report the matter within 2 years. Besides the focus groups, in relation to the investigations or the conducting thereof, improvements would be, one thing I know for sure is my diary has improved a lot. So yeah, that's about it. I don't know if there's anything more that you require.
No, I think as a committee, what we would like to know is that, as you said, I think you said earlier, you listened to parts of the testimonies of Mr. van Lochenberg and Pillay, and there were portions of it that spoke of personal pain, spoke of the impact that it had on people in terms of the investigation and the not just the investigation, but the findings. And so the question then is, what would you do differently as an investigator? You have now had learning, and certainly there has been grueling learning, and you are sitting before a committee now that is doing oversight over the public protector. What is being done differently within the organization, and specifically yourself? I hear focus groups, but I'm asking, what are you doing differently now as an investigator? Has there been had a conversation with you in terms of improving performance investigations? Has the organization introduced training that now results into a way of improving the quality of the investigations and implementing the the criticism, certainly, or improving on that came out of the judgments?
I think I answered, maybe it wasn't satisfactory to you, but yes, there have been improvements.
What are those improvements?
Well, I can't comment on the emotional pain suffered, because that is now in the past, I guess. So in terms of going forward, is that what you're asking?
No, I'm asking, once you've had those judgments, Chair, it's going into my time, and I think it's an important point for us as a committee to know what was done after those judgments. I asked you specifically, what is your attitude towards the judiciary? Now, I'm going to come back to the issue of processes. It maybe gives you more time. What is the attitude of the public protector to the judiciary?
The public protector, the institution.
The public protector, Advocate Mvuyana.
I don't know the attitude of Advocate Mvuyana towards the judiciary.
Well, is there anything in the reflection of the leadership of the organization that shows that there is a respect, like you've said, a respect for the judiciary, and respect translates into taking cognizance of what the court has said, and for that then to be like the public protector from Zambia said, for it to be a self-cleansing exercise almost. Is that attitude being reflected either by your direct line, and now I'm broadening it, or by the public protector after all of the criticism the office suffered, after all of the negativity that the office had a burden under? Has anything been done to change the way it operates?
Yes, Advocate Sukas, thank you for clarifying. Yes, the attitude has changed. There are systems in place to ensure that investigations are conducted in terms of the SOPs, and that there's proper analysis, there's proper collection of evidence, ensuring that all evidence is incorporated if necessary or relevant. This is, I know right now we have regular full bench meetings whereby any report or Section 7(9) that will be issued is thoroughly set down by management as a whole. That includes the APP, the CEO, your legal services, your quality assurance, the EMs, the ACOO, the PRs, the investigators that are relevant to that particular matter are also present every day when they do sit. Rules change, of course, to be in line with whatever the achievement is of the report. So it must be concise, it must be proper. So those are the systems that are in place now to try and curb that, and to show that we actually understood what the judges were saying, and to implement correct procedures and follow them to the T when doing our investigations. So definitely there is that within the institution.
So was that done under the leadership of the of Advocate Mvuyana, or was it done under the leadership of the current acting public protector?
I won't be sure, but if I recall properly, the full bench idea came with or was suggested by the current APP. That time Advocate Mvuyana was on leave, and then when Advocate Mvuyana arrived back from leave. It was continued until she was suspended. Yeah, they have different management styles, so I won't comment much on that, but they were in place because the in-depth sitting down of everyone, all management, I don't recall it happening during PP's or Advocate Mkwebane's era, but she did have, I believe, a team of managers that set to look at the reports. So that would be a think tank, legal services, that would include her, of course, legal services and QA, and quality assurance.
Yeah,
So
I think, I'm sorry, I interrupted you. Did you want to add something?
No, you can continue.
Okay, so if I understand you correctly, the changes were introduced by the acting PP public protector, and when Advocate Mkwebane returned from leave, it was still continued, but it was under the leadership of the APP.
No, it was when Advocate Mkwebane returned, it was under the leadership of Mkwebane
Okay.
until her suspension. So, yeah.
Okay, now you need to clarify to me the changes, the improvements, the new way of working, and that, and you mentioned one, which was the full bench.
Yeah.
That was done by the APP that you've said to me, I think a few minutes ago. And that when
Yes.
Advocate Mkwebane came back, it continued, it wasn't stopped, right?
Yes.
Okay, so now my question directly initiated by Advocate Mkwebane to change
No.
or improve. I'm not talking about under whose auspices it was when the person came back, because the initiation, as you said, was done by the APP, right? Now I'm asking which changes and improvements were you can directly attribute to Advocate Mkwebane following the harsh and critical judgments, adverse judgment that was made against the public protector. What can you attribute to Advocate Mkwebane?
I'd have to recall the reports that were issued in between each person's time, and I don't.
Okay.
Yeah, but yeah, no, I can't recall any reports now because I don't work on all of the reports.
And you can't recall any specific action that takes your organization 180 degrees away from where it previously was as a consequence of the organization having suffering a very negative, certainly public rulings in public by the judiciary.
No, I can't be specific in terms of when exactly the changes that now would put us in the spotlight again, or good spotlight, started. So
Okay.
if some cases were won, some cases were not won. Yeah.
Okay. Can you just lastly tell the committee?
That has to be your last question, yes.
It is, yes, it is, Chair. Thank you. Thank you, Chair. What is the attitude of the Public Protector South African? I'm now talking about the office. Does it see itself as right and the judges as wrong? Or does the organization see the judgments as opportunities for self-criticism and improvement and self-correction?
From my own view and what I've seen is the judgments are appreciated and are seen as methods that can be used to improve the processes of the public protector and how the public protector South Africa conducts investigations.
Thank you, Chair. Thank you, Mrs. Mvuyana. I appreciate your time.
Thank you.
Thank you. Honorable Gonde.
Thank you very much, Chair. Good afternoon, Ms. Mvuyana,
Good afternoon.
how are you?
I'm good. How are you?
I'm fine.
Thank you.
I have a couple of questions for you. The first one is a follow-up on the question that Honorable Dlagude asked you. Her question related specifically to the Nugent Commission report and the Kroon report and the reporting by the Sunday Times. And in response to the question she asked, you said these reports were used as evidence. But then my question to you becomes, if they were used as evidence, why were some of these not reflected in the Rule 53 record and in the entries in the investigation diary related to the investigation into the so-called SARS unit report, the rogue unit?
If I recall correctly, it's Advocate Bauer pointed out the Nugent report as not being a part
Yes,
of the Rule
she
53.
indicated. So my question to you is that why were some of these not reflected? Even in the investigation diary, she pointed out that there was no reference made to those reports and in the Rule 53 record to some of the interviews that were conducted.
Specifically in the diary, the reports would have been received from SARS. So when we receive documents from SARS, the bundle of reports is there except the Nugent report. I've already explained why the Nugent report was not in there, Rule 53. So in the diary, it just says response received.
The Nugent report, what was your explanation that it was already in the public domain?
Yes.
Okay.
And so in the diary, it just says response received from SARS. And in the diary, we don't detail the specific documents that are submitted.
And in the Rule 53 record?
And the Rule 53, you would put them. Were they not there?
According to Advocate Bauer, and I think you conceded to the fact that, they were not, some of the reports were not reflected in the Rule 53 record.
Sorry, Sean.
I don't recall. I can confirm the Nugent based on Advocate Bauer, but from my records, the KPMG's Kakane report are in the Rule 53.
Your mic is not on.
That's why I used the word some and not all. So it was only the Nugent report that was not reflected in the Rule 53 record. Is that what you're saying?
That's what I'm saying. Yes.
Okay. Just to follow up on a question that Honorable Milam asked you. He asked you whether you thought the investigation into this so-called rogue unit by the Office of the Public Protector was a quality investigation, and you responded to say, no, it wasn't, because there were certain things that were overlooked in the course of the investigation. Please confirm to this committee which things were overlooked during the course of the investigation, and who's to blame for overlooking those things.
I can't comment on that. I won't recall line by line what was missing.
Okay, can you name one or two? Because you mentioned that certain things were overlooked. So I'm trying to figure out.
From his pushing that there were certain people not interviewed. So he also gave, but the example that he made was that evidence was pushed aside or evidence was not considered.
So are you conceding to the fact that
the interviewing of certain people? Yes.
Okay, so certain people would include not interviewing a single person, that supposedly belonged to that unit, that was a member of the unit. So not a single person. So things like that constitutes overlooking certain things in terms of the investigation.
Yes, things that could have been done properly.
And impacted the quality of the investigation.
Probably.
Okay, but you indicated that it wasn't a high quality investigation.
I agreed with your colleague.
Okay, so if you agreed, it doesn't mean that you're conceding to the fact that it wasn't a great investigation and it could have been done better?
I just said that I don't agree with the name of Shoddy.
Then he came back and he used quality,
Yeah,
and then you conceded that it wasn't a quality investigation.
due to some of the evidence and not interviewing. Yes,
Okay, so you feel that impacted the quality of the investigation.
yes.
All right. Okay, I have another question regarding this investigation. In the course of your evidence, you indicated that there was some equipment that was that you had determined belonged to the so-called rogue unit.
Yes.
Do you know where this equipment, I mean, is it still in existence? Do you know where it is?
No.
Okay, and do you have evidence, and I'm talking about direct evidence, linking the procurement of that equipment to the so-called rogue unit?
I don't know if you want me to answer from the time.
Yes,
'Cause
from the
I
time
don't
of the
have
investigation.
evidence.
So there was no evidence.
No, I don't have evidence. I thought you meant at the time
Yes,
that linked
yes,
to the equipment to the rogue
the
unit.
procurement of that equipment to the rogue unit. To the
Yes,
so-called rogue.
at the time we believe so.
So it was evidence, direct evidence. In other words, evidence showing that that unit procured that equipment.
It was the unit. I'd have to argue the report now if I answer that question.
Okay. All right. So what do you recall about the equipment and the procurement of that equipment?
I recall that there was an allegation that was made that the unit had certain equipment that was used for COVID operations. So that unit was then procured through a particular memo. The memo was approved and the equipment is then was used.
So I'm not entirely sure where the direct link, just explain a bit, comes in.
Sorry?
The direct link in terms of the procurement.
We received a list, etc. So those were the links.
Okay, all right.
Mm.
Okay, you stated in the course of your evidence that you were not privy to the report by the Inspector General of Intelligence on the so-called rogue unit, but the report was in the Office of the Public Protector. Am I correct? And you were not privy to it because you did not have top secret security clearance.
Correct.
And then you later revealed that you had only confidential clearance. May I ask why you had confidential and not top secret clearance? Because we had evidence earlier in this inquiry that a top secret security clearance was almost a requirement for all investigators.
Why? Well, when I arrived at the Public Protector, I was a trainee investigator. That's when the application to state security was made. And at that time, we could only know confidential information. Then when I became an investigator, an application was made, but we've never received any feedback from state security.
Yes, I'm asking this because we also had evidence that Advocate Mkhwebane kept the former Deputy Public Protector, Kevin Malinga, outside, out of investigations because he did not have a top secret security clearance. So my question then becomes to you, the fact that you had confidential security clearance, has that in any way hampered your ability to do investigations? Were you prevented from doing certain investigations because of that?
I would not know because I'm not the allocator. I don't allocate to myself.
Okay.
So,
but that has
depending-
never been an issue to your knowledge. Has that been an issue?
I wouldn't know because it's a discussion that have.
No, I mean,
without
has
me
anyone come
present.
to you and said the fact that you don't have top secret security clearance?
No one has ever said
All
that to
right.
me.
Thank you very much. Chair. That's all from my side.
Thank you, Honorable Bondwe. Honorable Mailam, is that an old hand?
Chair, I wanted to ask one question that I neglected to ask, if I may.
Okay, go ahead.
Thank you, Chairperson. Mr. Mvuyana, you said in your evidence that in the quality assurance process, things get changed in the reports. So you said that once it leaves your hands, it goes up the line to the public protector and things get changed. Are you ever consulted on those changes? Do you ever have an opportunity to say, I'm sorry, but that's not what I said, that's not what I found, that's not what my investigation showed?
Yes, the inputs are returned to me. So the document with the inputs. In some instances it will be discussed. They explain their viewpoint and why it was inserted. Then we'll either concede to it or I'll then make the final decision as the lead.
Thank you very, very much.
In this case, I was working with the team, so I won't say a proper lead because there was information that was included that I could not argue with.
Okay, thank you very much. Thank you.
Thank you, Honorable Mailam. Come again? We don't do that. I will give you a special dispensation because Honorable Mailam would have cut short his time. It's the reason I gave him. But you'll be the last one.
Okay.
And then I go to Advocate Mbofu.
Thank you very much, Honorable Chairperson. Ms. Mvuyana, I'm sorry to do this to you, but the Chairperson at least gave me the opportunity. So during your evidence, you said that, I mean, let me leave that. In the PP's office, there is a system of circulating a report to managers, COOs, CEOs, CEO, the legal services, and also the quality insurers before the report is released. So with regard to the SARS report, why did a different approach used to deal with this, not the normal way of doing things when it comes to reports? Thanks, Chair.
In this report, I wouldn't know the exact reason of the break because my line didn't break. So my direct line to Mr. Matabuke was not broken.
Okay, thank you, Honorable Dlagude. We now come back to Advocate Mbofu. If he has any pick-up questions, he had indicated about that email, so I'm reminding him.
Yes, thank you very much. I appreciate that.
That's one of the things he wanted to say.
Yes,
So
thank you. Chair, can I not do that?
That's fine.
I'll explain why.
That's fine. That's
Let me just explain quickly why. That email was actually indeed displayed by Advocate Bauer without displaying the name. So we'll leave it there. We will post that document. And then when we deal with the PP, because it was really addressed to her, so then we'll deal with it then, yeah, thanks. But I think that issue of the email about Godan must be stopped and so on has now been clarified, yeah. At least at this stage, but we'll revisit it when the public protector comes. Thank you, Chair. Now, you've been asked some questions and some questions. Isn't it obvious or isn't it true that because of your security clearance status, you were indeed hampered in the sense that unlike the other members of the team, you did not have access to the report.
Correct.
All right. Anyway, okay, I'll come back to some of this. Let's just start, I think, with the issue of the balance that Advocate Bauer was suggesting to you. And I just want to be clear on this, because you've been accused of all sorts of things, including favoring evidence that is not verified versus that which is under oath and all that jazz. Now, yesterday, you remember that we established that the affidavit, sworn statement of Minister Godan did not refute his role in the establishment of the unit.
Correct.
In fact, he confirmed his role in the establishment of the unit, correct?
Yes, that's correct.
We also established that the, let's call it Trevor Manuel memorandum, made it clear that the establishment of that unit would be illegal in the hands of SARS, at least.
Yes, within SARS.
Yes, and that indeed that unit was in fact established within SARS, despite the knowledge of that illegality.
Well, that's correct.
Okay. So now, when you are doing this so-called balance that you're supposed to do, the statement of Mr. Godan, which is the, as I called it yesterday, loosely, I must confess, an agreement or a confession of that wrongdoing. So you have your preliminary provisional findings, right?
Yeah,
Then
correct.
you have confirmation of the provisional findings under oath to the extent that I've just described by Mr. Godan, correct?
Yes, that's correct.
Yes. And but you are told that you have nothing under oath, whereas you had a statement of Mr. Godan which confirmed your provisional findings. Isn't that a bit twisting the logic? Maybe I'm putting it strongly. Let me put it in a way that is not what I'll argue at the end. If there's a statement that confirms your provisional findings and you have to do a balance, which side of that scale do you put it? Do you put it on the things that are good for your provisional findings or those that are against it?
In this case, and based on that, the statement under oath confirming that he was responsible or had a hand or approved or requested the establishment of the unit, the allegation as well as the memo stating that there would be a unit created, etc. Yes, that would lead us to make a finding that he was involved in the establishment of the unit.
Thank you. Because we know, Chairperson, that the purpose of a response to your Section 7.9 is to do two things: either to refute your allegation or to strengthen it. Or I suppose three things, or to do nothing and leave it undisturbed.
Yes, that's correct.
Yeah. Okay, thank you. Now, so then let's go to this issue again, which I think was not, well, obviously not clear or clearly understood, of the alleged conspiracy, vendetta, whatever you call it. and correct me if I'm wrong, my understanding is that what you and I had established yesterday, which has not been disputed, is that if there was a conspiracy, vendetta, what have you, against Mr. Gordhan and anyone else by the public protector in respect of this particular investigation, then that vendetta campaign, whatever you call it, could not be executed without the participation of you and or Mr. Mataboge.
Yes, that's correct.
Right. So have you ever been accused or charged or disciplined at PPSA for being a member of that conspiracy?
No,
Has Mr. Mataboge ever been charged or condemned or accused or given an audit letter or anything for being a member of that conspiracy?
no, none that I know of.
Yes. So the only person, the only member of that conspiracy who's facing removal from their job, I'm saying member, quote unquote, of that conspiracy would be the public advocate Mkhwebane, correct? If it existed.
Correct.
Do you know what a signal jammer is?
No, I've heard about the word in movies, but I won't know exactly what it is.
Yes, yes, I've also heard about it in movies and also in this parliament, I think it was used once. But to your knowledge, and I know you're not an expert on this, neither am I, but is a signal jammer generally known as spying equipment or intelligence equipment? Maybe spying is too strong.
Yes, generally.
All right. Now, while we are on this issue of the equipment, you remember yesterday we established that there were two issues about the equipment. Firstly, it was its nature, like whether it's a signal jammer and what have you, whether it's spying equipment. But the second issue was also, assuming it is not spying equipment, was the fact that it was allegedly irregularly procured.
Correct.
To the tune of about 40 million rand, give or take. I mean, I know that was not your figure, but that was the figure that was bandied about.
Yes, that was the figure in the report.
Now, if let's assume everything else, there was no rogue unit, there was no all the equipment was nice equipment and so on. If you only established that there was irregular procurement of 40 million rand worth of equipment, would that have attracted a negative report from the public protector?
It would depend on the process that was followed to procure the equipment.
Yes, no,
The
I'm
amount,
saying, sorry, finish.
The amount would not necessarily just lead us to making an automatic adverse finding.
No, I'm saying, well, okay. I'm saying that's why I use the word irregular expenditure. If you had found that there had been irregular expenditure in respect of equipment worth 40 million rand, would that amount to a breach of the PFMA?
Yes, it would. Irregular expenditure.
Thank you. All right. And on top of that, in this case, then we have the issue of whether it was spying equipment or not. And then, of course, we have the issue of whether it was lawfully established or not, which we've already covered, correct?
Yes, that's correct.
All right. So then on all of those, let's just take those three aspects based on the evidence that was before you, whether it's the signal jammers or the absence of the procurement paper trail or the evidence of Mr. Godan, would you come to any different findings on whether just those three aspects were substantiated today?
With the evidence, the same evidence. Yes.
You would come to a different conclusion,
No, I'm saying that I would come to the same conclusion.
to the same conclusion. Thank you. All right. Now, you, Advocate Bauer said the following in regard to the court. I'm quoting a verbatim. She said, "Yeah, if there are certain allegations put by an applicant, then the court is entitled to accept that evidence." You would agree with that?
Yes.
So in the case of the rogue unit judgment, who was the applicant who made those allegations of bias, dishonesty, which were then accepted by the court?
I believe it was Mr. Gordon.
Thank you. Now, just this one topic, which I think we have to put to bed once and for all, because it looks like there's, despite all human effort to explain this, there's still either deliberate or inadvertent, as the word goes, failure to understand it. Let's just put it plainly. In the judgment, you've referred to the section, I think it starts at 112, although in your statement it says 113. Can you put up the judgment, please? While this being put up, let me ask you, is there any truth to the proposition that the public protector in the report said she had never seen the OHIGI report?
No, there is none.
There's no truth. Now, based on that incorrect statement, factually incorrect, should be plain to even a 3-year-old child that it's factually incorrect, is repeated here at paragraph 113 of the judgment. Okay, it says the public protector relies on this report despite explicitly stating that she has not seen the report. That's part of that incorrect statement, correct?
That's correct.
Yeah.
In the report,
Yeah.
there's no
such thing.
of
Just doesn't exist.
explicitly stating.
Yes. And then that same incorrect, go to paragraph 115. It says, despite that fact that the public protector, according to the report, has never seen nor verified the contents of findings of the OHIGI report, she ordered minister, what have you. That's based on the incorrect factual statement that the public protector said she hasn't seen the report in her report, correct?
Yes, that's correct.
That's number 2. Paragraph 116. The court says, it is difficult to understand on what basis the sections of the Constitution can notionally grant the public protector the power to rely on a report that she herself has not seen, because this is what she says in the report. It's false, that statement. It is not true, correct?
That's correct.
Number 4, go to paragraph 118. The judges say, most alarmingly, however, and despite the fact that the public protector stated in the report that she did not have sight of the OIGI report coming to her findings. That is factually incorrect, right?
That's correct. Incorrect. Yes, that's correct.
It's
on what you're
correct that
saying.
is incorrect. Thank you. All right. And then after those 4 factually incorrect statements, demonstrably agreed, should be agreed by anyone who has eyes. Okay? Then the punchline is then at paragraph 120, which says, this turn of events is disturbing and, to say the least, it's difficult to label the public protector's conduct in this regard as anything else but dishonest. Right?
Yes, I
Now,
see that.
if that dishonesty finding, which is what brings us here, is based on an untruth, can it withstand any logical, sane scrutiny?
I won't use saying those,
Yeah.
the word your
Okay,
words
logical,
exactly.
maybe.
But basically,
All right, let's
she
put it
never
this way.
said
Can
that
it
she saw.
survive? Once you scrutinize it, if you look at those 4 things and come to the conclusion, and then on the one hand, on the other hand, you establish that this actually has never happened. In other words, you say the public protector stabbed somebody at the offices, and you say it 4 times, and therefore she's a stabber. But then you discover that actually she has never stabbed anyone. But can the appellation that she's a stabber of people survive if it can now be shown that the factual basis thereof is false?
No, that you are correct. It can't because of the report states that she, yeah.
Yeah, and in fact, let me demonstrate to you that actually not only is it false that she ever said this, but actually if you read the report properly, you'll see that there is more evidence that shows that she had seen the report. I'll show it to you now. Go to the report itself. Sorry, can go to oh, sorry, let's see. I'm missing some document. Okay, let's do it like this. Maybe just to kill 2 birds with 1 stone about why certain documents were not listed and so on, something that was raised. Let's start at 4.4. Sorry, I'm sorry, of the report here. That's page 4247. On your, okay, let me use the paragraph itself, because I think we're using different sources. 4.4, yeah. Right. That list, you were told, why is this there? Why is it not not there? Is that the, okay, what is the heading of that list, 4.4?
The key sources of information.
Yes. When it says the key sources of information, does it mean that all the information that was ever used will be listed there?
No.
Okay. So that would be what is regarded key by whoever is compiling the report, correct?
Yes, that's correct.
Thank you. All right. Let's put that aside. so this kind of document doesn't purport to be like a Rule 53, which lists every piece of information. And in fact, the law says every scrap of piece of paper.
Yes,
Yeah.
no.
All right. Okay, fine. Okay, now that we've put that aside, let's then go to the what I call the proof that the public protector actually was not concealing that she had seen the report. If anything, she was revealing it, maybe not in so many words. Look at the letter at 4.1.6. It's a letter from OIGI from the public protector dated 14 January 2019, correct? Oh,
Yes,
sorry.
that's correct.
We can just see the face of Mr. Milham. I thought it was displayed. It's not there. 4.1.4, rather 4.4.1.6. Just where we were on the same page we are on now, just now it's up. Okay, so the letter from the OIGI from the public protector dated 14 January 2019. That's and 4.1.4, 4.4.1.7 letter from OIGI to public protector, subpoena of the Minister of State of Security, letter from OIGI to public protector, 4.4.1.10 letter from acting DG of SSA, 4.4.1.11 letter to the Minister of the South African Security Agency. All that would be rather the letters regarding the attempts to declassify the report, correct?
Yes, that's correct.
Yes. And more importantly, 4.4.1, 4.4.1.12, letter from the Minister of SSA dated 20 February 2019. Now let's go to that letter. You'll find it at page 5810, bundle F, item 190. Bundle F, item 190, it's page 5810. Yes. Yes, that's the letter. Yeah. Can we go to paragraph 2? Okay, so in that letter, which is listed by the public protector in her report, if anyone had that letter and go to it, this is what they will find. It says, yeah. And this information is freely available for anyone and even to this committee. This is what it says. The minister confirms that during the meeting, the PPSA informed her that a copy of the secret report was purportedly delivered to their offices by unidentified persons, which is therefore patently unlawful. As I said to you yesterday, forget about the legal conclusion of the minister. But doesn't this letter confirm that the report was dropped at PPSA?
Yeah, that's correct. Confirms it.
Right. So that's the first evidence of the public protector actually revealing a document which shows that she has seen the report, not the opposite that is said 4 times incorrectly in the judgment. Then if you go to paragraph 4.4.12, no, I'm sorry. Paragraph 5.2.35, I think, Tsepo. 34, sorry. .34. Yeah, pardon? The same document we're on now. We were at 4.2.12 of the report. Now just move a few pages of, yeah. No, was in the report. Yeah, the letter is done. The report 4.5. Okay, let me check it again. It's the report that we're on now, which had the key, what have you, key documents. Yeah. Yeah. It's the type page 50. Oh. Thank you. 5.2.34. Yeah. Then the public protector says there, the OIGI report recommended inter alia that 1, criminal charges be investigated and so on. B, SARS produce a credible inventory of all operational equipment and so on. Could someone who has not seen the report write a paragraph like that?
No.
And could someone who is concealing the fact that she has seen the report write a paragraph like that?
No.
Okay. Now, you were then asked about by Honorable Sukas and somebody else about learnings. You've confirmed that you were part of focus groups that dealt, among other things, with judgments. Correct?
Correct. But I said I only recall one.
Yes. And that was the intention of such a focus group would have been to see what one could learn from the judgments in order to improve, correct?
Yes, that's correct.
Yes. Now, you made an example of changes that were effected as a result of the judgments that had to do with section 6.9, that's the jurisdiction section, correct?
Correct.
Yes. And are you also aware, and I'm asking this because I was involved in some of this litigation. Are you also aware that before at least the Busasa judgment, and I think this judgment that we've just looked at, and the Pillay judgment, there were two views about whether there should be a second Audi after the section 7.9, and then when you get the remedial action, whether you should get another Audi. Are you aware of that?
Not so much. I just know that now the remedial action is within the section 7.9. Yeah.
Okay, good. That's exactly what I'm saying. Before then, well, I think it was I can't remember which one. I think it was Mr. Kakana who confirmed this, and there's a memorandum from Mr. Namasisi and all that. Don't worry about that. But it's sufficient for you to confirm what you've confirmed. Anyway, before the judgments, I can tell you as a matter of fact, the PPSA took the view that section 7.9 was confined to the to the findings, not the remedial action stage.
Yes.
Then
yes.
the judgments came, including these ones that I had argued, and the Busasa one, which said the opposite. After that, did the institution, as you've just confirmed now, change to including the remedial action in section 7.9 as a result of learning from the judgments?
Yes, that's correct.
Thank you. And now you're told that this there could be, you're told that in terms of the quality of the report, there could be room for improvement. Have you ever written a report yourself as a lawyer or as a person, ever written a report or done an investigation in respect of which a year later, if you looked at it, there would be no room for improvement? In other words, it was like 100%, or is that a natural consequence that if you were to do it again, you would change certain things?
Yes, that's correct. I have, you always check your work and try to improve it.
Yeah. Right. Now, tell me this. If I'm going to ask you this in relation to two things. I don't have time now to go to the judgment, but it's been put up here. There's a judgment by the Constitutional Court which says that some of the so-called scathing criticism by judges on the public protector is unfair, and which says that the judges have made it fashionable to visit the public protector with personal and punitive costs in circumstances where it is unwarranted. Just take that as a fact, okay?
Okay.
Yeah. Now, I'm giving you that scenario. Let's assume then that, I don't know, shall we say 5? Let's say 5. I'm just making it up. I think it was 4. Yeah. Say that on 5 times, judges visit the public protector unfairly and in an unwarranted fashion with personal and punitive costs. Okay?
Okay.
Yeah. Now, in that scenario, what is it that the public protector can learn? Who should improve? Is it the public protector or the judges?
If on the 5 occasions,
They wrongly and in an unwarranted fashion put a punitive cost on her. She has done nothing to deserve it. What must she improve? Who must improve? Is it the judges or the public protector?
that's a difficult question.
Well, it's
because the courts, unfortunately, are above the public protector.
no.
Okay.
Okay, fine. Let me put it this way. Let me assist you. The judge who said this, Judge Madanga, said that this tendency should stop because it undermines the office of the public protector. Her words were, you undermine that office, you undermine our democracy. His words in that judgment. So that warning, you think, was it towards the public protector or towards those who had been doing the act of unfairly visiting her with personal costs?
I believe it was directed at the judges who made the scathing remarks and personal cost orders.
Thank you. Now, in the same vein, I read to you 4 pronouncements within the space of about 5 paragraphs or 6 paragraphs, where the incorrect assertion is made that the public protector said she had not seen the report. You remember that?
Yes, I remember.
Now, when you have your focus group or whatever you call it, and the public protector now has that judgment, which says something that does not exist, what can she learn from that? What learnings, improvement, all the things that Honorable Sukas was telling us about, what learnings can she make that she must not do what next time? Because it's not true that she said in the report that she didn't see the report. Who must improve here? Is it the public protector or the people who wrote 4 times something that does not exist? It's fine. You don't have to answer. It's fine. It's, I think the answer is obvious, but don't want to put you on the spot. We'll deal with it in more detail. But you know, this is the kind of country we live in now, where we're told that we must have learnings and improvement. Improve on what? When you are the one who's a victim of being subjected to untruths and unfair personal costs. Improve on what? Anyway, all right. Now, the last one, Chair. Oh, sorry. It might not be the last one, Chair. Let me look at this. Oh, yeah. Yeah. All right, just 2 quick ones, Chair, before I come to my last question. All right, we know for better or for worse that you were not able to successfully subpoena Mr. van Lochenbeck and get any information from him, correct?
Correct.
So having not been able to find him, and I say whether you are to blame or not to blame for that, that's not where I am now. Would it have been then possible for you in the report and the public protector to include information from him?
Received how?
Well, the whatever it is that you wanted to subpoena him for. If you had failed to get that information, can you be blamed for it not being used in the report?
The information was not there though.
Yes, thank you. And the information from, so the affidavit that is now bandied about of Mr. van Lochenbeck is an affidavit that came in the litigation, correct? Long after the report was out.
Yes, that was my understanding from Advocate Bauer.
Right. And then Mr. Pillay, all these things that he says in his affidavit about the unit and all that, were those things put in his response to the section 7.9 to your memory?
Yes, to my memory, they were his response and his response to the 7.9 in the final report.
Right. And to the extent that they were put in the section 7.9, were they considered by you and the public protector in fashioning the final report?
Yes.
Okay. Yes. And then you are told that, again, I'm going back to that balancing exercise, but for a different purpose, Chair. You were told, it was selectively said that you only relied on Mr. Manyike without verifying him, Mr. Duval and the recording without authenticating it and so on. Isn't it a fact that you told this committee yesterday that you also relied largely on information supplied to you by SARS as a
Yes.
result of the subpoena?
Yes, that's correct.
And did you have any reason to doubt the authenticity of that information?
No, there was no reason to doubt.
Thank you. Now, now I didn't know what was my last question. All right, it's a small one. Advocate Power put to you that Mr. Matabuche said that the public protector is involved from start to finish in an investigation. Now, you tried, I think yesterday and today as well, to qualify that by saying that she gets involved at a high level, not with the, what do you call it, assessment of evidence and the nuts and bolts of any investigation. Remember that?
Yes, that's correct. I remember.
Now, let's assume now the public protector was like this busybody who wanted to get involved in every investigation literally, as it is being suggested. My information is that at any given time, as fortunately we are now in the provinces, countrywide, there would be more than 200 up to 300 investigations going on at a time, correct?
Yes, that's correct.
So would it be humanly possible, even if she was a busybody, would it be humanly possible for her to get involved from start to finish in the literal sense in all these 300 investigations going on around the country?
No.
And lastly, is an investigation diary, and I accept, I don't want to take away from your concession made to Advocate Power that there could have been more items listed in the investigation diary. But the question I want to ask, is an investigation diary like that list meant to record literally everything that happens, every phone call, or is it also about key milestones in the investigation?
It's key milestones.
6073. Sorry, Chair, sorry, I misled you. This one is really the final. The affidavit, and again, you may not, it might be an unfair question because the affidavit of Mr. Libello, which was made to before the commissioner retired Judge Nugent, 6072 of bundle F, item 190. I take the point, Chair, that an Advocate Power, I think, made it, assisted us in this, that you were not one of the recipients of this. It was sent to Mr. Rodney Matabuche and Ponatseho Mokhaladi, the EM. But while TEPO is looking for it, I just want to say to you, Chair, and maybe the members, if anyone is interested in understanding this whole rogue unit issue, that 66-page document I read yesterday and this affidavit, which is 135 pages, contains almost everything that you'll ever need to understand. But the point is that this document, although it was not sent to you, it's obvious that it was being sent for the attention of the team. Let's just go to the next page, sorry, 6073, just so that you can see it. All right. And just maybe to try and refresh your memory, it starts with, go to the next page, observation. It deals with the media reports. It deals with the so-called Kanyane panel. Go to 6086. It deals with the Sikakane outcome and the appointment of Mr. Mvuyana, 86. Yes, go to 6087. It deals with what it calls clarity on the different investigations and their roles. Advocate Sikakane panel, next one. Advocate Brasi, next paragraph. Next paragraph, KPMG. Next paragraph, investigation findings on Brasi. Next paragraph. Next section, sorry, but 51. Just, yeah, Ivan Pillay, and then it discussed is in particular. If I may just, at paragraph 54, it then goes in detail, and I'll read it out. On point 2.1 of the memo, Mr. Pillay and Mr. Godan asked the then Minister for funding of 48.9 million over 3 years to establish a unit within NIA for collecting of tactical intelligence, possibly intended for penetrating and intercepting organized criminal syndicates. On the same point, 2.1, Mr. Pillay and Mr. Godan state that this is an activity for which SARS does not presently have a capability, including a legislative mandate to clandestine activity. And then 56, in other words, and as Advocate Kakane correctly pointed out, it was through Mr. Pillay and Mr. Godan's admission, no one else, not even me, that SARS does not have the legislative mandate to manage clandestine activity. That is, quote, to collect tactical intelligence, penetrating and intercepting organized criminal syndicates. And then it goes on to misrepresentations by Pillay, goes on to covert spying by current employees, engagement of informers, Project Sunday evenings, and so on. Allegations that Van Lochenberg has disclosed information to the media, and so on and so on. So that document, the evidence of the public protector will be that it was received, indeed, as it says, in December 2018 and forwarded to the team. And obviously then used either by them or by you. Are you familiar with that document, or at least its existence, if not its contents?
The existence, I believe so, because there was a discussion held with Mr. Matabuke saying that he did receive a document after, I think after the meeting.
Yeah.
The meeting was to take the team through this document, if I recall.
Yes.
Yeah.
Okay. No, thank you. We'll deal with it when the public protector testifies. But I'm just, so this, at least you may not have been involved with that, but this document to as much extent as other people, including the public protector. But this was part of the material available to the team, broadly speaking, in 6 months before the report was released, correct?
Yes, that's correct.
Thank you, Chair. I just want to say, Chair, that we, and I'm not doing this. We should be, I was trying to object when Honorable Lagude was posing her questions in the same vein as I did this morning. I think it's our responsibility, Chair, and yours and all of us to try and protect whistleblowers. No, there's a problem in South Africa. Whistleblowers, we just don't care for them, and that's why they get killed left, right, and center. So let's please not have questioning that says, well, somebody dropped a document anonymously or as a whistleblower, and could it have been Mr. Shabalala? Could it have been Advocate Matlape? Could it have been this one or that one? Please, because what if the witness says, yeah, well, I think, yes, I do think it was Advocate Shabalala. Then if he was a whistleblower, then we all know who that is. So I'm just, I know it was not intended in that fashion, but it's just something we should just be aware of. Just 1 second.
Thank you.
So, sorry, Chair, I'm getting these notes left, right, and center. All right, so I think we covered this yesterday, but Advocate Shabalala wants, obviously wants to be the leader of the team, as the chair has been trying to elevate him. But sorry, another serious note, okay, is it a fact that the responses of both Mr. Pillay and Mr. Godan were taken into account when you did the final report and even referred to in your final report?
Yes, that's correct.
Yes. And in fact, and also to be fair, the responses of SARS were also taken into account.
Yes, that's correct.
In fact, it is in that connection that the Nugent report was quoted in the final report. It was not because you just went around looking for the Nugent report per se. It's because in the Section 7.9 responses, it was cited to you.
Yes, it was cited in the note.
Well, it was cited by you, obviously, in the Section 7.9s, but also in the responses, you were referred to it by SARS and the others.
Yes, correct.
Yes, thank you. And just to be clear on this, Mr. van Lochenbeck, although he was mentioned, was not himself a target or of negative findings, in the sense that he would have deserved to receive a Section 7.9 notice.
Yes.
Yes, he was. Yes, we know that he was mentioned, and they said he's a recipient. And I think he was in the same league as Mr. Makwakwa, for example, who was also accused of having received money in his personal money in his account.
Yes, that's correct.
Yes, and nobody has ever suggested that you should have given Mr. Makwakwa a Section 7.9 or regard him as an implicated person, correct?
Yes, that's correct.
Thank you, Chairperson. Thank you, Ms. Mvuyana.
Thank you. Ms. Mvuyana, we've now reached the end of our interaction with you. Is there anything you want to say to the committee? That's your
No.
last comments.
No, there's no comment.
As a remark to the committee.
No. No,
Should we take a break and you come back?
no, I'm perfectly fine with leaving. Good luck. All I can say is good luck to everyone.
Okay. No, thank you, Ms. Singobile Bianca Mvuyana, for availing yourself before and during the last 2 days come and present to the best of your ability what you know in relation to the issues that we ask you to, that we identified for your testimony. On behalf of the committee, I want to thank you for your time, your contributions. We do hope that whatever you placed in front of this committee would be useful to our deliberations and to the kind of work that we've been mandated to do by the National Assembly. And on that note, you are now officially excused. Thank you very much.
Thank you.
And then,
Chair,
colleagues, honorable members, we are going to proceed with our committee meeting, just to indicate that we have received a correspondence from the PP, and I had directed that that correspondence be sent to all members, which it was, and had indicated that immediately after we conclude with Ms. Mvuyana, we are going to have a committee session to attend to all of those issues. So it will be a committee session that is open to the public in all of its platforms, but we will excuse the evidence leaders as well as the public protector and her team. They can both join if they so wish in whatever platforms as they normally do, so that they follow the deliberations of the committee. So for us, we'll take a quick break, 10 minutes break, and then we come back, and then we resume the committee session. Thank you very much, colleagues.
thank you, Chair.
See you tomorrow.
Yes, we'll catch you on Google.
Thank you. Thank you. advantage when you are on the ground, you know, than high flyers. They don't have that advantage. But welcome back, colleagues. We want to resume and start a committee session. Let me just check if we still, you're still with us. Honorable Mayelam, are you there?
Yes, Chair, I'm here.
Thank you. Honorable Nkosi?
I'm here, Chair.
Thank you. Honorable Hermans?
Was that Hermans or Heron?
Honorable Heron, let me go to you. It was Hermans. Thank you. Honorable Manili?
I'm here, Chair.
Honorable Mgweba? Honorable Jane Seboletswe Mananiso? Akawubitsa. Honorable Sukas?
I'm here, Chair.
Okay, thank you, colleagues. Honorable Siwela? Yeah, that's what you do when we don't speak with you, you speak. Thank you, honorable members. We have called this session to attend to one particular urgent matter that we just need to confirm either way. And then there's a list of other issues. This meeting is called in response to the correspondence, as I referred earlier on, that we received today. I think should be after tea or whatever time, from the public protector. There would have been whispers before the correspondence to me as a chair, and those whispers found a very closed ear. Couldn't hear anything in terms of those whispers. I then received the correspondence, which I immediately instructed that it be shared with members, and that immediate after this witness, as members, we deal with whatever issues that is being raised. The evidence leaders have left and the public protector, but perhaps I should have said that to them, that the schedule, the program, dated and timed with the former public protector from tomorrow and Thursday stands until decided otherwise in this meeting. So that's a status. The letter, and I'll ask Ms. Ibrahim, the letter raises about, I think, 6 issues, and I'm going to just have us attend issue by issue and have a resolution on each of those issues, also to save time and not be all over the place. Maybe before I make my further comments, I'll ask Ms. Ibrahim to just take issue A, evidence of Professor Madonsela as arising out of the letter. And then I'm going to invite members to deliberate on that. And we have an immediate resolution on the matter.
Thank you, Chairperson. Chair, as you indicated, we received a letter earlier today. I think it was probably around 11:30 this morning, if I have my timing right.
The letter raised various issues, but as you've indicated, we'll deal with each one in turn. The first one is titled A, Evidence of Prof. Madonsela, and it says we are instructed to raise the aforementioned issues for decision by the committee. The deadlines for the submission of Prof. Madonsela's affidavit was 22 February 2023. We communicated this fact to her when she insisted on preparing her own statement, either with the evidence leaders or independently, but not with the legal team of the public protector. The chairperson unilaterally and without any consultation with us granted an extension until Friday, 24 February. That deadline too was not met in that the statement was only delivered on Saturday, 25th February, when members of our team were busy preparing to travel to Cape Town and with preparations for the evidence of Ms. Mvuyana, which had been interposed for 27 and 28th Feb. Upon proper reflection and after consideration of the statement, which is not only late but also unintelligible in parts, it has become clear that we would be doing our client a huge disservice if we were to proceed with dealing with the evidence of Prof. Madonsela on schedule. Accordingly, we have firm instructions to reschedule the evidence of Prof. Madonsela to a later mutually convenient day and without breaching the 7-day rule. So Chair, just by way of background, the committee will recall that there was an application received from the PP in December, I think it was the 13th of December, but that was dealt with only this year, in which she requested that various persons be summoned, and that included Prof. Madonsela. And in fact, her name also appeared on the confirmed, on the witness list, at least not as a confirmed person, but on the witness list of 8th of November. The committee then on 24 Jan considered those requests to subpoena various persons, and the committee agreed that it would subpoena Prof. Madonsela. At that stage, Chair, when the decision was made, the committee didn't have regard to any response from Advocate Madonsela to the request or the invite from the PP because she had not responded to that letter. She then, in fact, only responded to them later the same day. And the issue was then reconsidered by the committee on 1 February. And after consideration of Advocate Madonsela's response, which in short was that she was declining the invitation because she did not see her evidence as being relevant on the one hand, and on the other, she indicated that the information could be found via other sources at the PPSA. The committee then decided that it would still want her to appear before the committee, specifically on Vrede and Sex. And this was then confirmed to her in a letter from the chair. On the 7th of February, Prof. Madonsela then responded in writing, saying it was still her view that her answers won't be relevant and they can be obtained by other means, but that she would avail herself to the committee on 1 March. She then also asked for independent legal advice to draft the statement and that such independent services be procured by the PPSA. A letter of response was sent by the chair to Prof. Madonsela, reiterating that her evidence is limited to CX and Vrede. And we said to her, well, if you do need assistance, we can avail the evidence leaders for that purpose. But what we will also do is to refer your request to the PPSA and ask them to respond to you directly. Chair, what happened in between was that there was some toing and froing, but following the appearance, the initial appearance of Ms. Mvuyana, where there were issues raised about her statement, I then placed a telephone call to Prof. Madonsela, explaining to her that she did appear as a witness on the PP's witness list, that she was requested to appear at the behest of the PP. And so there was a concern from evidence leaders that there shouldn't be a perception of bias, or they were a little bit uneasy. This also, in this conversation, what I also discussed with Prof. Madonsela was her concerns Similar to Mr. Mataboge, in fact, that she did not want to appear before the committee as a witness for either the evidence leaders or for the public protector, but rather she wanted to come to the committee to assist the committee independently, as it were. Chairperson, she then indicated that she would then do her own statement. We gave her an extension until the 23rd of Feb instead of the 22nd of Feb, which was the initial due date for the statement, because she had raised with me the fact that she had various commitments. On the same day, Chair, she received a letter from Sianego in which we were copied on the email correspondence that attached the letter. And they raised various issues in that letter and further questions that they wished to pose to her. There was then, Chair, on the 22nd of Feb, an email from Advocate Madansela to myself, where she copies in the PP's team, and she writes that unfortunately I'm unable to submit such statement within the stipulated timeline for several reasons, key among which is that I have no idea what I'm required to depose to, due to the fact that I now have 3 letters with disparate contents that purport to request me to avail myself as a witness and which indicate the crux of evidence required from me. So the background there is, Chair, is that there were letters being sent from Sianego Inc. on behalf of the PP, requesting that they want her to answer questions in relation to things beyond CX and Vrede. And then there was communication from our side as a committee saying, we want you to testify on those matters. So this is where the confusion then comes in. Chair, we then wrote a letter to Prof. Madansela indicating and confirming what her evidence is sought on. But she also received a letter from Sianego indicating that they won't accept any deviations from the 7-day rule, and they can't commit to how much time they would need to deal with the statement once received, but that this will be raised separately with the committee. So that was sent to her on Friday, 24th of February, and that is, of course, what is being raised in the letter sent to us today. Chair, it was my understanding yesterday, and unfortunately Advocate Bauer is not here now, but it was my understanding from informal discussions yesterday that the PP's team was ready to proceed with Advocate Madansela, or Prof. Madansela now as it is. But in terms of making a decision now, Chair, the directives are in fact silent on the issue of the 7-day rule for a witness like Prof. Madansela. So what we had catered for were witnesses that were appearing at the behest of the evidence leaders on behalf of the committee, or witnesses that were going to appear on behalf of the PP. So it said that when the PP submits a statement or when the evidence leader submit a statement, the 7-day rule applies. We never dealt with a case where the person is submitting a statement on their own accord, independently, as is the case with Prof. Madansela. So there is that lacuna. If the committee is of the view that the 7 days should still apply, of course, there's nothing wrong with that. The committee can do so. But in making a decision, things that the committee could have regard to, Chair, would be the length of the statement, whether there has been sufficient time for the PP's team to consider the statement, the fact that they had indicated as early as last year that they wish to put questions to the PP, to the former PP at least, and that their letters in the recent weeks have all indicated what that line of questioning is. So that's something that the committee can take into consideration. Chair, the proposal from them, and it's a little bit on point 2, but I'll mention it though, but the proposal is not that we don't sit tomorrow and the next day, but instead that Mr. Mataboge sits and Prof. Madansela is then pushed to a later date that would obviously have to be decided. Chair, I did take the liberty of contacting Prof. Madansela during the afternoon tea adjournment, just to ascertain from her, because I suspected members may put the question to me as to her availabilities. If I can just deal with it upfront, and she did indicate that her schedule is fairly full, and she gave me certain dates. Unfortunately, some of the dates clash with other things that the committee is involved in. So, for example, the litigation in the High Court on the review was one of the days. Another day, proposed day, I know advocate or the PP's team at least had indicated that they have something else that they need to attend to. So that wasn't put on the program. So we would have to look for a date. And obviously I wasn't able to do that. I would need the direction of the committee to do that in a more formal way. But Chair, that is where we stand. If the committee feels that the 7-day rule is applicable, the Chair does have the power in terms of the directives to allow for a deviation in terms of the rule. But the committee, as I always remind the committee, would have to consider the issue of fairness, which is paramount in the process when making its decision on how to deal with this. Thank you.
Thank you, Ms. Ibrahim. There you are, honorable members, just on this issue of tomorrow and Thursday, as planned by ourselves. I think the explanation has just been summarized to all of you in addition to the letter that you have. May I hear your inputs and your contributions on this matter? And then I'll come later as a chair. Any takers that wants to come in? Honorable Nkosi. I have only Honorable Nkosi on the virtual platform, indicating to have an opportunity. Honorable Maneli. Honorable Siwela. That's those are the 3 members I have on the virtual platform who wants to speak on the matter. Thank you. Let's start with you, Honorable Nkosi.
Thank you, Chairperson, and good evening, members and the Secretariat. If I may just check with the legal team, our legal team. Is Professor Matontala available tomorrow?
I'll answer that. She's available tomorrow and Thursday as scheduled and programmed.
Okay. Yeah, Chair, I think in all fairness to Professor Matontala and the fact that we have started communicating with her earlier, and her attitude that she doesn't want to assist the legal representatives of the PPSA or the evidence leaders. My proposal would be that we allow her to come and present tomorrow, proceed to present tomorrow, whatever she's able to go through throughout the day. And if there is any other thing that the team from both ourselves, the evidence leaders and the PPSA prepare overnight or in the time that we have to engage with her evidence. Remember that we have confined her evidence anyway, and we know exactly what we want her to assist the committee on. And in her deposition, she has indicated and she has responded exactly to the issues that she thinks she can assist the committee on. Unless there is anything beyond that. But I think with what we have written, submitted by her, I think it's adequate for us to proceed with her tomorrow and Thursday. Secondly, Chair, I think we'll have a program overrun unnecessarily. And we can't allow a situation where the fluidity and our ability to be adaptable is then exploited to the extent that, in between scheduled and firmed commitments, we then interfere with the program to interpose, or whatever the word that is used, to interpose further evidence. We have responsibilities elsewhere as members. Some of us are chairing committees, etc., and this committee has taken the bulk, or about 25% of our work elsewhere. Thanks, Chair.
Thank you, Honorable Ngosi. Honorable Maneli.
Thank you, Chair. Greetings to members. I think a number of points would have already been taken by Honorable Ngosi, but I wanted to start with the point that relates to the directives, and maybe as Ms. Ibrahim would be responding later on advising further, would be on the 10.3, Chair, because it will appear that gives you the discretion to look at that in terms of extension or no extension of time, first on submissions that people make. And I want to then say, surely we should then agree that the 7 days rule should not apply in this regard, especially because there's already a submission that would have been received and the witness prepared to come before the committee tomorrow and on Thursday. And I'm saying this, Chair, because this would not be giving preferential treatment to this witness, Prof. Madonsela, but this has been the case in some situations on both sides, that there would be such delays and the other information may not be within the 7 days. But what is important is the reasonability of having received the information and processed the information. And I'm not getting a sense that the challenge of not proceeding once again is a point of not being prepared on the other side, or the evidence leaders to proceed. So I thought I should make that submission, Chair. But again, respecting that in the initial response, there was reluctance to come before the committee, firstly on the basis that with the information available, there may be no need to come before the committee unless the specific matter, which can also be responded to even in writing and not appear before the committee. I think we should appreciate, therefore, their willingness to still come after all those persuasions, Chair, instead of having an undetermined date. And unfortunately, as things stand, we may forever have clashing dates, and that prolongs the program unnecessarily, as though the witness was not prepared to appear before the committee. I'll submit for now, Chair. Thank you.
Thank you, Honorable Maneli, for your contribution. Honorable Swela.
Thanks, Chairperson. Chair, the two speakers have taken my words. I just want to support my problem, Chair, on this process is the delay which we are experiencing. And Chair, as you know, that we belong to other committees, and it's a very big quarter, this one. So to me, to prolong issues of this committee, I don't think we are doing justice. And number two, if we have agreed, or as the legal rep has advised us that it is allowed that she stand on her and her own as an independent witness. If that it is allowed, we're not going even to use the 7 days. And if she has submitted something before us and we feel it will assist us because we are the one who has requested her to come. So I think it's the committee which must take a decision because as our legal rep has indicated, those dates which they are trying to agree upon, if those dates are clashing to each other, it will still delay this process. So I want to conclude ourselves, what we need is to get information which will assist us to arrive to a particular determination. So my submission, Chair, is that if Prof. Madonsela is ready, let us allow her to come tomorrow and Thursday. Finish and clear. Thank you.
Thank you, Honorable Siwela. Any members here, Honorable Gondwe and then Honorable Dlagude?
Thank you very much, Chair. I'm going to agree with previous speakers that let's go ahead with Professor Madonsela as scheduled. Let's not change any aspect of our program for the rest of the week. Time is a luxury for us. It's of the essence and we need to finish. And I'm also concerned like other members that, this committee has literally halted our participation or hampered our participation in other committees and prevented some of us from actually, concentrating on our constituencies as well. So would really like nothing more than anything else to continue at full speed. Chair, you'll also know that in terms of Directive 20.3, you have the power as a chairperson to condone that 7-day rule, provided there's good cause to show that and to show, to good cause to support the condemnation rather. And it is in the interest of fairness. So Chair, let's leave it as it is. Chair, can we respond to the other issues in the letter?
We'll come to that.
Oh,
We
okay.
just want to make sure we deal with this.
Okay.
And then immediately so that work is done in terms of communicating.
All right, thank you so much.
That, and then we'll come to the others.
All right.
So we might pair, I think Ms. Ibrahim has already tried to combine with B, but we'll
Yes.
quickly go through those.
All right, thank you, Chair.
Thank you, Honorable Dlagude.
Thank you very much, Honorable Chairperson. I want to fully agree with my colleagues. I think, Honorable Chairperson, since Professor Madonsela is not coming on behalf of the evidence leaders or the PP's as legal reps, I want to say, let's allow her to come because we've been waiting for this date for quite some time and she is available. So if we change the date to another date, then it will create a problem for us. So my colleagues have already said that this is not the only committee that we are serving in. Some of us have been in this meeting since 8 o'clock in the morning, so it's quite stretching us a little bit. So ours is to stick to our program as our living document, unless we are advised otherwise by the legal services. So we concur and agree that Professor Madonsela can come to the committee as she's coming on her own accord. So to assist the committee. Thank you very much, Chairperson.
Thank you, Honorable Dlagude. There being no other hand, because I don't see any other hand, maybe I will need to summarize the point. I see the hand of Honorable Tlape.
Thank you, Chair. And let me also add on what my fellow honorable members are indicating here, Chair. I am also of the opinion that it is in fact, a thing that we should welcome, that Professor Madonsela is indicating her availability in this regard. It is a respect for this committee, for her to make us aware that she is even available on these dates. So I concur with my fellow members that let's afford her the opportunity, because besides our stringent schedules, we don't even know how hers look like that she could indicate her availability now. We might even struggle after this time to get hold of her. So for now, let's allow her to come in and we know that we are done with her. Thanks.
Thank you, Honorable Tape. I think I will take the approach that cancelling of Gondwe. I think I'll try and summarize everything at the end, but there's been a particular trend of contributions up to this point with some level of unanimity, but I'll summarize at the end. Let me ask, therefore, Ms. Ibrahim, perhaps you can package the rest together and take us through, and then we maybe to save time. My initial approach doesn't seem to be saving time, so let's do that. Over to you, Ms. Ibrahim.
Thank you, Chairperson. Paragraph B of the letter deals with the evidence of Mr. Mataboge, as I said. And the reason it refers to that is because there was a suggestion from the PP's team that Mr. Mataboge appears tomorrow and the next day instead of Prof. Madonsela. The committee will recall that he's scheduled to appear on Friday, and that is after the PP's team invoked the directives to give them additional time to consider his evidence that he presented, because you'll recall that he did not submit a statement. So if I'm following the committee, the committee's of the view that in terms of Prof. Madonsela must continue for tomorrow and the next day as per the schedule, which would mean that this particular suggestion in paragraph B then also falls away, Chair. What I do need direction on is whether we then maintain the schedule for Friday, which is where Mr. Mataboge is now situated in terms of the current plan for the week. Must I continue?
Just unless members want to quickly deal with that, but maybe, yeah, just offload everything. Please take notes.
Okay, Chair, then paragraph C, calling of further witnesses, and it states the necessity to call the following further witnesses has been identified. Mr. Mayamani, and in brackets it says CR17 Bosasa, B, Advocate Sela Mayema, and in brackets a request for authorization from the NDPP is imminent, and then C, Mr. David Linder, and paragraph SARS unit. Mr. David Linder, members will recall, we have his affidavit. He is the person who attempted to deliver the subpoena to Mr. van Lochenberg. It says these witnesses have been rendered necessary due to recent evidence led at the inquiry. And it says nothing further, Chair. So I'm not sure whether this is an application or a request for the committee to now agree to call these witnesses. What the directives provide for is that the committee may call additional witnesses, and it provides that the PP may make application to the committee to summons any persons that she feels needs to appear before the committee, but there is no further information on why these persons are required to appear before the committee. So I don't know how the committee wants to deal with this particular request, Chair. As I said, it only indicates in brackets a broad subject matter like CR17 Basasa in respect of Mr. Mayamani. Chair, however, perhaps we must ask for further information on that so that the committee can get an understanding of what it is these witnesses' testimonies sought on, and then deal with it that way. But there is no reason why this can't happen at a later stage in the schedule, even after the PP's commenced evidence, because it is going to depend on what the process is that we would need to follow here. There's no indication here of whether these people are going to willingly avail themselves or what the proposed course of action is, Chair. So I can't speak in too much detail on that. In terms of paragraph.
Maybe just before you proceed, if you can add on what you've said, especially in relation to the very new witnesses that are being requested, Linda and so on, because the directives do even speak to that. 5.11 is very clear, and I may quickly read that. That says the chairperson may direct any witness to respond in writing to allegations arising from a witness statement and or the oral evidence of any witness. And so we've got to even look into that, because it might be that there's nothing substantial for Mr. Linda, but would have been mentioned as part of the oral evidence or statement. So we shouldn't exclude that as an option. Please go ahead.
Yes, Chair, written questions are always an option if it means that you can dispense with the matter more easily. Chair, the next one, paragraph D, appeal for reconsideration of non-calling of various witnesses. We are aware that a number of appeals have been rejected by the committee. That fact notwithstanding, we are instructed once more, and in light of recent evidence which puts a new perspective on the issue, to request that the committee should revisit its decision not to summon the following material witnesses: Mr. Cyril Ramaphosa, Mr. Pravin Gordhan, and Ms. Natasha Mazzoni. The relevance in areas of interest in respect of each of these witnesses has previously been communicated. Failure to call these witnesses must be accompanied by reasons, if any exist. Chairperson, this is a matter that we've dealt with a number of times. Members will recall that it's cropped up in correspondence over a long period of time. And in fact, it forms part of the subject matter of the review proceedings currently before the High Court. Our latest correspondence on this particular issue said that the committee considers the matter closed. But if it were that the Western Cape High Court reaches a different conclusion on that issue, then the committee would certainly then reconsider its position. And Chair, there was in fact correspondence sent last year on the 24th of October, and I just want to read a short paragraph there. In that correspondence, Chair, we stated, nevertheless, following the PP's indication that those individuals should be cross-examined further, sorry, Chair, I'm mixing up two issues now. Apologies, let me start again. On the non-calling of the various witnesses, we've already provided reasons. The committees had already considered that in detail. Mr. Ramaphosa, Pravin Gordhan, and Ms. Mazzoni. If the committee wants to reopen that discussion, then certainly the committee can do that if it so wishes. But I don't believe that we need to furnish reasons in respect thereof. That matter has been dealt with extensively. In respect of E, the refusal to recall various witnesses, that, Chair, has to do with Mr. Pillay, Mr. van Lochenberg, and Ms. Beloy. And this is the matter that's been raised a number of times, and in fact that forms part of the current review process. And it says failure to recall these witnesses must also be accompanied by reasons. And Chair, in respect of that, as I've indicated, our last correspondence said that the committee considers the matter closed and we would only reopen it if the Western Cape High Court rules differently, because as I said, it does form part of the matters under review. Also, Chair, there was a letter sent on 24th October 2022 where we said, nevertheless, following the PP's indication that those individuals, now being Mr. van Lochenberg, Ms. Beloy, and Mr. Pillay, should be cross-examined further, the committee wrote to them to request that they give further evidence. They have refused, but have indicated their willingness to answer questions in writing and under oath. If you are unhappy with this approach, you will need to make a formal application in writing to the committee, indicating what evidence you still require to solicit from them and why written questions would not suffice, so that consideration may be given as to whether, where possible, they should be subpoenaed, notwithstanding the PP having been afforded more than adequate time to cross-examine these persons. In the absence hereof, no assessment can be made as to the usefulness of having these witnesses return. So, Chair, we have dealt with this issue. We've not received a formal application precisely setting out why these persons need to be recalled, what the nature of the questions are, and why those questions cannot be put to them in writing. And members would have seen the correspondence where these witnesses have indicated for various reasons why they're not willing to voluntarily avail themselves before the committee again. Chair, paragraph F, repeated muting of legal representatives. Lastly, we are instructed to place the strongest possible objection to the recent tendency of the chairperson to deny the public protector her rights to full legal representation and fairness by muting the legal representatives from the electronic platform at any stage, but more recently on 23 February. It is unknown what the reason was for such conduct. More importantly, there is no legal basis upon which the chairperson is entitled to conduct himself in such an objectionable manner, which is calculated to exclude the public protector from participation in the inquiry. We are accordingly instructed to demand the reasons for such conduct, as well as being informed of the purported legal basis therefore should be thereof. We also demand an unconditional apology from the chairperson. Failure to do so as demanded may result in the taking of legal action by the public protector without any further notice to you. Chairperson, I won't talk on the issue of apology. That is something for you to determine by yourself if you want after consultation with the committee. But in terms of the rule, a chairperson is meant to preside over meetings. That is the role of a chairperson in any parliamentary committee, and implicit in that, Chair, is that a chairperson must maintain order. The issue of having hybrid meetings where people are on an electronic platform is something new and that our rules don't cater to specifically. But by way of comparison, Chair, Rule 80, which is a rule that's applicable to the speaker, specifically allows the speaker to mute the microphone in their house, because of course the house was using that system. So, Chair, the committee can have a discussion if it so wishes on whether it was appropriate for you to do so or not. But also Rule 183 says that any persons appearing before a committee, including legal counsel, must conform to the procedures and directions of the chair. So I'm not going to get into the question of whether it was fair what you did and whether it was necessary to maintain order and so on. But those would be rules that underpin such conduct. Thank you, Chair.
Thank you, Ms. Ibrahim. So what she's basically done, so that we then get into a full discussion, would have taken all those points from B to F. And so when you then come and make a contribution, you would want to speak to any of those issues and tell us your recommendation and what decision of this committee must be on any of those. Thank you. I see, can I now recognize the hands so that we take our discussion further? I see the hand of Honorable Mailam on the virtual platform.
Can I go ahead, Chair?
Not yet. Mailam. Honorable Dlagude. Honorable Gondwe. Well, I have a thumb up of Honorable Nkosi. You know, there's an organization where if you must be a member, it's either your thumb is up or down. So I've got his thumb up. Honorable Sukas. Oh, I see now Honorable Ngosi's hand up. In that order, colleagues.
Chairperson, let me start with the witnesses, the additional witnesses that they wish to call. Frankly, if they wish to call additional witnesses, that's within their power to do so. And if those witnesses refuse to attend, then they can request that they be subpoenaed. But we have not been requested to subpoena them. And I don't think we should entertain or go down that road until such time as we are asked to subpoena them. So if they want to bring those witnesses, they must ask them and bring them as witnesses of the public protector. With regard to recalling of the other witnesses, Chair, look, I think we dealt with this. We've dealt with this on several occasions, and I think that Ms. Ibrahim has been very clear in her advice that we agreed that we would wait for the outcome of the Western Cape High Court, but that as far as that is concerned, I don't believe we should entertain it at this time. I don't want to address the issue of the witnesses that we chose not to subpoena. I don't want to enter into that discussion at all. I do, however, wish to address the issue of muting. Chairperson, I will tell you that I, for one, felt that it was long past time that you exercised your authority as the chairperson and muted Mr. Mpofu. He has repeatedly interrupted Advocate Bauer, yourself, members of the committee. He seems to have no rules except his own and does not wish to abide by the decisions of the chairperson. And so I think that you are perfectly entitled as the chairperson of a committee of parliament to order that he be muted. You were quite polite in asking him not to interrupt. And then when he continued to interrupt, you then instructed that he be muted. So I think you are perfectly within your rights. Chair, I'm going to leave it there. Thank you very much.
Thank you, Honorable Mailan. Honorable Dlagude.
Thank you very much, Honorable Chairperson. Honorable Chair, we started with the issue of Advocate Madonsela coming before Prof. Madonsela, who will be coming before this committee tomorrow and Thursday. We agreed that we proceed in that way. Then Friday, as proposed to this committee, will deal with the Mr. Mataboke. Then with regard to the calling of further witnesses, we take you from the advice that there need to be reasons for that, because we cannot have witnesses list open-ended. So we are taking you to that advice. As for number D, we dealt with that matter. I think Ms. Abrahams, Ms. Ibrahim's, yeah. It's correct to say that the matter was closed by the committee. So with regards to the muting of legal representatives, I just want to remind all of us, members of the National Assembly, that the rules of virtual and hybrid meetings, be it sittings of parliament or committee meetings, they are the same, they apply. So how members are dealt with in the House, those who are on virtual platform, is the very same way that will be dealt with in the committee. So people indicate when they want to speak and the chairperson will mute them. But when it comes to a point where a member or a person keep on doing one and the same thing and disrupting the proceedings of a meeting, then the rules applies. Those individuals are muted. Also in all other committees, that is how it's done. We have adopted the rules. They are in that order. So, yeah, that's our take, Honorable Chair. Thank you.
Thank you, Honorable Lagude. Honorable Gondwe.
Thank you very much, Chair. I think I've spoken on the issue of Prof. Madonsela, so I'll just talk through the issues, the other issues. Regarding the evidence of Mr. Mataboge, that falls away because we've already just, agreed that Prof. Madonsela must appear before this committee tomorrow and Thursday. Now, the calling of further witnesses, I agree with Honorable Dlagude, we can't have an open-ended list of witnesses. I assume that, it was a closed list. We had closed off the list of witnesses. And remember, if we now call further witnesses, we run the risk of overrunning the program, as Honorable Nkosi has indicated. And Chair, I just don't think it would be prudent of us, given that we don't have time on our side, to allow further witnesses that have been identified by the PP's team to be called. And we have very little information, as Ms. Ibrahim pointed out, on why they need to call these witnesses. So, Chair, let's not even entertain that. And then the reconsideration of non-calling of various witnesses, we've dealt with that matter as well, Chair. Let's stick to our decision and stand by the reasons that we postulated when we took a decision around those three particular witnesses. And then the refusal to call various witnesses. Ms. Ibrahim has indicated that, we consider the matter to be closed as the committee because we considered it. And until, the Western Cape High Court tells us, that we took a wrong decision, we will not move by that decision. So let's stick to it. And then I want to speak to the issue of the repeated muting of the PP's legal reps. As Honorable Dlagude has explained, this committee is by extension, Parliament and constitutes the sitting of Parliament. And we have rules that pertain to hybrid and physical sittings. And as the chairperson of this committee, you have certain powers, and those powers include keeping order in this sitting, ensuring that the decorum of this house and people are heard. Now, you had good reason for muting Advocate Mpofu. Other MPs have been muted during sittings and other meetings, and they've never threatened us with legal action. And Advocate Mpofu is no exception. Once he steps into the premises of Parliament or on the virtual platform, he's bound by our rules, and he's bound by whatever decisions you take as a chairperson. So, Chair, you owe him no apology. You made the right call then. He was interjecting, he was interrupting, and it was upon you to ensure that, the decorum of this sitting, of this inquiry, is maintained as a chairperson of the committee. So, Chair, don't be moved. You did the right thing. Thank you.
Thank you, Honorable Gondwe. Honorable Sukas.
Yes, Chair, with your permission, I'm going to keep my video off, just for the sake of connectivity.
It's okay.
Thank you, Chair. I think I would just echo really what was said before. I think I would start by what Honorable Gondwe has spoken about in terms of the letter referring to you needing to apologize. I want to echo what was said by Honorable Milam. It is time, sir, that Chair, that Advocate Mpofu realize that this is Parliament. It is no one's playpen, Chair, and I think it was prudent to enforce the rules, and I think it was high time, as was said by Honorable Milam. And Chair, I think the impact of continuous interruptions, the behavior by the legal team in some instances, in many instances, does have a material impact on the flow of the hearing. And we cannot ignore that either. And that is why it is so important that the rules of Parliament be adhered to and that it be implemented in this hearing. The whole of South Africa are listening to us. This hearing is holding the public protector to account. It is the body of Parliament operating its constitutional mandate, and it needs to be given its due regard, which is lacking many times. So I would say that. And then secondly, Chair, in terms of the additional witnesses as well as the recall of witnesses, we cannot have an open-ended process that further balloons the cost to the South African taxpayer, that further impedes the committee from fulfilling what is being by a court order put out to us for this to be timeous. We are way beyond the timeline, and we cannot have this program further extended. The people of South Africa needs to hear the public protector of South Africa speaking to this committee and fulfilling her constitutional mandate to the people of South Africa through this parliament. So we need to emphasize that. We cannot make allowances that goes beyond the accommodation, the process of the due process of fairness that has been the guiding principle of this committee. Those are my inputs, Chair. So I fully stand by what was said by the previous members, and are looking forward to hearing from the previous public protector tomorrow, and then for the public protector of South Africa to speak to this House. Thank you, Chair.
Thank you, Honorable Sukas. Now recognize Honorable Nkosi.
Thank you, Chairperson. Let me just start from the repeated muting of legal representatives. I think I agree with all members on how they've expressed the issue. But I think it also bears reminding the legal representative of the public protector that they are not participants in this meeting. They are representatives of the public protector, and therefore speak at the behest of an invitation of the chairperson and the committee itself. And this must extend, Chairperson, when you communicate to them on advocating for calling points of order in this meeting. He's not a member of the committee. He cannot call order. All what he needs to do is to follow your directives. And where he doesn't, and where he violates the decorum of this committee through uncontrollable language and the like, you have the right to call him to order like you do all of us. In all our committees in the legislature, we're called to order, we're muted. At times, we're kicked out of the meeting, both physically and otherwise. So I agree with members in that regard. I would agree, Chair, that on point E, on refusal to recall various witnesses, I think I picked up what the legal advisor was saying, that to date, we have not had an application stating the reasons and the specific questions that must be forwarded to these people who have undertaken to assist the committee, but this time if questions are put down to them and they respond to them. So that must come in the form of that application. Just to say we want them here, we want legal reasons why we are not doing so is not enough. They must provide the questions themselves and the reasons why we must recall them. Otherwise, let's stick to our decision. On detail, I agree fully that we cannot retake it, go back, visit the decision that we have taken ourselves, and we close on that. On C, Chair, on calling of further witnesses, I tend to agree with Honorable Mylan that perhaps what we should do is to ask the PP to demonstrate the relevance of the evidence that would be given by witnesses A, B, and C, and take a decision to allow those witnesses to appear on the basis of a demonstrated relevance of their evidence. Just to say that it was alluded to here, it doesn't suffice, and it's not substantive. Yeah, Chair, I think I've spoken on A. B falls from A. Thanks, Chair.
Thank you, Honorable Ngosi. I think that was the last hand of the members who raised their hand to make a contribution. I'm going to attempt and summarize our discussions, colleagues, from point A to point F, so that you can listen attentively where you think when I'm done there is a gap, we can do that. I think firstly, as a central point, both points A and B, the major thrust of our decision here is that the program that has been scheduled, which is dated for tomorrow and timed from 10 o'clock from tomorrow up until Friday, we are confirming that stands. And this committee makes that point. I think that's the first point that must be made. On the evidence of Professor Madonsela, it would be fair to also make the point that, so that there's clarity, we received the statement of Professor Madonsela on Saturday, that and that would have been the date that my last letter as a chair to her, which was written on the 23rd of February, asking her to deliver that statement on the 25th of February. That was done, and the committee secretary in fact had to during the day to ensure that it is delivered and shared with the PP team and ourselves. It's also important to acknowledge, colleagues, that as Ms. Ibrahim was reading these letters, that there's been a lot of confusion created, and in the main created by the legal team of the public protector, written to her, asking her to make a statement on all sorts, manner of things, when this committee, when it took a decision, was very clear that it is confining her to FREADE and CX. So in my letter of the 23rd, I had to reiterate that, because before that she was then saying, but the statement that I must make, I'm getting mixed signals. I'm getting this from the chair, and the PP team is asking me all sorts of things. So we had to firm it up on the 23rd. And so that if there's any delay, it would have been as a result of that kind of confusion created about the nature and the content of that statement and the scope of that statement. It's only out after it was reclarified by the chair on the letter of the 23rd. Secondly, we must be worried. I didn't hear any member raising this issue. That the timing of the letter from the PP to come to us this morning can be an issue that we don't talk about. And I think it's an issue that in our response we'll have to raise, because if they receive a statement, a 4-page statement, let me make this point. If they receive a 4-page statement on Saturday, it can't be that whatever concerns they have, they only raise it a day before the witness comes to the committee. So the timing of when the letter also arrives is very problematic. I'm not into conspiracies, but I think it can be acceptable. That Saturday, Sunday, Monday, for that matter, they were here with us on Monday. Nothing of that sort was raised. It's raised today after 11. So that's the second point I think we want to make, because I think members are indicating that we knew quite very well in advance that the 1st of March is a date for the former public protector, Professor Motonze. More than 3 weeks that we knew that date. And so in summary, you all are saying we need to proceed tomorrow so that we avoid a program overrun, because we've always regarded as our program as a living document. And members are saying that living document can't be abused simply because it's a living document. And therefore, but more specifically on the issue of the 7-day issue, with the powers invested in the chair in terms of the directives, that 7-day issue has been attended in terms of it being condoned, and I think 10.3 speaks to that. But finally, on this issue, this decision of the committee is therefore saying that the public protector is therefore directed to attend with her team as scheduled tomorrow and Thursday. I think failing which we will continue without her. It's going to be important that Ms. Ibrahim that gets properly communicated. On the issue of Mr. Matabuche, in addition, as we're saying, the program from Wednesday to Friday remains programmed, scheduled, dated, and timed. So we expect Mr. Matabuche, who should have been concluded the other week. And in fact, Mr. Matabuche has again constitute another condonement by the chair, because when they invoked the directives, when they decided not to proceed with the examination or cross-examination of Mr. Matabuche, and the directives allow that, but it then says it can't be beyond 5 days. The chair has condoned that, because if it was last week, it needed to be before Friday. There's already a condonement on that by the chair. So that will, the one on Professor Matonzela won't be the first one. And we can't therefore drag him further than Friday, because he's on condonement in terms of it can't be beyond that 5 days in terms of the directives. And then on the issue of the calling of further witnesses, different views, but I want to summarize it in this way to say, I think members are saying it must be indicated that this is not an open process. We have a set timeline, and that timeline includes, in terms of our program that has been shared, that we expect by the 15th to have the PP coming, and then up until the 31st of March, and you get into a report writing, that we must avoid anything that becomes elastic. But I think more importantly, as our resolutions members are saying, the PP must be asked to demonstrate to this committee on what areas and on what specific issues we're all here, because the further witness are asked on the basis that these were issues that would have been ventilated in the last few days. And because in the absence of that kind of an explanation or demonstrated relevance of evidence, there's another option of written statements or affidavits in relation to that. So it's not just a matter to dismiss out of hand. We're saying we want to be persuaded and convinced about why we need to go to that route, and therefore there must be proper explanation. On point D, final appeal for reconsideration of the committee, as Ms. Ibrahim and members were said, we had long past this point. The last meeting when we closed this point, I want to emphasize this, we said, unless there's new evidence that the PP, beyond us having taken that decision about all of these members, that it's placed in front of this committee, our decision remains. Now, instead of providing new evidence, the PP team says, we must provide reasons. Don't know if you get that, for refusing. So it's being turned the other way around. I don't think it can be allowed. And we've got to stick to that. The refusal of recall of Mrs. Pillay, Van Locherenberg, and Ms. Baloy. These are three witnesses that we concluded on. These are the witnesses that would have taken the longest of time. All three of them. Ms. Baloy didn't just take 1 day and ran away. Mr. Pillay had a particular issue that was explained, but evidence was led, cross-examined, members asked, the matter was concluded as a witness. Again, here, we long said, give us new evidence as to why our previous decision must be changed on this issue. On point F, I think members have spoken about this, and I'll just summarize it. This is a rules-based institution. There are rules that control this National Assembly. In addition to those rules that apply to committees, there's also, this committee has got directives. In fact, the directives also empower the chairperson to do the kind of muting that we did. But the muting is a minimum action that you take. We have not taken the maximum action, which is removing a member out of that meeting. And that has happened, was part of the rules. And so the muting is a first step when somebody disregard the authority of the chair. It's not even the extreme that we have taken. But I wanted to add a point here and hear what members are saying, because I think instead of just directing a response to the PP legal team, the PP legal team represent the PP. It's the PP that we need to communicate with here, because I think the PP at some point needs to explain whether she's condoning this kind of conduct and behavior of her legal team. She must be on record indicating, because it can't be that we just treat the legal team, because that's a legal team of the PP. So whatever he does, he speaks through the PP. So the response has got to be even asking the PP that, because the PP would have been with us and has never been on record. And as a chair, I've not done that before. I might have to do it. That the PP must explain and be on record and indicate whether this is on her behalf. This is what kind of conduct that she so that now that this is written to the committee through the hand of the PP, because it's the people who's writing to us. And I think it's going to be important that we do that. That's the only part I wanted to add in terms of the summary. So that's a summary, colleagues, that I'm trying to make. I'm attending to all of those issues. Do we have any grief about the summary? Are we okay with the summary? Does it reflect our discussions? Honorable Lagode?
Yes, Chairperson. We have summarized it accordingly. Thanks.
Thank you, Honorable Lagode. Honorable Ngosi?
Seconded, Chairperson.
Thank you. Honorable members, that is the conclusion of our discussion on this matter. We therefore going to resume tomorrow at 10. We will try through Ms. Ibrahim to communicate, especially the first decision that is urgent about tomorrow, Thursday, and Friday. So I want to thank you very much. The time now is 19:30. The meeting is adjourned. Thank you.
Thank you, Chair.
Recording stopped.